morning, Ms. Bokako.
Good morning, DCJ.
Are you ready?
I am ready, DCJ. Thank you. Good morning, Commissioners.
How are you today?
Quite different, but I'm well, DCJ. Thank you.
You'll be fine, don't worry.
Thank you.
You hold 3 degrees, an LLB, an LLM in international law, and an MBA.
Indeed, DCJ.
And these were obtained from the University of Zululand. I imagine it would have been the University of the Natal at the time.
I beg your pardon, DCJ?
Where did you obtain the LLB?
University of Zululand, which is different from UKZN.
Oh, I see. Oh, from Ongoy.
Ongoy, yes. Yes, DCJ.
All right. And the LLM you obtained from Amsterdam at the Freie University.
Yes.
And the MBA, I've never been able to pronounce this college's name. What is it called?
You mean the one in Amsterdam or the one for my MBA?
For your MBA?
My MBA, it's Regenesis Business School.
Regenesis?
Yes,
So
which I'm still studying with them.
Okay.
Yes.
I learned something today. You started working at the city of Johannesburg in 1990.
1990, yes.
And you were there until 2000, your CV says. What did you do there?
Well, I started, thank you, DCJ, for the question. I started at the very early age, immediately when I completed my matric. Obviously, given the circumstances that our parents could not actually immediately take us to universities. So I opted to study part-timely. At the time, I think I was studying with Technicon SA, and I was doing municipal law or municipal administration. That's when I joined the city of Johannesburg with an understanding that I just wanted to grow in the area. So I started at a very teething stage where I worked as within an admin office. I was doing records and having to keep file. Particularly, I was in the Department of Environment and with the inspectors and the health department, where I made it a point that it was my task in having to keep their files. Because at that time, we had a number of environmental inspectors that actually will go within the city, having to check whether things are in order. That's where I started. And then from there, I was even responsible in having to issue stationery at that time. And to me, that was really impeccable, DCJ, in the sense that I learned the basics, in terms of administration. Then subsequent to that, because the city is fairly big, then I had to join different sections, data as a data capturer at some stage, working with epidemiologists, and also I worked within the committee section. Committee section then was within the legal department of the city, whereby I was responsible in having to take minutes during the council's meetings or during different sections meetings within the city. And also, I think the last straw where I was in the city, that's when there was an establishment of a center which was fairly unconventional within the local government environment. There was a creation of a human rights information center whereby it was some kind of an excitement, given the newness of the constitution and reformations and transformations that were taking place. So I ended up being in that particular unit, and the role that I played there, I was a junior manager, obviously having to conscientize, having to teach the communities about their basic social rights, and having to teach the councillors, because it was a fairly new phenomenon. I mean, if one looks at the history of the local government by then was said to be an institution that promotes social welfare to the communities. But during that time, I was part and parcel of the transformation in having to change mindset that people, they need to take responsibility in having to pay for their services whilst they are entitled and they're right. But the emphasis that I was doing mainly, it was to teach people and train communities in respect of their rights. Thank you, TCJ.
Thank you. That's a very good start in life. Well, I've always found that people who start working at a young age
Yes,
turn out well later in life. It builds character.
it does.
At the risk of offending the anti-child work lobby. So you decided to become an advocate.
Yes.
Yeah, and you had all this experience by then. You were a fully formed human being.
Basically, I was. And I think, DCJ, I was encouraged with the environment of the human rights sector. I think that's where I developed the passion. And I said to myself, because I'm more passionate about it, I think it's appropriate for me to get skills so that I can be in the position to articulate and in a position to assist where I can. That's when then I decided to go back to the university. And at that time, I was now fairly an adult. As you can see, DCJ, that I've spent about 10 years. I think I went to the university full-time when I was the mother of two, and I was, I think, about 30 years old, which is fairly unconventional, you know, having to start being at the university full-time, but I suppose it was a good decision. It wasn't an easy decision, but it was a decision that I had to take at the time.
Well done. So you were at the bar between 2003 and 2008, and then went to join government. You became a state advocate in 2008, but you were there briefly.
Yes.
And you joined the Public Protector's Office
Yes, DCJ.
as executive manager.
Yes, DCJ.
Right. But you didn't stay there as well.
I didn't stay much.
You became a company secretary for the Joburg Roads Agency
Yes,
for 3 years.
yes,
Then the bar called again
indeed.
in 2013.
Yes, DCJ.
And that's where you are until now.
Indeed.
All right. You have acted, I see, for a number of occasions, but I'm not going to ask you about that experience. I'll leave it to Judge President Lambo to do that.
Yes.
But let me just ask if you have had an opportunity. Well, first, do you have any reserved judgments from those acting stints?
So far, none, DCJ.
None.
Yes.
All right. Have you been able to write judgments?
Yes, I've written quite a number. Quite a number.
How many?
I think about 65, DCJ. 65 judgments.
So you say you've written about 65 judgments
Yes,
in
DCJ.
all.
Right.
Right. I wanted to ask you about something you raised in your application form, where you are asked to disclose if there's anything you think might embarrass you in this venture.
Yes.
And you mentioned that you owe SARS and you are currently working on it. Would you care to expatiate on this statement?
Indeed.
What is that about?
Well, in actual fact, it was my fault. I hadn't filed my returns. I think that was 2019, 2020, and 2020, 21. So that was an issue because of penalties, obviously, but it has since been resolved.
All right.
I've since filed DCJ. Thank you.
Okay. You know, you have such an illustrious CV, and I'm really suitably impressed by all your achievements. But I was a bit disappointed when I went through your application form. For lack of a better description, it appears that it was carelessly completed. It's replete with typos, and just the manner it's been done that does not show that you took the exercise as seriously as you should have. What happened there? I mean, you misspelled obvious words. It's just a short piece of work that doesn't suit someone of your caliber. For example, where you are asked to outline your entire career in the law, giving an indication of your principal areas of legal interest and involvement at page 32.
Page 30.
It's a short paragraph, yes.
Yes.
Doesn't have to be long, but I picked up at least 3 typos there. You misspelled exams, you misspelled preferred, you referred to a commercial case when it should have been cases, you misspelled judgment, and did you complete this form in a rush?
I think I must have. I really apologize. I don't think I really intended to do a shoddy work. And I've just realized that indeed, you're quite correct, Mrs. J, that I've made some typos in that. Severely, I apologize to that.
The other aspect where you were asked to list not more than 10 of your judgments which you regard as being the most significant, you list them, yes. Then one, what you say is significant for is the fact that the accused, I imagine, were found in possession of stolen property. I don't understand what that means. And in another, you say my client was discharged of murder. And,
Which one is
and
that?
that's the tenor. This is at page 35 of the application pack.
Or where it 6.3?
6.3, yes. You say the case is most significant because these parties were found in possession of stolen property, and that's not the question. You are expected to give a substantive reason why this case is important, and that's the general tenor of your explanation for these cases you list. So this is what I'm talking about.
Oh, I see that. You are referring to number 2.
Yeah, in fact, number 2, you say the court found in favor. And I'm not sure why that would make the case significant. In favor,
What?
no unlawful arrest, detention of prosecution. Then the other one, you say very long trial and accused number 7 discharge of all counts. Then the other, they were found in possession of stolen property. Then the one I mentioned, my client was discharged of murder. And this is not, obviously not what this question is, requires from the applicant.
Yes.
You are supposed to, to explain as a lawyer why the case would have been important.
Indeed.
Now that shows that you did not apply your mind at all.
Will I be permitted, perhaps, DCJ, to explain? Thank you.
If you want.
If I may. Well, in respect of the first one, in paragraph 63, the first one, well, this is the matter that I'm currently busy with. It's a fairly significant DCJ in a sense that beside it being a long trial, but given the number of accused that are before court and the number of charges that are leveled against the accused, it's not your day-to-day matters within the criminal courts. It has to do with money laundering, it has to do with poker, it has to do with fraud, quite a number of extensive. So what is significant in this case is the dynamics within the trial itself, because we are different counsels in the matter, and the accused persons in the matter are fairly diverse and very dynamic in their nature, in that it's not just the accused that will sit and wait for the counsel to make submissions, but it's a fairly engaging matter in a sense that, if I'm not mistaken, there's quite a number of applications, interlocutory, if I may just coin it, in this particular process, if which to me it is significant in that obviously I had to think on my feet, and continuously you get to learn a number of things in the process. That is why I've just indicated it, that it's a fairly significant matter. Now, in respect of the second one, I was a counsel in the matter. In actual fact, I was briefed by the state attorney, is the Minister of Police, against Quinike and others. What I found interesting in this matter, they were bringing the claim in that they were unlawfully arrested and unlawfully detained. So the issue was there wasn't a proper investigation in the matter to such an extent that the very same claimant, they were automatically released from custody because, according to the prosecutor at the time, said there wasn't any tangible evidence for such people to actual fact to be kept in custody. But I had to go deeper into the matter, understandingly very well that it was a civil litigation, but with the extensive background in respect of my criminal law experience, I had to dig much better so that I can be able to win the case. So that was very significant. Well, the reason why I'm saying that, there was an element of complexity or contentness from the applicants themselves to say we were not found in possession of the stolen items, but the factors that led to the arrest, I was able to articulate to the court. That is why I was able to get the order in our favor. In respect of the third one is a criminal trial as well, which took very extensive time at DCJ, whereby in actual fact in that matter I was representing accused number one, which subsequently he was the only person that was released. He was acquitted comparatively to 11 accused persons that were found in court. Regardless of the situation and the facts that were before court, there were a number of confessions, number of pointing out of statements, and but I was able to work in the matter. But what was significant is that even at the time, you could see that the state did not have much evidence against my client. To such an extent, they went to a level of having to source the presence of an informer, which is fairly unorthodox in that an informer would actually come to court. But because there was an issue in respect of the evidence leveled against my client, they did that. And it emanated that the very same informer was not very candid with the court. And it was very strange as to why one will actually expose himself in having to come and tell the court as to what he knew. So that was fairly significant to me in that particular aspect. And then the last one, I beg your pardon, I think it's Peter Muklowu. Very interesting matter that has saved millions for the state. It's a matter of Peter Muklowu and others versus the minister. I think they were suing for about, there were 4 claimants. In total, I think they were suing about 8 million, if I'm not mistaken. This case was fairly significant as well at DCJ, in that these were said to be the police officers that were actually arrested. And in the process, they got to be released from custody by the prosecutor with an understanding that there is nothing tangible, without really having to go deeper in having to do the investigations. But then I was able to save the state a lot of money. It's a very interesting case in that the police officer, whilst they were on duty, they were found wanting in having to steal certain items which was necessarily not due to them. So this was fairly impeccable on my side in having to save the cost for the state DCJ. Thank you.
Thank you very much, Advocate. All right, I'll leave it at this point for now. Maybe we'll revisit a little later, depending on how the questioning goes from the rest of the commissioners.
Thank you, DCJ.
I'll hand over to JP Mlambo.
Thank you very much, DCJ. Advocate Bokako, good morning.
Good morning, JP.
You've acted in Gauteng. You've acted for a total of 70 weeks, 70. You've got the spreadsheet in front of you, am I correct?
I do, correct.
And in your acting stints, the only court you've not acted in is the tax court, am I correct?
Yes.
Yeah.
Besides that, I was once confronted during a full bench appeal with a tax matter, though I was not a scribe in that matter.
Yes.
Yes.
You've done work, you've done 2 urgent court weeks, am I correct?
Correct.
and I'll come back to how your experience was, and you've done 3 special motion weeks, as well as 5 opposed motion weeks.
Indeed,
Those are tough work areas, am I correct?
indeed, JP.
Yeah. Where in general is your strength and experience? Is it in criminal law or in the other side of the coin?
It's mainly in criminal,
Mainly
but in the process, I got to gain some strength within civil.
Yeah. But I suppose as a black female from an underprivileged background, it's difficult to crack it in terms of the lucrative work areas, am I correct?
Indeed,
That's what determined where you gained experience in.
indeed.
Right. You've also written a total of 69 judgments according to the list that I've uploaded, I've given the commission.
Yes,
I know you understate it yourself, but it's 69. Now, my interest as JP of the division is to be able to recommend candidates who appear here who, in my view and in the view of this commission,
yes,
will be able to handle the workload of Gauteng.
indeed.
And I mentioned that deliberately. You've acted for a number of terms for the full term,
Yes,
and you have a good idea of what the full load is in Gauteng.
indeed.
It's easy to accumulate 20 judgments, reserve judgments, in one term.
Definitely.
Now, you are here because you regard yourself as ready to become permanent and do that kind of work continuously.
Indeed.
Am I correct?
You're correct.
Yeah. Let me just raise 2 aspects preliminary. One is the issue of reserve judgments is a problem in the judiciary.
Yes.
There are 2 judgments that are mentioned here which took you 7 months and over to finalize. And the GCB says you don't explain why it took you so long. Are you able to tell this commission why you reserved these judgments for so long?
I can.
Please.
Thank you.
Don't go into details.
Yes.
Just explain briefly. Yeah.
Thank you. I think one which I recall, it was a full bench matter where I was sitting with other judges, senior judges. Obviously, I was assigned to be a scriber. So normally there is a process in me having to produce my first draft, having to give to other judges, and bearing in mind that other judges, they still have their work to do, and that could have been the cause in the delay, in particular to that, because it wasn't a judgment that was fairly easily, it was fairly complex. And it needed me to apply my mind, because I don't just say for the sake of having to produce, but quality is very important. So that is why I took my time, but bearing in mind that there is this 3 months, that's the first one. In respect of the second one, DJP, I beg your pardon, JP, I take serious responsibility on that one. I think that one really fell into the cracks. I don't know how I missed it, because I normally have my list of judgment, in particular when I have opposed matters. It's quite a number of them. But this one, it was total oversight. It's not necessary that I reserved it because I did not know what to do with it, but actually it was just an oversight,
Okay.
which I apologize sincerely on that one.
Thank you for that explanation. The other issue that I need to deal with regarding your candidature per se for Gauteng is the criticism that's been leveled against you in the comment from the GCB.
Yes.
Now, I want to state up front that I'm always happy as JP of Gauteng if people who are, candidates who are technically competent,
Yes.
who show themselves in what they've produced, technically competent and hardworking,
Yes.
but above all, conceptually savvy
Yes.
in terms of the law, in terms of the cases they deal with. If they fulfill those 3 competence, I usually am happy that they are suited to do work in Gauteng.
Yes, JP.
Now, the criticism from the GCB raised serious issues and suggests that you don't meet those requirements. You've seen them.
I've seen that.
One probably is the easier one. Not easier, but it's very obvious. It's the one that DCJ pointed out,
Yes.
that in your completion of the questionnaire, it was a shoddy piece of work. But the judgments, the comments say this shoddiness also manifests itself in your judgments. Typos, grammar, but more than that, the GCB points to weak legal reasoning. They point to you citing passages from other sources in certain instances without explaining why you're citing those passages, and in certain instances without acknowledging where you're getting these sources from.
Yes.
This is serious criticism. You are aware of it. I'm giving you the opportunity. That's why we are being interviewed, to explain us if this criticism is valid, and if you don't agree with it, to tell us why you don't agree with it.
Thank you. One, I think I need to indicate that I take criticism very positively and seriously. I've looked at the cases that they've made reference to, in particular the case that was a constitutional court judgment that had actually written. I've seen my weaknesses in it, though there are certain level of strength that I saw in it, and the peripheral, these mistakes of typos, I've taken that into cognizance, and I don't know why it happened because I do concentrate to detail, but I'm taking them very positively because to me, it says you can do better, which I'm prepared to do better. And beside this particular one, when I work with other senior judges, obviously this becomes the process in me having to submit and them having to critique and make correction. And immediately when they correct me and show me certain mistakes, I work in them and there is an improvement. I mean, if one can look at some of my judgment that I did, in actual fact, I acceded to the call because I totally believe, JP, that I'm a product of mentorship and I take counsel very seriously. But in respect of the reasoning of the law, I suppose it's a skill that continuously I am learning and I'm developing in it. That is why even currently I'm still studying. And for me to continue to study in doing my doctoral studies is also to assist me in having to improve in terms of being a good orator, improve in terms of my writing skills, improve in having to have an IQ, in having to analyze and give reasons. It's not an easy thing. I know it's easy for one to come up with an order, but having to deal with the reasoning aspect, I think it's an area that I am quite committed that I can be in the position having to improve on that. But in respect of their comments that I've made, I've taken them into cognizance. And I do appreciate because it makes me to sharpen my skills and to be abreast of what I'm doing.
Yeah.
Yes.
The commission has been interviewing candidates for the week.
Yes.
And in this week in particular, it has established a certain bar
Yes.
that candidates who've appeared here who were technically deficient or not up to the required standard, as well as conceptually weak,
Yes.
were not recommended. That's what this commission has done this week. It's done so, I think, in other sittings, but I'm just bringing it to your attention because you were not here.
Yes.
These comments suggest that that's the case with you, and I'm giving you the opportunity to sell yourself.
Yes.
Yeah, please.
Thank you. Thank you. I appreciate that. What I can simply say to the commission that I've crafted, like the JPA indicated, it's about 69 judgments. Then what the commission is exposed to is the judgments that are here. And what I can simply say that I have grown. Some of the judgment that I've actually crafted, I think they date back to 2019, which I was still teething, in particular on the aspect of civil law, but I have since grown as a person. I mean, now recently I was crafting my heads of argument, and now I've got a different way of thinking and different way of having to interpret principles of law and having to make it succinct and clear to the point, because my previous judgment were fairly lengthy. I do take that into cognizance because I think I seem to dwell much in having to read and understand the facts, and in other instances you may find that the issues of law that are before me, it's something that I've never dealt with as a counsel. So it's very primary for me to understand the facts and understand the issues and make it a point that I tend to be content about it. And also I think the other issue that causes a delay and some mishaps in this, I tend to dwell much in having to research the law. So that on its own, I take comfort to say, at least if I understand the principles, I understand the facts and understand the issues, then I am in the position to produce good judgment. But I can assure the Commission that I am amenable to change, I am amenable to learn, and I know for a fact that there are programs in place that actually takes junior judges for training purposes so that they can actually improve in respect of their writing skills. Like I've indicated, JP, in that currently I am studying, and the area of my study is mainly on research, and on daily basis I'm learning new things as to how to craft, how to concentrate on issues, how to focus on things that are of primary. So with that, to me, is a bonus that is going to be invest positively in what I do in respect of my judgment writing. Thank you, JP.
Thank you for that explanation. One last question. You mentioned that there are programs. I know in Gauteng, whenever acting judges are appointed, when they request to be paired with a mentor, we do that.
Yes.
But we say it's up to you as an acting judge to knock on a permanent senior judge's door that you feel comfortable with,
Yes.
to talk to,
Yes.
to give their judgments.
Yes.
Now, the general report I get from judges is that acting judges don't take kindly to being criticized and being told, this is not correct, this is shoddy, this is how you do stuff. And a number of acting judges who have that problem don't expose their weakness and cry for help to senior judges.
Yes.
And sometimes that manifests itself in these judgments that they write, going into the public domain.
Indeed.
They didn't mention you. I'm
Yes.
just saying that's what I've heard, that acting judges in general tend not to accept
Yes.
criticism. But it's there.
Yes.
Now, these judgments that are being criticized, did you seek senior judge assistance with these judgments?
I remember with one, in particular the constitutional one, because it really, really worried me. It's an area that I was not comfortable with. I'd actually requested 2 judges. So it so happened at the time, that is why it was actually delayed as well, because I'd actually sent to 2 senior judges, so that if they can just have sight and see that it's coherent and see that there's logic and see that any other person when reads the judgment could actually understand what I'm talking about, with an understanding that I'm not only writing a judgment for advocates or lawyers, but it's a public document. So it so happened that those judges, even though they were keen in assisting, they were quite busy. And they were quite busy. So I wasn't in the position really to push them to say, I've got a deadline, because that's my responsibility. But to confirm your word, I'm one person who's not scared, JP, in having to knock in people's doors. I'm one person who's not scared to place myself to be vulnerable on issues. And that's how I learn. I suppose that's how I develop in the process. And moreover, the other area which I did not make use. Now I know that I can actually make use. We do have researchers, and I'm made to understand that they're very good, even though there might be few, but they can be of great assistance in having to take my judgment to them, let them look at it, and let them having to see whether the law that I've actually applied, it's relevant and it's correctly interpreted. And I think in the process, they can be in a situation to correct and edit where I went wrong. So I think I have those avenues in having to make use of them.
Yeah.
Thank you.
DCJ, that's it. I just want to just deal with this last aspect. I can confirm that the research units of Gauteng, no matter how small, if they find something seriously wrong with the judgment, I've told them they should not be scared to point it out to judges. And I know that in general, acting judges don't use the researchers. I don't understand why, but they are there. Thank you very much, DCJ. I don't have any other questions.
Thank you, JP. Good morning, MEC.
Good morning to you, and thanks. Can I?
It's your turn to ask questions if you have any.
Yeah. Good morning, Advocate.
Good morning.
And thank you very much. My question, I've got only one question to you, and it flows from the replies that you have just provided in the two conversations you had with the DCJ and the JP
Yes.
Gauteng. And whilst I think in the responses you have given me comfort that where there are clear weaknesses, challenges, and of course some mistakes, you do take responsibility for those and frankly and acknowledge them and commit to work on them.
Yes.
And secondly, I do appreciate the point you're making about your commitment to further studies to make sure that you improve the quality of your application of the law.
Yes.
And all that. But while that's positive for me, I just need you to take me out of this bit of dilemma that I have, that with all that being said, we still have a responsibility to put into the public space confidence that if you are recommended for appointment, those things will not persist, especially the quality and integrity of decisions and judgments that you'll be responsible for. And these are the two things. So your honesty, frankness about the issues, highly remarkable. But on the other hand, we've got a public out there to say, here is a good candidate, and deposit that level of trust and confidence in the public. And the two things for me create a bit of a dilemma in that I'm happy with one, but I still have got, issues, because when all is said and done,
Yes.
the credibility and integrity of judgments and decisions made, it's what matters.
Yes.
And I can tell you, for the period that I've been MEC in this province, we have been having difficulties with some of the quality of decisions that comes out of courts. So just give me the comfort there that, the public and everybody will sit comfortably that these issues will not persist, because there can't be permanent learning, correcting. At some point, we have got to have the assurance that, we have reached a critical point where we can sit comfortably with whatever, including administrative work, decisions, and all that.
Yes.
If you can just talk to that. Thank you very much. That was my only question.
Thank you. Thank you, MEC. I totally agree with the MEC that at some point in life, you need to reach a point of saying, I'm content with what I do. But having to respect the process in having to build towards that particular goal. But like I indicated, that I'm a product of mentorship, and I'll continuously listen and I'll continuously improve. I mean, if I do my own self-introspection, I see that there's been change thus far Obviously, change is fairly relative, I think, but in respect of me having to assess myself, I think there is a serious change. And I'm very optimistic that should I be given an opportunity, definitely I wouldn't disappoint the community. I wouldn't expose the judiciary to things that are not correct. I'm fairly committed in having to promote the rule of law, obviously through my judgment, through my reasoning, through the logic, and appreciating what is happening in our surroundings. I'm fairly committed to that. Thank you.
Thank you, MEC. AP person?
Thank you, DCJ. Good morning, Advocate Bukapo.
Good morning. Good morning, Commissioner.
You are presiding in a civil trial
Yes.
concerning a delictual claim for patrimonial loss. The only issue which is contested by the defendant is negligence. And what test would you need to apply to determine whether the defendant was negligent as alleged by the plaintiff?
Thank you for the question. I think it's the reasonable men's test and foreseeability.
I beg yours?
I think it's a reasonable men's test.
Yeah.
You're making reference to negligence.
Yes.
Yes.
Could you elaborate?
Well, for an example, let me just make reference to medical negligence, whereby there's an issue with an obs and gynes during birth. It may happen that obviously the claimant will raise that there was some negligence. It may happen that a doctor in question at the time, or the staff that is supposed, the midwife that are supposed to be taking care of this particular woman, they are not effective and responsive in respect of the process. Now, the question one that will pose in the aspect of a reasonable man test is that any reasonable person would have foreseen what was going to happen. For an example, it may happen that the hospital is just overcrowded and there's quite a number of women that are giving birth and there's a shortage of staff. Now, a person maybe that is fairly new had actually attended to the patient. Now, one will ask whether this person, did he or she foresee that if she or he does not engage the services of an expert, being the gynae on an obs at the time, would not have led to this particular situation. I don't know if it answers the question.
Is that your complete answer?
Yes.
Thank you. We'll leave it at that. You are sitting as a member of an appellate court
Yes.
in an appeal against sentence by an accused person.
Yes.
Under what circumstances would interference by the appellate court be warranted
Thank you.
with the sentence imposed by the trial court?
Thank you. Under normal circumstances, the appeal court is not expected to interfere really with the sentence processes. Given the circumstances at the court of call, where the presiding officer was actually exposed to the processes. But then the question as to when can actually the appeal court can actually interfere, there are some instances. Should it happen that the person was actually convicted, either charged with murder and convicted for murder, but then when you look at the circumstances as to how that occurred, it's easy for the court to see whether was that particular action premeditated Or was that situation action of necessity, provocation, or self-defense? And you find that there is a prescribed minimum sentence in respect of premeditated murder, whereby a life imprisonment, that's a prescribed minimum sentence. But if the appellate court is of the view to say the action does not justify the punishment, in that particular instance, the court can actually interfere to that, to say, let's rather look at the facts as to what led to this particular instance. And the other issue, it pertains to the aspect of substantial and compelling reasons. In that, if the appellate court is actually convinced that there are substantial reasons that they could actually deviate from this particular sentencing, the court can actually interfere to that particular situation.
Thank you. I'll leave it at that.
Thank you.
Thank you, DCJ.
Thank you, AP. Deputy Minister?
Thanks. Good morning, Advocate Bukako.
Good morning.
Just a quick issue, and it should have really been a follow-up question, but clarity on the SARS issue, which the DCJ had asked you about. On the form, you'd said, I'm currently owing SARS.
Yes.
And you're working on it. When she questioned you on it now, you said that it related to 2 years of tax returns that hadn't been, or 2 years tax returns that hadn't been submitted,
Yes.
and you've done that.
Yes.
Are you currently owing SARS?
Well, because of the penalties, yes, and I've entered into arrangements.
Okay, so you're not overdue, you're not in default or anything like that with the payments?
No, I'm not.
Okay.
I'm not. Thank you.
Thank you, TM. Commissioner Nyambi?
Thank you, DCJ. Morning, Advocate Bukako.
Good morning.
One question from my side.
Oh, thank you.
After the interaction with JP Mlambo,
Yes.
maybe if you can share with us the challenges facing judges in the division of Gauteng.
Is it like acting judges?
An experienced acting judge.
Yes. One, it will be my personal experience, or rather experiences, in that when you act, obviously it's for a term. In other instances, it might be lesser than that. And you may find that at the time you are busy with other matters, which that's what happened to me in most instances. In that immediately when I'm done with my stint of acting, I have to immediately go to court. And the matter that I was busy with is the matter that called me to be in court on daily basis. So the challenge that I face in having to balance my commitment in having to represent my client and having to produce the judgment, that's the challenge that I had. In that I have this 3-month period that I need to excel and produce quality whilst I'm expected to represent. So those are the challenges that I've experienced. But in any other instance, I think if one could say there are many, it could be out of my own action in having not to utilize the resources that are there. I haven't found anything administratively, Commissioner, that was some kind of an impediment. In actual fact, with the new system of case line, it's something that is fairly impeccable, and it becomes an enabler to say one could be anywhere to work. You don't have to carry a number of files. So those are the positive thus far that I've realized as a person. But in respect of challenges beside the workload, I mean, it's given. Like the JP has indicated that if I'm sitting in an opposed motion, you may find that I come up with a number of judgments, and they come within a week. And when you look at the time frame of all these judgments, I have to produce them within 3 months. So those are the challenges that personally I had, but I've since improved in that particular aspect. But any other thing, I just see the positives, and what is good, which I think is important for me to emphasize, that it's an open door policy of the senior judges. They're fairly welcoming. I mean, anytime they'll say, Tembi, should you need any assistance, please knock at our doors. So that's what I've experienced, Commissioner. Thank you.
Any weakness from your party that you still have to work on?
It's time management. It's time management. I need to be honest with that, in that I really need to master my time. But then in this situation, it was the case that I was busy with. I think it took a lot of my time, but now I've worked on a system and thus far it works. And the other way of improving, Commissioner, is that when you are exposed to the matter as we were trained, is that you deal with the matter immediately. At least come up with a draft within a week, because the issues and the facts are still fresh, and then it will be easy to move forward. So the delaying in having to come up with my draft, that was the weakness. But now I've since created a system in place which is workable.
Thanks, Advocate Bukako. Thank you, DCJ.
Thank you, Commissioner. Commissioner Dudu?
Thank you very much, DCJ. Just one question. I can see that you presided over the case of the infamous advocate Maloisane Tefo, where he was charged for contravening the code of conduct of the LPC.
Indeed, Commissioner.
In your view, how widespread is this problem in the whole ecosystem of the judiciary? And what is it that can be done if it is quite serious to uproot it?
Thank you. Thank you, Commissioner. Indeed, I presided over the matter. I was sitting with a senior judge, which is Judge Nyati. The issue of practitioners finding themselves in this unwarranted situation is fairly prevalent. I think, in my personal point of view, Commissioner, there are a number of dynamics within our profession. If I may just relate to attorneys in particular, because those are the ones who deal with the public purse. There are a number of shortcomings in having to understand as to how it's expected of them having to run the business. And when I looked at that, I looked back at the university where I studied, that when I was prepared to be a lawyer, there was never any course that prepared me to be an entrepreneur, or there was never a course within my curriculum that suggested that I need to have an understanding in respect of business management. Now, when desperate time comes, desperate measures prevails. I suppose with some of the attorneys thinking that they cannot be found, then they go to the kitty in having to take what is not due to them, with an understanding that in future they will take back the money. But the essence is, I think we really have to conscientize ourselves as legal practitioners that we need to have a certain kind of value system. Value system in that we respect the rule of law in particular, and ethics, and we also respect our clients. Because with this case, I think it was bothering in an attorney having some kind of authority or power over the customers. And most of the customers, you'll find that they were at his mercy because a number of them were actually dismissed from the workplace. For an example, I'll make an example of the police officers. They just want to go back to work. They see they've got a legal representative that has an energy and a drive in representing them. Then they entrust him with that. But I think he generally failed them. But the emphasis is people need to continuously be sensitized to say, you are taking responsibility in people's lives and statuses.
Just on a lighter note,
Yes.
the other day I saw the caption of a photo of this advocate with Advocate Ngaitobi, with a caption on the same level. Thank you.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Muiman?
Thank you, DCJ. Good morning, Advocate Bukako.
Good morning, Commissioner.
Yeah, just one question from my side. Section 165 of the Constitution makes reference to the independence of the judiciary. So my question is whether the independence of the judiciary, is it meant to protect the judiciary itself, or is it meant to protect the individual judges? Thank you.
If I understand the question correctly, is it meant to protect the judiciary or the judges themselves?
Yes, you've captured it quite well.
I think it's twofold. Independence in respect in having, for a judge, protect him or herself. You really have to coin what you think is appropriate without any coercion, without any influence. That protects the judge, in that as questions are being posed in respect of my judgment, I need to be in a position to take responsibility and answer in my reasoning. That deals with the personal protection of a judge. Then, in respect of the judiciary itself, it's about integrity that we need to show the communities. And it's not only even for the judiciary, it's for the community itself, that they have trust and believe in us, that we are actually impartial and we are actually transparent and we are independent in what we do, just creating trust to the communities. Thank you.
Thank you, DCJ. Thank you, Advocate Bukako. Thank you, DCJ. Good morning, Advocate.
Good morning, Commissioner.
I have a question for you. And I'm happy that you are specializing in criminal law, because there is something that has really been troubling me in my mind generally. Because I don't know to what extent judges generally read or have regard to Section 280 of the Criminal Procedure Act. No, don't worry, I will help you with it. I'm not good, because I understand this is not a test.
Yes.
It deals with cumulative and concurrent sentences. And I've read your judgments, especially Serake, Mutsweni, and Khobani. I'm not sure if you remember those.
Yes.
I'm not going to burden you with the facts.
Yes.
And the issue of cumulative effect and concurrent sentences comes out quite extensively in those judgments. Now, I just want to understand, given the fact that a crime in South Africa, it is what it is.
Yes.
And you find that people are charged with multiple counts and they get convicted of those crimes. Do you think that judges generally are of the view that ordering concurrent sentences, it's a matter of course? In other words, it's not discretionary. Because it seems like in every other case, sentences are continuously being granted concurrently.
Yes.
And there is a public outcry where somebody has been charged with 7 counts and is convicted, maybe it's like 5 years, 7 years, 8 years, 10 years, 20 years.
Yes.
And effectively the person has been convicted for 20 years, and after 7 or so years comes back. Is this not a challenge? Perhaps maybe Section 280 is not really being taken seriously by the judges, given the extent of crime in South Africa.
Right. Thank you, Commissioner. Well, there's normally a phrase that even if a person is actually charged with 7 lives, a person's got only 1 life. That's the essence of concurrency. I understand the dilemma that you have, and I strongly believe, Commissioner, that even if a person could actually, well, I'm talking in my personal, as a person, since I've been a counsel in respect of criminal matters, that even if a person can actually be sentenced for 70 years, there isn't any guarantee in that there could be a redress that is sufficient to make the communities to take comfort. Even if a person could be in custody or in jail for 15 years, when they come back, the community will still have an issue about it, not understanding that this is a prescribed minimum sentence, for an example, in respect of robbery. Now, the concurrent, it's mainly applicable, for an example, when a person is charged with murder, is charged with robbery, possession of ammunition, and firearm. And you'll find that the smaller sentences, obviously, they get to be taken into the life sentence being 25. So that's the concurrency in respect of having to impose this particular sentencing. But what I think is more fundamental is on the issue of sentencing is an emphasis that one sees in Zin's case, which is a fairly popular case law, in that if one will have to impose a sentence, you need to have a cognizance as to why are you sentencing. One, either to rehabilitate the person, or the other one is to deter the person. And there's quite another elements. So one can ask whether even if you take them for life, are you deterring them? Because they come back in the very similar environment. I think the issue, Commissioner, in answering you, it's not only the sentencing that are being imposed, is the environment where we find ourselves in, because I strongly believe, Commissioner, that in us having to curb the issues of crime and keep away people that are said to be unwanted in our communities, it's not only the court's role in having to play that. There's quite a number of social effects that contribute. If I can just make one example with your permission. There was a case, a matter that dealt, I was a counsel in the matter. It's the matter of a number of accused persons that belong to two different political parties. And it was an area of a squatter camp. So the concentration of the court in respect of mitigation pertaining to sentences, yes, she convicted them, but she had an interest in having to look at the social circumstances beside her having to make a decision in having to take them to custody for life. She was interested to say, in us having to cap this reoccurrence, let's go deeper. To such an extent which it was unorthodox or unconventional for the court to suggest that we need a professional person to come out with a proper report so that it could be a persuasive report to the court in relation to the social circumstances. Because normally when we argue in court in respect of lesser sentences, we mainly look at the personal circumstances of the person. But that court, it wanted to know the social to such an extent that we were actually assigned to go to that particular community to see the circumstances. And if one looks at the circumstances, it created a different mindset if one will have to argue and present the mitigating factors to the court. And to me, that was plausible. That was plausible to say the court can actually be convinced to say, I'm not only have a homogeneous approach in respect of the accused, that it is a known fact when they kill somebody, they need to be taken to custody for life. But the court looked at the deeper factors to say how best the court or the justice system can actually assist in having to curb crime in our communities.
No, well,
Sorry, Prof, just before you carry on, Advocate Bogabu, I'm really enjoying listening to you, but in the interest of time, we still have 8 other candidates to interview and the day is short. Could I just ask you to be a tad, just a little more concise in your answers?
Thank you.
Thank you so much.
perhaps DCJ to assist as well, let me leave it here.
All right. Commissioner Makwanesh?
Thank you very much, DCJ. Good morning, Advocate Bukako.
Good morning, Commissioner.
I have 2 quick questions. One is influenced by what you indicated to us on page 31 of your paginated documents. Are you a member of a political party currently?
No, I'm not currently.
Thank you very much. Then this one is a comment, which I think your response will be helpful. Given what you have admitted or what you have promised to do when both the Judge President and the Deputy Chief Justice were having a conversation with you, that you are working very hard on working on the improvements.
Yes.
What would you say to a person who would say, no, this body would at least need some comfort by seeing that those improvements before recommending you, meaning that between today and the next time you come, we should have seen those improvements before recommending you? What would you say?
Can I just get the question again, Commissioner? I think I lost it somewhere.
Okay. What would you say to a person who would say that you made certain commitments about your own improvement?
Yes.
That this body, before recommending you, they
Yes.
would want to see that indeed you have improved from the last time you came, which is today.
Yes. Well,
So in that case, then the view would be, let's say, if you come the next time and would want to see those improvements, what would you say to that?
definitely you'll see the improvements. You'll see the improvements, Commissioner. There are actually improvements, judging from what I've written at the later stage.
Thank you very much.
Thank you.
Just a follow-up, quick follow-up, DCJ.
Sorry? Yeah,
Follow-up.
carry on.
No, the question is, what if we say we shouldn't appoint you now with the hope that when you come next time, there will be some improvement from all the criticisms observed here? Do you think will be unfair?
That's a difficult question, Commissioner Malema. I'm fairly optimistic that the Commission will be amenable and in giving me the opportunity, to say, I'm a candidate of improvement. I've shown with my judgment that I can do better. So in having to say to the Commission, no, I'll come back the second time, I think I'll sound like a pessimist. I just want to remain optimistic to say I'm doing good and I'm doing better. And the continuous exposure, I'm currently acting as a judge, it's an exposure. It's giving me an opportunity to say, Tembi, do better. So I'll appreciate if the Commission could actually decide contrary, Commissioner. Thank you.
Shouldn't we give you more extension through the JP of acting? Thank you, DCG.
I'm available to serve. I'm available to serve, Commissioner.
Commissioner Kane?
Good morning.
Good morning, Commissioner.
You would have, I presume, read the report from the GCB pertaining to an overview of your judgments thus far.
Yes.
Have you done that?
Yes.
And you would have seen that they criticize you for not actually applying the correct legal tests established by precedent.
Yes.
And this is an opportunity then just to explain, if you've had a good look at that, how you would deal with it now. One of the examples they give of that failure, for instance, is not applying the requirements for an interim interdict when a bank actually sought the return of a motor vehicle. You've seen that criticism?
The Mulimi, I think it's Mulimi.
It's paragraph 6.5, ABSA versus Mokatimi.
Yes.
Now, could you explain to the Commission what the difference would have been if a final interdict had been sought in this case? What test would you have then applied?
Right. Obviously in interdicts, there are two, the interim And the final one, with an interim, obviously the court will have to look at the prima facie case, will have to look at the injury, apprehension, or irreparable harm, and then the test then in respect of the final interdict will have to look at the clear right and irreparable harm, and also will have to look as to whether is there any alternative remedy to the situation. So I suppose in the matter that I dealt with, it pertained to an interim interdict whereby the applicant actually needed the respondent to
Yes, all right. I'm going to stop you because you've dealt with my question and we're pressed for time.
Thank you.
But I just want to now take you on to other kinds of interdicts that are ordinarily dealt with by high courts.
Yes.
For example, a mandament van spolie. What sort of test would you be looking at there?
I think it's possession,
And what's the test?
whether the person was in a peaceful possession.
And would the right to ownership be relevant in those circumstances?
No, it's not relevant.
And then an Anton Pillar order is another example. What would
Yes.
be the purpose of such an interdict?
Anton Pila, I think, Anthony Pila, I think it has to do with recovery of documents.
Let me assist you. You are correct, the preservation of evidence.
Yes.
Now there, would you be exercising a discretion?
You do exercise a jurisdiction, particularly when the applicant can actually convince you, the presiding officer, to say particular evidence or information is at the disposal of this particular person, and there are probabilities that this person can actually dispose of the
All right,
document.
you said that you would exercise a jurisdiction. Did you mean a discretion?
A discretion, I beg your pardon.
All right, and what really is the test there? How are you going to apply that discretion?
The imminent irreparable harm in having not to secure particular evidence,
As against?
as against having to notify the person, because normally in those particular processes, there isn't any requirement or obligatory having to inform the respondent, because as soon as you do that, they get to be aware and it's easy for them to dispose with that particular information.
Let's take another example, an application for an eviction. Are you exercising a discretion there, and how are you going to be guided?
Eviction, knowingly, is guided by PI Act. It has some requirements. Well, one, it's led by the prescription of the legislation, and in other instances, obviously, it's the facts that are presented before you. Discretion can come into the picture whereby there are elderly people within that particular household, there are young people, so that it has to be discretionary in having to take that into cognizance.
Thank you, DCJ.
Commissioner Baloi?
Thank you, DCJ. Good morning, Ms. Bukako.
Good morning, Commissioner.
Ms. Bukako, I've looked at the judgment of the deformalisela defo that you discussed earlier with Commissioner Dodovu.
Yes.
And the reason I've looked at it is because it's a very recent judgment.
Yes.
It's in September 2022. When did you start your first stint at acting?
2018.
And you say you've written how many judgments?
About 69.
About 69.
Yes.
And this is one of the 69 in
Yes.
September 2020. Now, the judgment is replete with errors. Errors of reasoning, structure, typos, and it's very difficult I don't know where to start. So I'm just going to pick randomly an example that I want to make. But before I do that, let me ask you this. In that judgment, at paragraph 133 of the judgment.
If I might just go there.
Yes, please.
Commissioner. You
One,
said
133, are you there?
133.
Yes. You say in that paragraph, you start off by saying it is trite that in this is a striking off. You say it is trite that in application of this nature, there is no less between the applicant and the respondent, right?
I beg your pardon, Commissioner, I think I'm in the wrong page. 133, according to my bundle, is
Paragraph. The Malisela judgment at page 100, handwritten page 100 at the bottom of your bundle, and then the stamped case line 01847-47.
I found it.
Okay.
Yes.
So you say it is trite that in application of this nature, there is no less between the applicant and the respondent. The applicant is by virtue of its statutory duties, furnishes the court with the relevant facts and findings. Now, my understanding of what you are saying there, and please correct me if I'm wrong, my understanding is the duty of the LPC as a regulatory body in these kind of situations is not to prove a case, it's just to come and assist the court, to be of assistance to the court. Am I correct?
Correct.
Okay. And then go to paragraph 143. And there you say, in the second line, you say the second sentence, you say, this court is satisfied that the applicant has proven its case on balance of probabilities that the respondent is not a fit and proper person, right? You say that. Now, that's the opposite of what you said earlier. You're saying here the LPC had to prove a case and it has done so. So the reasoning is completely wrong, and there's lots of it in this judgment. And the reason I raise this is you've been acting, your first acting stint is 2018. This is a judgment in 2022. It doesn't seem to show development and growth. And I've just picked an example, but this whole judgment suggests there hasn't been any meaningful growth over time from experience of writing judgments and reasoning. How do you explain this? Because it's a bad judgment. How do you explain it?
Well, Commissioner, without me being defense, I think I take your cue and take your counsel. I did realize that in actual fact, I could have done better in my reasoning in this particular aspect. I see that it's fairly minimal. So I've taken that into cognizance.
Okay.
Basically, that's what I just want to say.
All right. So that's my one concern. It doesn't seem that you know, over time you have grown to a point where today we should be confident to recommend you. That's the one. The second related issue for me is when you were answering, I think it was one of the commissioners on the other side, I don't remember which commissioner it was, you were discussing about reasoning being a skill that will develop with experience over time, and you're bettering yourself, you're studying. Now, my difficulty or the problem that creates for me is, as a judge, and that holds true as an acting judge too, is you make decisions that affect people.
Yes.
You make decisions that affect people. And I think it is unfair on the public, would be unfair on the public for us to say that, she should be appointed as a judge. She will grow in her reasoning capacity to the extent that's a thing. She will grow in her reasoning capacity, but in the meantime, the public has to put up with this deficiency of reasoning in the judgments that she makes. That makes me terribly uncomfortable. I don't think that I could recommend that of any candidate, that they should be appointed and they will grow over time, and in the meantime, the public must suffer the consequence of this deficiency, because it is very important. What do you say to that?
I hear what the Commissioner says, and it is not intended in me having to embarrass the judiciary and expose our courts in respect of this. But I can safely say, Commissioner, that I have improved. I understand you have raised the time factor, but if I compare this comparatively to what I had actually written, because all the time when I write judgment, I don't write with an intention of saying this is going to be less of a quality or better of a quality. I give it my all in doing it. I suppose by me being exposed to these circumstances is going to enable me to be a better analytical person or a person that reasons. So I can't take it any further, Commissioner. Thank you.
All right, thank you, Ms. Bukako.
May
Thank you,
I follow?
DCJ.
Thank you, DCJ. May I follow up? And it will be my question as well. Thank you. Good morning, Ms. Bukako.
Good morning, Commissioner.
Ms. Bukako, I'd like to follow up on what was put to you by Commissioner Baloy and by Commissioner Malema. You've described yourself as a candidate of improvement.
Yes.
And I think what you're asking us to do is to give you a chance to carry on brushing up your skills while you're sitting as an acting judge. Commissioner Baloy highlighted the risks associated with that. And I just want to bring that down a bit and demonstrate to you how enormous the risks really are. And I want to do it with reference to your solidarity judgment.
Yes.
Now, you'll remember the solidarity matter comes to you when you're sitting in unopposed motion court.
Indeed.
And it's a huge application because it's a constitutional challenge to 4 sections of the National Health Act.
Yes.
But what was a crucial feature is that these 4 sections hadn't yet come into effect.
Indeed.
Because the proclamation which purported to do that had been set aside by another court as being unconstitutional.
Right.
Now, when one goes through your judgment, and I say this with great respect, because I accept that you've already said to us that you've got limited constitutional experience.
Yes.
But if one goes through your judgment, it's almost incomprehensible in terms of your reasoning, in terms of you dealing with the technical issues that were very prevalent in that matter simply because of the nature of the matter.
Yes.
For example, when you're dealing with the question of jurisdiction, you do the right thing, you refer to section 1722A of the Constitution, but that should have been the beginning and end of the discussion.
Yes.
You then go on and you ask whether or not the fact that the matter is not opposed,
Yes.
Whether you still have jurisdiction to determine the matter.
Yes.
So that's just a minor example, and the entire judgment is littered with errors. From the very beginning, when you talk about the applicant raising preliminary points, right to the end in terms of the order that you craft.
Yes.
So I raise this, Ms. Bukako, firstly with great respect, because I think what we do want to see is candidates of your nature being developed within the judiciary and eventually taking this position because they should. But it is of enormous concern that when you are discharging your judicial function,
Yes.
you're doing it in a way that has consequences.
Indeed.
And I think the solidarity matter is one such matter where the consequences are clear. So I want to come back to what Commissioner Malema put to you earlier.
Yes.
Do you not believe that given these real conceptual difficulties with your judgments, that you will benefit from acting a bit longer before you're ready to be considered seriously for judicial appointment?
Thank you. I do appreciate that. I'm not just going to be hard in not having to listen to counsel. I'm open, I'm available, I can continue to act, and that is going to assist. But in respect of this matter, I've gone through it. It was the first constitutional matter, Commissioner. It was difficult. My nerves were just all over the show. So, but I had to give it my best because I had a responsibility in having to dispose with the matter and come up with an order. looking at it, I see the shortcomings, but I do appreciate the fact that I've learned one or two things, and having to hear from commissioners in respect of their comments, I'm taking them to cognizance. Thank you.
Thank you, DCJ.
Thank you, Deputy Chief Justice. Good morning, Advocate Bukako.
Good morning, Commissioner.
I must commend yourself. You've done well academically. You've really improved, and I'm really proud of you. But what I wanted to find out from you is, you know the briefing patterns that we really cry about. And I see that you have worked with the municipalities, you have worked with Johannesburg Rules Agency. Do they give you work in practice?
No.
At least the MEC is here, at least tell him that they must give you work in practice, so that at least you upskill yourself to all the issues that the commissioners are raising.
Yeah, no, I don't normally get, briefly, Commissioner, with that challenge, I think that's what actually led me to study. Because I realized that if one talks about transformation and having to be ready in receiving matters, I looked at it differently in that I seem not to have expectation of being transformed, but I think I have a duty, a personal duty, to transform myself. And that is why I decided really to continue with my studies so that I should be ready. I mean, even now, I'm dealing with my doctoral studies that talks to a land question which is fairly fundamental and topical. I'm just getting myself ready because it's something that is of moot, and there will be a need in our society in judges having to engage on the question of land. So that on its own, it becomes an enabler to me. But the issue of briefing pattern, it has been a challenge, and I think it's still a challenge. But it takes one also to make yourself relevant.
Okay, thank you. And the second, maybe advice, there are these courses on judgment writing. Do you normally see them?
Yes.
Yeah, or keep on attending them. I think it will work.
I'll do that.
Thanks.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Noches?
DCJ, unfortunately, the questions by Commissioner Paloi defeated the very question I was to ask. So I withdraw. I'm not asking question.
Commissioner speak.
Thank you very much. Thank you very much, Deputy Chief Justice. Good morning, Ms.
Good morning, Commissioner.
Now, there is a matter which was raised by the professor there, and I'm interested in it.
Yes.
Professor was talking to sentences.
Yes.
And in a country where now everybody is up in arms about the high rate of crime, there was talk of concurrency of sentences. Don't know whether you call it concurrency or sentences running concurrently, but I know, and I've watched several cases where a person who's committed some of the most gruesome crimes, the person will be given 2 life sentences or 3 life sentences, but we know actually that 25 years down the line now, in the past it would have been 20, 25 years down the line the person will come out.
Yes.
I hear you say when the person eventually comes out, it doesn't matter if the person has served minimum sentence or not. You will still have the kind of reception which you would have had from the side of the public, which you would have had even if you were given a longer sentence than the life sentence. Because in South Africa, the life sentence is not life at all.
Yes.
And this is what people are complaining about. Now you say you have to deliver your judgment, you have to give a sentence, irrespective of how people may feel about it. That should not inform your decision.
Yes.
My question is, what then becomes the role of the judiciary in educating our people, in educating the ordinary woman and man, in educating even the victims of crime about what to expect and why they should expect that? Because I don't see you, I didn't hear you, your consent did not, maybe it's because that's how you should be as judges when you preside, but when we engage in this kind of forum, I would have wanted you to say, however, in spite of this kind of reception from ordinary citizens of the country, there is a need perhaps from the side of judges to do the following to educate our people.
Yes.
I didn't hear that. I just heard somebody who was saying, look, I do my work, I look at the legislation, I do things by the book, I give a minimum sentence, and how that minimum sentence is interpreted by your ordinary person and its impact on the victim is another matter.
I hear you, Commissioner.
Can you help me there?
In that particular aspect, yes. Commissioner, I think it borders to a principle in us having to uphold the rule of law, in that as much as we are individuals and the members of our communities, we still have a duty to promote the constitutional aspirations and the law that we're dealing with. And that's what confines us as judges. Without shying away that we are exposed to these ills within our communities, it will be inconsistent of us as judges to make determinations or craft judgments based on people's perceptions or community perceptions. Because if we stick to that, that is contrary to judicial independence. So it means continuously, if we'll have to do our job, we need to succumb to pressure, which I don't think is acceptable. But it doesn't really mean that we are immune as to what is happening around us. In writing our judgment on its own, a judgment, it's an educational tool on its own. It's a document that it's important. That is why the commissioners are posing the question of reasoning, to say for you to reach a conclusion in having to give only 1 life instead of 2, or only having to give 25 instead of 70 years. What led to that? So that reasoning aspect, the process that leads to that, it's educational. And the other aspect, Commissioner, is the access to courts, whereby we see our courts on a daily basis in our screen. That is educational on its own, because it makes a very knowledgeable society. They're exposed to what is happening. Yes, people will always have their views, their perceptions and opinions, but we really need to guard against emotions, because these emotions are fairly temporarily. It might happen for now. Circumstances in other cases could be different. So judiciary, there are a lot of publications that are there. There are a lot of bodies whereby judges, they actually attend these seminars. They get to talk. And we have seen with the Chief Justice in the past, which it was a little bit unconventional, the former, whereby he will talk about these things. People will get to understand what is the Constitution all about. That is educational on that. So our education, our judgment is educational. Thank you, Commissioner.
Judge?
Are you done? Okay.
TCJ.
Are there any questions from the commissioners on the virtual
TCJ.
platform? Oh, I'm so sorry.
DCJ, I'm a lay person, but I hate to say the manner in which you deal with this particular issue may sound extremely insensitive. The question I'm raising is, in view of what is currently going on, I'm not talking about pressure being applied on the judiciary. We respect the independence of the judiciary
Yes.
and the rule of law. Have we reached a point in our society where society needs to be educated and taken along to have an appreciation of why certain decisions are taken by the courts, such as just that which you've illustrated? For instance, you'll talk about 2 life terms, 3 life terms, and then you say as a judge, of course we know there's 1 life.
Yes.
You get my point?
I understand.
To a victim, you may as well appear to be extremely sensitive. To somebody who's lost a loved one, who will say to you, what is this 2 life terms, 3 life terms? And then you say, as a judge, after all, you only live once. There's
Yes.
only 1 life. So I'm just talking about, don't you see the need, in view of this uproar around sentences which are imposed on people who have committed gruesome crimes? Don't you see the need, not so much to change your penalty structure, but more about informing and educating South Africans, and perhaps that should come from the side of the judiciary itself, so that South Africans are not judgmental, so that South Africans are not impacted negatively by decisions of the courts.
I hear you now, Commissioner. Thank you. Apologies, I didn't mean to be insensitive, perhaps the manner I came across. I'm a very conscious person, Commissioner, when it comes particularly the plight of the accused persons and the plight of the victims. In that I don't only litigate on the basis that I win cases, but it's a consciousness that I have in me. When it comes to the judiciary having to be out there, having to teach the communities, I think it's primary. I think it's fundamental. But we really need to guard against a situation whereby we find ourselves entering into the space where we shouldn't. Perhaps suggestion could be we need to come up with civil social movements that will be out there specifically in having to promote the rule of law, specifically in having to talk about the culture of human rights. Because basically, if the society is not conscious on aspect of respecting one person, that is why we're in this situation. It's not only the judiciary that will have to keep this, but the society in all and in general has a duty to teach the communities. Our small social structures in our communities, they don't have to be formal structures. We have duties to teach our communities. I think if we can just look at one of my writings as to which body do I belong to, I belong to a structure within my community with women from Soweto. Those are elderly women which are exposed to crime on a daily basis. And the young children, mostly they're in jail. And they're sitting with little ones that do not have parents. So we look at the issues that if the person comes back, does the person has a second chance within the community? And we don't only look at the individual when she's back or he's back, the ex-convicts. We also look at the victims. I mean, you know for a fact that the correctional services had this victim dialogue session. We get to be involved in those processes to say, if you ought to be accepted, you need to take responsibility of the actions. And if I believe that if one person changes in the family, the whole community gets to change. So it's not only the judicial that has a responsibility, but cohesively, everybody has a role to play in capping crime and the ills within our communities. Thank you, Commissioner.
Commissioner Barnett?
Thank you, DCJ. Advocate Bukaku, you speak about the rule of law, but I think that, part of the rule of law is knowing what the law is. So certainty, legal certainty we speak about. So sometimes you have conflicting judgments and you would go to a higher court to say, please, SCA or Constitutional Court, give us a direction in this matter. We have different judges with different things. The problem with your judgment is one of the points has been highlighted is there's an uncertainty within the judgment itself. So, for example, in the Mokotimi, Absa versus Mokotimi matter that was already referred to, where in the one paragraph you seem to say that cancellation of the agreement is important and the communication thereof to be able to get an interim interdict, but then 1, 2, 3, 4, 5 paragraphs later, you turn it around and you say cancellation of the agreement isn't important. And so the problem, for example, the GCB raises is one doesn't know, just looking within one judge, it's not even a conflicting two judgments, it's one judgment that says yes and no. It sounds a lot like the Afrikaans expression ja nee. You know, we don't know what to do with that, yes, no. So I think that's a problem, is the legal certainty. Please address the Commission on your attitude towards rule of law and legal certainty. Thank you.
I think in respect of legal certainty, it's when one really having to interpret the particular prescript in different contexts, be either having to contextualize it or by virtue of you having to interpret that particular prescript literally. That's about that. And then in respect of the rule of law, yes, I agree with you that having to express my views, it has to be clear, it has to be concise, and it ought to be practical. That's my answer.
Thank you, Advocate. Thank you, DCJ.
Thank you, Commissioner.
Thank you, Commissioner Bernard.
Sorry, DCJ, I just wanted to confirm just one small detail, that the Tefo judgment was concurred in by a senior judge.
Indeed.
Thank you, DCJ.
Thank you, Commissioner.
Thank you, Commissioners. Advocate Bukako, we've reached the end of your interview.
Sorry, DCJ.
Is there another question?
Sorry, I had my hand up for some time. I thought you'll recognize me. A very quick
Commissioner
one.
Singh, I'm sorry.
Thank
I
you,
was
ma'am.
not
Thank you.
alerted to your hand. Sorry about that.
Thank you.
I didn't
Thank you,
even
ma'am.
know you were
Good
with us
morning,
today.
No, I am. Just yesterday I had a medical appointment. Good morning, Advocate. I'm on the virtual platform.
Thank you, Commissioner.
A little more clarity on the SARS matter, because, it's something that's worrying me. You completed your form on the 22nd of November last year, and you say that you are dealing with this matter, but this is an outstanding matter for the 2021 financial year, which would have ended in March.
Yes.
Can you tell us what is the quantum of how much you owe SARS? And when you say you are dealing with it, what do you mean? What are you saying to us, the Commission? Thank you.
If I may just recall, there have been different quantums because it started at about 91, but my consultant have actually filed a number of objections, and in respect of me having to file my returns, obviously it decreased the amount. So currently, I think I might be sitting at about 40,000, Commissioner. Obviously, this is information based on my consultants having to give me feedback. So we're just currently working on that. That is why I'm saying I've actually entered into arrangement having to pay that particular debt.
No, thank you very much. Now, the reason I asked that, if the Commission has to appoint any person to the bench
Yes.
that's owing SARS, which is an institution that we really hold in high esteem, then it'll make it difficult for us as a Commission. No, thank you very much. Thank you, DCJ.
Thank you, Commissioner Singh, and apologies once more for overlooking you.
No problem.
Any other question, colleagues? Are we done with this candidate? Thank you. Advocate Bukako, sorry. We have finished with your interview. Thank you very much for making the time to come and speak to us. You will know in due course what the result is, as you know. All the best.
Thank you, DCJ. I appreciate the invite. Thank you, Commissioners.
You're excused.
Thank you.
Good morning, Advocate. I'm sorry, how do you pronounce your name?
It's Holland Muter.
Holland Buter.
Thank you, Deputy Chief Justice.
Thank you. Good morning, sir. How are you today?
Nervous, but okay.
But you're an old hand at this. How many times are you coming before us now?
No, but it doesn't take the nerves away.
Yeah, well, I hope this will make your life a little bit easier. This body has tested your suitability as a judge, I don't know how many times now. So I think we have enough information on record to establish that you are a sound lawyer and a fairly decent human being, if I may say so. So I'm not going to ask you any questions. We know exactly who you are. The record speaks for itself. I'm just going to ask if, well, your last interview was it was as recent as October 2022.
That's correct.
It was barely 6 months ago. So all I'm going to ask is whether there is anything earth-shattering that has happened, to enhance your CV that you'd want to bring to our attention. And if there isn't, I'll hand over directly to JP Mlambo.
Thank you, Deputy Chief Justice. The only thing which changed since I filed my application is that in the first term of this year, at a very short notice, the Deputy Judge President phoned me and asked me for assistance. And then in the 10 weeks, on loose standing weeks, I assisted the Pretoria High Court for 5 weeks, ending in the last week of term in the urgent court. So the statistics have changed because there are 5 further weeks, and unfortunately, because it was in the last 2 weeks of term, end of the term and so on, I've got 2 outstanding reserve judgments which I picked up then 2 to 3 weeks ago.
Those are very fresh. Is that all?
That is all, that is all. I have obtained more grey hair, but that's natural.
So have we all.
Yes.
You're in good company. Thank you very much, Counsel. All right, JP Mlambo, I'm handing the candidate over to you, sir.
Thank you very much, DCJ. Good morning, Advocate Holland Muter.
Good morning, JP.
I think the DCJ is correct. You've been here, this is your 4th time. Am I
Fourth
correct?
time, yes.
Yeah. And in this room, only the Deputy Minister and the Speaker have not featured did not feature in your last interview. Now, so the DCJ is correct.
Yes.
You've been here, we know you. But this is what I want to ask you. You've acted for a total of 100 weeks now.
That's correct.
And that's because of the example you've just given, that at any time when we run into a problem, a judge falls ill, we need assistance, we know we can call you and you can come.
When available, yes. Because it's a duty which I have to my country and to your division.
Yeah. And I want to thank you for that.
It's my pleasure.
My role as JP of the division is to ensure that people who are hardworking, technically competent, and conceptually up to standard are appointed in the division. Now, I've looked at your acting stints. You've acted for a total of 14 weeks, if I'm not mistaken, in the opposed motion court.
That's correct.
That's a court where it's a warehouse for reserve judgments.
For sure.
And you've also acted in the special motion court. That is the 3rd court, right?
Yes.
As well as in the agent court quite a number of times.
Yes.
In fact, the agent court also warehouses a number of reserve judgments if you don't hit the ground running and you're not confident to do extempore judgments.
Yes.
Now, looking at the terrain, the comments that have come, have you been criticized in any way about your judgments? How you've reasoned them, whether they are shoddy pieces of work like they are replete with grammatical errors, typos, linguistic issues, weak reasoning?
Well, JP, the comments which I received from the various bodies, all of them stated that I'm a fit and proper person, that my knowledge of the law is good, my writing skills are good, and so on. So, no, in the recommendations or the documents which was forwarded to me, there are no serious criticism on the quality of my work.
Yes.
The Commission, everybody has it with them. No. I may also say is that from time to time you hear from Council that they are very satisfied with your judgments. I even had instances because many of the judgments which are not reported, but they hear about it and they phone your registrar or come to you for a copy of that to use in their arguments and so on. So it's not that I want to be profess that I'm very good, but no, there's no serious criticism which I'm aware of.
Yeah. Your list of judgments, I think you list 69 judgments, is that correct?
That's correct.
Okay, but for having acted for so long, that's a bit of a low number, if one may say so.
To a certain extent, yes. The more experience you gain, especially in the courts, the default judgment court, etc., you become confident to give extempore judgments.
Yes.
And with the rider that if the parties would like further reasons, they're welcome to request that. Especially in the urgent court, because the whole purpose of the urgent court is the people want urgent relief. Then it happens from time to time, especially towards the latter time while I was acting the latter years, is that you give a very short extempore judgment and then you elaborate on that, and that is where some of the reserved judgments come from.
Okay. Thank you. My last question, DCJ, is having looked at the last interview where you face questions from this body, and you may go to other interviews, what were the points where you were criticized, and if there are any, can you tell this commission if you have improved on those criticism points?
The one criticism, JP, is that I can't remember who it was. The commissioner said that he sees no growth because we're talking about weak and strong points. And under the strong points, I mentioned that I'm very dedicated. And on the question, the answer, because it was on one of your questions, referring to the opposed motion court and the urgent court about the volume of work. My answer was that it from time to time means you work after hours, after midnight. And then the question was posed to me, but you work hard doesn't mean you work smart. I have, having read the typed version, did some, in retrospect, questioned myself whether hard work after hours so late is necessary and how can I improve on that. And I've come to the conclusion that the volume of work does not decrease. And I will, in future, whether acting or appointed, when you are faced with matters, especially the opposed motion court, the week before that, because you don't have, like in the unopposed court, a reading week in advance. You get it the Monday or the Tuesday for the Monday coming, your opposed motions, but for instance, you may still be in the unopposed court or in the trial court. You have to prepare after hours. There's no question about that. And my motto is, and that is many of the reports I received back from council, is that my preparedness when going to court, especially in the opposed court, is that I know the papers well. And that takes me, in instances, after hours, after midnight, and even on weekends. But yes, I have had a look at that to see whether I can improve on my system. But with regard to that, to a large extent, it's dependent on the volume of work which you have to go through. Because in the opposed court, having 12 to 16 opposed motions for the week, it boils down to more or less 1,500 to 2,000 pages which you have to prepare. And that's a lot of reading to do while you're still in the week before that, busy with other work. So you have to do that. A question was asked about my weaknesses, and I said it may be seen as a weakness, is that I have a very soft spot for children and females or abused people. A weakness in abbreviations because I know that those people are the people who are most vulnerable, and they are the people who need protection. So if I can state it, overprotective towards them, I don't feel that I'm failing my duty towards those persons, because those are the people who normally don't have the opportunity to speak for themselves, and they need to be protected. That was that. Then there was the aspect on which I was criticized as being a senior counsel, and the comparison was drawn between Johannesburg and Pretoria, that I had less juniors which I led should have been in Johannesburg. But that is also dependent on where you are, the kind of work you do. And you have to remember, the fact that I'm in practice for 23 years does not mean from year one you have a junior with you. Your first 12, 13 years as a junior counsel, you build a practice, and then after that you start, before you obtain silk, is take in juniors and advise them. I have explained that I've a category where I take juniors in on full brief. I take in them on my account with the consent of my attorney, but I pay them out of my fee. And then there are those, because for a long time I was the convener of the pro bono committee at the Pretoria Society of Advocates. And by doing so, to give juniors and pupils who have the right of appearance the opportunity to come into court, I've roped them in. I take them, and I take them to court, and I give them the opportunity to first experience the court. And at a later stage, you take those people in, those young counsel, when there's a pro bono brief or so, and you ask them to prepare it, but you go there to keep their hand. In my view, that is to give them the opportunity to be exposed, and that is to help them to become better counsel.
Yeah. In terms of your work, your performance as an acting judge, is there any criticism? Because if there's none, then I don't think you need to be...
No. In my view, no. I'm not aware of criticism against the quality and the work which I've delivered.
And your judgments?
And my judgments, no.
If none, that's fine. If none, thank you.
Thank you.
Thank you, DCJ.
Thanks, JP. Do you have questions, MEC?
Yes, just one. Good morning. I see I'm right here.
Oh, yeah, good morning. I saw the hand there.
Okay.
Yes, MEC.
Yeah, I just have got one question to you. And I just wish to get your insights on perhaps a comment, if it were to be made, that your appointment may not enhance transformation. In other words, it will not be considered a transformative appointment. Well, what will be your take on that, on gender, on Africans, black people, and youth, given your age?
MEC, the Constitution in Section 172 amounts to that. To be appointed as a judge in the High Court, you have to be a fit and proper person. I know and then it's further, there are the restrictions of other legislation. I accept and I agree that there must be transformation of the judiciary. To a large extent, that has taken place. According to the statistics in the report from the GCB, at present there are 75 judges in the Gauteng division, of whom only 15 are white males, which amounts to about 18.5%. So I hear what you say about that. Would my appointment send out a message to the public in general? If it's only on the question of the color of my skin, then there may be questions. But that's only one factor to be considered. If you take into consideration that there are no serious comments from all the institutions who had the opportunity to give their commentary, it would be sending out the correct message to the community that, and I'm not boasting myself, but my appointment will be in the interest of the bench of Gauteng, because there are no serious criticisms at all of the quality of my work. So the public outside can rest assured that a fit and proper person has been appointed.
Commissioner Lokis?
Thank you, TCJ. Do you agree that language can be an impediment on the project of transformation, for the reason that the language of colonizers becomes the most preferred language than the other languages? In this instance, this relates particularly to judgment writing. For instance, I read the comment on yourself, your judgments are well-reasoned, well-written, because you write in your own language.
Yes.
But generally, the GCP, when analyzing other candidates, would be very critical of their language. So I want to know from you, do you agree with me that the issue of language is central to transformation?
Yes, of course. Language, not only language, but culture is of importance in transformation. And that is why under the previous Chief Justice there was a strive that the official language of judicial procedures are in English. And English is not my first language. So we are all, to a certain extent, standing a bit back from your language. I know from my involvement when I was still on a governing body of schools for many years when my children were there. We had satellite schools in the rural communities which we have assisted. Education in mother tongue language up until a certain age is non-negotiable. It should be done. But we sit in a society where we have 11 official languages, and we have to marry that. And by doing that, we all have to, but for the people who are English speaking from their first language, we all have to make sacrifices. But there must be, and I know, and thank you for the comments on the language in my judgments, but at some stage somebody, and that may be avenue to have a look at, is to explain it from time to time from the judiciary in workshops or so with people in rural areas what a specific judgment may mean in simple language of theirs. I am unfortunately not proficient in any of the indigenous languages, which is a pity, because I wasn't given the opportunity when I was at school. There were not indigenous languages offered to us.
With your leave, Chief Justice, just that's the last portion on this question. When you first wrote a judgment, that is, as an acting judge, what challenges that you experience, and how would you relate those challenges that you experience to other acting judges, in particular the black judges, acting judges? Thank you.
Commissioner, the difficulty I had when I first started acting in 2015, I had a very prominent senior judge sitting next to me, and my JP will remember Judge Fabricius. Not only was he good, very proficient in English and Afrikaans, but also in German. And because of the difficulty of writing judgments in English, being Afrikaans speaking, I approached Judge Fabricius many times to assist me with the language. And that is, I think, which should be done, that from judges and acting judges, there must be some sort of fusion that acting judges must have. They must feel free to approach a judge or a senior person to assist them in the beginning, not only in the beginning, but also as it goes on. From time to time, that a senior judge just have a look at it and assist you to better your quality.
Thank you, DCJ.
Thank you, Commissioner Otyes. Prof?
Thank you very much, Deputy Chief Justice. Good morning, Advocate.
Good morning, Commissioner.
I was going to ask you about something else, but your answers to both the Judge President and Commissioner Nyokesi drew me to what I'm going to ask you on. You were asked a question in relation to the quality of judges and the judgments and the criticisms. And you repeatedly said that there are no criticism that you are aware of, and correctly so, because we have not been furnished with any. And Commissioner Nyokesi also asked about the quality, and you also said you yourself are not aware of the challenges in your judgments. And that drew me to the judgments of yours that I know I've read before. The first one is the one where you dealt with Matrimonial Property Act, and you dealt with issues of forfeiture and all those kind of things. But for the purpose of time, I want to go to another one that you wrote. This one you wrote, and that judgment was riddled with difficulties, right? Which I'm not really sure why the independent bodies were not able to pick up on those. But the one that I want to debate with you on is the one that you wrote in insolvency law. The body corporate of Heiselhurst versus Ramachia. It was delivered on the 27th of October 2017. I'm not sure if you remember that judgment. It dealt with, from what I can gather when I read the fact, it was compulsory sequestration. But when I read the judgment, it seems like you are confusing compulsory sequestration with voluntary surrender. And I'm going to point out something and I want your comment on it. The difficulty that I have with this judgment is, and I'm not sure, it's not part of the PEG, unfortunately. I don't think it's part of the PEG.
Of the bundle?
Yes. In paragraph 9 of that judgment, but do you remember that judgment? Because I want to be fair on you, but the thing is, I'm asking this based on the criticism that you raised.
If it's a 27 judgment, it's
2017.
Yeah, 2017. It's some time ago. I've had a couple of insolvency matters which I heard. So no, I don't recall.
But can I just point out?
Yes, you can.
The issues with this judgment in response to your response in relation to the quality of your judgment?
Yes, please.
In paragraph 9 of that, in paragraph 9 of this judgment, what you first do, you speak about the acts of insolvency, and you list about 5 of them. And when you start speaking about acts of insolvency, you give an impression that you are dealing with compulsory sequestration. In other words, what you are dealing with here is compulsory sequestration. And once you have outlined these, in the following paragraphs, you don't even deal with any of these acts of insolvency and what or which one of them is actually applicable in this case. And there is no reasoning in relation to the requirements of compulsory sequestration and as to why the person who is being sequestrated in this particular matter meets those requirements. And that is the first flaw that I found in this judgment. But apart from that, you confuse issues. In paragraph 21 of that judgment, you say something that is quite surprising. You speak about somebody making a notice to surrender their estate. And if you start saying somebody surrendering their estate, you moved away completely from compulsory sequestration. Yeah. You are now dealing with voluntary surrender. And that is a second issue that I have with this judgment. That shows, one, confusion in relation to the area of law. But secondly, lack of attention in relation to the research that is needed to actually get into the reasoning and the order that you're going to give. But the third fundamental challenge with this judgment is the language that is used. In paragraph, you can just bear with me just for a second. In paragraph, I think 20 of the judgment, the language, the sentence construction that is used there, and when you read the entire judgment, and I mean, it's unfair because you don't have that judgment so that you can see. But I just want to say that this judgment and the judgment that I referred to, it has similar sort of things that come out of them, where you rely on the law, not the law in terms of cases, but the law in terms of the statute itself, but your interpretation of the statute and your reasoning in relation to the statute leaves much to be desired. So I'm not sure whether it's accurate to say that the quality of your work generally, it is satisfactory. I think there are points of weaknesses, and it's quite disappointing that some of the bodies have not highlighted it, and which raises a concern that perhaps maybe criticism seems to be restricted to certain people and not other people, and that for me is a concern. I'm not sure. What is your response to that?
Firstly, Commissioner...
No, DCJ.
Commissioner Malem?
I think in all fairness, that question is not in keeping with what we have adopted. Because it's not only the law bodies that have got a right to raise issues with the candidate before he sits here. We all do. If we look at the law bodies report and the issues we have, which the law bodies have not raised, we all have a right to raise those issues and send them to the candidate. And that hasn't been done. And it's not me, it is through the admission of the commissioner that hasn't been done. And it's unfair to the candidate and to all of us, because even in the deliberations, that point cannot be referred to, since it has not been canvassed.
Thank you, Commissioner Malema.
Before that, I take a point, but the thing is, I'm raising an issue based on a judgment which is a public document, which of course all of us will have access to, and we did that even yesterday, where somebody said the Supreme Court of Appeal confirmed me, and we all went to try to see whether indeed the Supreme Court of Appeal has actually done that. So the question that I'm raising is in relation to the judgment that the candidate actually authored. So it's not about the bodies or any other person criticizing. So it's my criticism to the candidate. So it's not really about anyone else. It's my criticism as the commissioner to the candidate.
Thank you. I hear you, Prof. But look, the judgment you say was written in 2017, and he has written dozens of other judgments since. So it may actually, I'm trying to put myself in his position, and I'm thinking, out of all the judgments I've written, if I were asked on a judgment I'd written some, 5, 6 years ago,
I accept that.
It might be difficult. But the Advocate Olan Muta looks ready to answer. I don't know what he was going to say. Let's hear from him. If you feel that the question is unfair, you will say.
Before that, DCJ, let me just say this. I understand that. I said the question was based on the assumption, or the saying that there's never been a critique in my judgment. Then he went further and said, I am not aware of any challenges in my judgment. So I was asking on the basis of the second leg, I am not aware. So I was raising that on that aspect.
And I just ask for clarity if this judgment was appealed against?
No, it wasn't.
It wasn't. All right.
If I may, Deputy Chief Justice, respond to that, and I would like to thank Commissioner Malema for that. Yeah, it is an ambush question, and I cannot respond to that because I don't have it before me. I'd never said that I never made a mistake in any judgments. I said, in overall, I am not aware of criticism. And if this is a valid criticism, I would have expected, and in all fairness to all candidates, not only for me, but all the candidates who come here, is that you have in advance that criticism circulated to you so that you can be prepared. That is as far as I would go. I cannot comment on that. But a last thing is, that if it was 2017, yes, I would agree in general that the quality of my writing of 2015, 2016, 17 is not as good as it is today because there is an improvement.
Thank you, Advocate. Well, Prof, you have your answer, and you've
No,
exhausted your quota of one question a long time ago.
No, I'm done.
Yes, I also have a question.
Thank you. Good morning, Mr. Holland-Mutter.
Good morning, Commissioner.
I can obviate the whole debate about referring you to a judgment that you're not aware of by referring you to a judgment in your pack. Now, I assume that you put those judgments in as a sample of your writing, and those are the judgments you want us to consider your application based on. Am I correct?
You're correct.
Right. Can I ask you to look at the solidarity judgment? It begins properly at page 219 of the pack. Now, the first point I want to make, Mr. Holland-Mutter, and I do this in the context that we've been quite stern with all of the candidates that have appeared in the course of this week in terms of structuring of judgments, as well as where judgments are riddled with errors, etc. Just want to firstly put to you the broad proposition that this judgment, and I accept that it's a judgment handed down in urgent court, but that this judgment is riddled with typographical errors and spelling errors. Do you accept that?
I accept it if you say so.
The second thing I want to put to you about this judgment, and I've been through the judgment quite carefully, this is a judgment handed down in the context of an application for an interim interdict, pending the review of, in this case, it's the review of the Tourism Equity Fund, the creation of the Tourism Equity Fund. You recall the matter?
I recall that matter.
Yeah. So if one goes through the judgment, and I've got limited time, so I can't go through it quite as carefully as I normally would have, there's a few things I want to just point out to you that raised a concern when I went through it. And the first one appears at 221 of your judgment. If you look at the paragraph 8, you say it was a concern on behalf of the respondents that the relief sought by the applicants amounted to the court usurping executive powers because the action attacked amounted to the exercising of executive powers not subject to judicial review.
Yes.
So that was the first red flag for me, that what you've reflected there is your understanding that the exercise of executive powers is not subject to judicial review.
It should have gone further and said that under normal circumstances, but in exceptional circumstances, I agree, it is subject.
No, but I'm sorry, even that is not a correct reflection of the law.
Yes.
And I really don't want to debate the law with you. All I'm raising with you is what this judgment reflects.
Yes.
It's a very tenuous grasp and understanding of the basic law of review. That's the first thing. The second thing is if you go through the judgment and you say in page 223 of the judgment that what you want to do is you use the term peek. You want to peek into the merits of the main application for review in order to decide whether or not to grant the interim interdict. Right? When you do that and you see it gets dealt with from page 225 of your judgment. When you're dealing with the review, what you do is that you start making reference to the outer test. Now, you'll know that the outer test applies in the context of the interdict, the interim interdict, not in the context of the review. So what you do there is you're conflating two issues, which again is another red flag in terms of your understanding of where the outer test comes in and how it should be applied. Then the third and final thing that I need to raise with you is if you carry on through the entire judgment, and now we're looking at it from the perspective of structure. Again, what you're dealing with here is an application for an interim interdict. You don't see anywhere in the judgment that you deal with each of the requisites for an interim interdict. It's simply not there, despite your finding ultimately that the application should be successful. Perhaps you'd want to just respond to that.
Well, I hear what you say, that I should have, and it's preferred, if you do it in a proper way, that you take each heading which is applicable on a clear right, no other remedy available, convenience, etc. Yes, I would accept that. I should have done it more that way.
Thank you. Thank you, DCJ.
Could I ask for permission to just follow up, because my question is also on the same judgment? Thank you, Deputy Chief Justice. I counted at least 5 typographical errors in the judgment, but that's not my question, but I really want to caution this general acceptance that there's nothing wrong with your judgments. But the other thing I want to ask you is your understanding of Section 9 of the Constitution, because in this judgment you do reference the Minister of Finance versus Van Heerden judgment. So firstly, I want to ask you what the Huxon test entails, and secondly, how does it differ from the Van Heerden test? Because those are the prima facie questions you should have answered in this judgment that Commissioner Pillay shows that you didn't answer.
Yeah. No, I agree. I should have done that. The only defense that I have is that this was because of the urgency of the matter, I had to do it rather speedy.
No, but what is the Huxon test? How does it differ from the Van Heerden test?
I'm not going to waste your time. I'm not prepared on that. So no, I cannot answer you out of the first on that.
Thank you, DCJ.
Council. AP Bezo.
Thank you, DCJ. Good day, Mr. Holland Mata. Lest I be accused of inconsistency, I have 2 simple questions that I need to pose to you. The first one, you are presiding in a civil trial concerning a delictual claim for patrimonial loss, and the only element that is put in issue is negligence. As a presiding judge, what test then would you need to apply for purposes of liability to determine whether negligence has been established?
Well,
in essence, the court asked itself 3 questions. If you could share those questions briefly with the Commission in the interest of saving time.
Starting with to define negligence, you go to the classic of Kruger versus Coetzee, the 1966 then appellate division. Was it foreseeable by the reasonable person that his conduct will cause patrimonial loss? If so, did he take, or should the reasonable man have taken action to avoid that? And then the third question is, did the defendant take action to avoid that or not? And if the question is answered that he did not take evasive actions, then the inference would be that he was negligent.
Thank you. And my second and last question. You are sitting as a member of an appellate court against, in an appeal against sentence. Forget about let me say, in circumstances where the minimum sentence legislation finds no application. Under what circumstances would interference with the sentence imposed by the trial court be warranted?
Well, a court of second instance would normally only interfere if the court of first instance sentence was shockingly inappropriate. If not, the fact that the Court of Appeal may have a different opinion, but it is not to a varying to a large extent from what was imposed by the court or quo, normally would not interfere.
I'll leave with that, although it's not the complete answer I expected from you. Thank you. Thank you, DCJ.
Thank you, AP. Commissioner Singh?
Thank you very much, DCJ. I'm on the platform. Good day to you, Advocate.
Good day.
Just one question. You were born in 1961, so that makes you 62 this year.
No.
Now, if we look at 176.2 of the Constitution and we look at the subsections 3.2 and 4.4, it speaks to the term of service of a judge. Now, what is your interpretation of how many more years of active service you offer if you are appointed.
Can I just correct you? I was born in 1956, not 61, as you said.
Okay, I saw 61. So if you can just calculate that and tell us the
I'm
question would be how many-
66. I'm 66 at the moment. I have at least 8.5 years active service which I can render. If you look at Section 4, Sub 4 of the Remuneration of Judges Act, it allows a person to go past the age of 70 up until 75, and if you do not complete a full term, then there are certain formulae which comes into operation in the calculation of your salary, which should not be less than 40%, and also the gratuity. There is a certain formula which, so it's not unfair towards a person who serves longer. It's just to bring a proportion there. But
Thank you very much.
I have 8 years at least.
Thank you very much. Thank you, DCJ.
Thank you.
DCJ, just a follow-up on this, on the same, just quick
All
one.
right, Commissioner Dodo.
Last time when you were here, I'm here. Advocate, I'm here,
sorry.
yes. Last time when you were here, I expressed a view, and the view was that I'm impressed about your determination. You don't give up.
No, why should I? Because I want to serve.
You don't give up at all. And just in my heart, when you entered, I said, in a colloquial way, this man is here again. But it's okay. Now I can see that intellectually and mentally you are okay. I just want to find out, physically, are you okay?
Yes, I am.
No major operations?
No.
No diabetes?
No.
High blood sugar levels?
No.
Okay. All right, thank you.
I also don't have any heart problems, but only for my wife, but I don't need heart medicine. No, I'm in good health. I go once a year to the physician just for a checkup.
I'm not sure I'm comfortable with those questions, Commissioner Dodo. They cut too close to the bone. Commissioner Malem?
No, thank you very much. SC, I never heard you saying that your judgments, both in language and writing, are A+.
No, I didn't say A+. I said I don't have serious comments, criticism.
Yes, I heard you saying from the law bodies, and that question came from the JP.
Yes.
There hasn't been serious criticisms
Yes.
from that end. And that doesn't mean there won't be typos and all of that, because you just told us that English is not your first language.
That's correct.
Thank you.
Thank you, Commissioner Malema. Any further questions, colleagues? All right. Well, this is the end of your interview. Advocate, unless there's anything you want to say to us, you are free to go.
No, thank you. Thank you to all the commissioners for the time. It's valuable time that you give here. And it's all part and parcel that we all, in different views, serve our country. And I hope you find me acceptable, because I still have, coming to the commissioner there with health-wise and so on, I have a lot to give back. Thank you very much.
Thank you. Colleagues, do you want to take the tea break now? We were supposed to take it a long time ago, but because of the slow pace of today's proceedings, we're still here. Take a short, how long? 10 minutes? One more candidate? No? Okay, we'll carry on then. Good morning, Ms. Lenyai.
Good morning.
Are you ready?
I am ready, thank you.
All right. How are you?
I'm well, thank you, and how are you?
I'm fine, thanks. I see that you were born in my hometown.
Yes, that's where my mom comes from.
Oh, you still have family there?
Yes, I do.
All right. Well, not such a great place these days. Not what it was when I was a little girl, at least. Yeah. All right. You hold a BProc and LLB degrees,
Yes, DCJ.
and you're an attorney by profession.
Yes, I'm an attorney.
You're a conveyancer and notary public as well, I see.
Yes.
Okay. You have practiced with various firms of attorneys through the years, including for your own account, right?
Yes, DCJ.
And you currently run your own practice
Yes, that is correct.
since 2018.
Since 2018, yes.
How is business?
Well, the business is doing well under the circumstances. After COVID, there were a bit of challenges, but fortunately enough, this year, the work has been very well. Thank you.
And now that things are going well, you want to go to the bench?
I don't know how God works.
Yeah. I see that you are a member of a number of legal organizations, including the BRICS Legal Forum.
Yes, I am. That is occasioned by the fact that I serve as one of the leaders of the Law Society of South Africa, and in that capacity, you get seconded to all these other international bodies to represent and fly the flag of South Africa.
I see. And you are also a member of community organizations as well.
Yes, I've been raised that way.
Yeah. What is this CareNet Development and Support Organization? I've not heard of it.
Which one?
CareNet Development and Support Organization.
Oh, a CareNet, or the CareNet. CareNet is we predominantly do social work services that we offer to families in crisis, children who are placed in alternate accommodations by virtue of being subjected to abuse at home. We offer a care and financial support and social services work. We also offer educational support to children between the ages of 0 to 18, as well as early child care development from 0 to 5.
All right. Well, that's a service which all our communities sorely need.
Yes.
You have indicated that you have a disability. Does it affect your performance of your work in any way?
No. This happened while I was still very young, and I have learned to turn my head in such a way that I can catch all the airwaves and I can hear quite properly.
Yeah, I can see that you're not struggling at all. Okay. You disclosed that there was once an attempt by the LPC to strike you off the roll.
Yes, I did, DCJ.
And you were suspended from practicing for your own account for a long period of time.
I was never suspended. I was interdicted.
Sorry, you were interdicted from
Yes.
from practicing for your own account.
Yes.
Under your own name and style for 8 years.
For very long 8 years, DCJ.
All right. What is the situation now?
The matter was resolved on the 25th of October, 2017. Would you like me to clarify further?
Yes, please.
We were, initially when the matter started, there were allegations that there were trust deficits in our trust account. These trust deficits were occasioned by the fact that the LPC sent, not the LPC, I must correct myself, the Law Society of the Northern Provinces, sent an account, their auditor to come and check our books. When he came, he checked our books and he found that, according to him, there were trust deficits. When I explained to him that there were no trust deficits because certain funds that belonged to trust creditors, we had actually opened trust investment accounts for those trust creditors. Those monies were occasioned by transfers that we did on behalf of the then Department of Land Affairs, where we were transferring property from farmers to the beneficiaries of the land claim. The farmers did not want to leave the property immediately after the transfer had taken place. In the deed of sale, a certain clause was included there to say that the farmers will be afforded a further 12 months to stay on the property, and 3% of the purchase price will be retained in the trust account of the conveyancer, which in that case was our firm. What we then did, we took that 3% and invested it in an interest-bearing trust account linked to our trust account. Immediately thereafter, the lawyer of one of the farmers started demanding the money. Now, the clause that I referred to had a further provision that after 12 months, when you leave, you need to give written confirmation to the Department of Land Affairs as well as to us, confirming that you have left the property before the funds can be released to you. When we responded to the lawyer that, has your client vacated the property? The lawyer did not respond to us. Instead, he took an application to liquidate our firm. He served the Law Society of the Northern Provinces, SARS, and the Deeds Office. So when he did that, we entered a notice of intention to oppose, filed our answering affidavit, and gave evidence that the money was indeed in the interest-bearing account. On the day before we went to court, the attorney then withdrew the matter, seeing that he had no hope of succeeding. That was the basis why the Law Society then sent their auditor, because they were in possession of that application to liquidate our firm. The judge who had the application to suspend and strike us, when he saw our answering affidavit, again, the same information was given. He did not find a good enough reason to suspend us, but rather decided to interdict us to give the Law Society an opportunity to come and verify this information.
And it took 8 years to do that?
It took 8 years. For some reason, they were not hearing us. I don't know why they chose not to believe us when we told them that the money was in the trust account and believed other people. After 8 years, only then was a council meeting taken to say that it was not appropriate to continue to want to persecute us in this unfair manner, despite clear evidence being shown to them that the money was in the account. When that resolution was presented to us, me and my then partner were not satisfied, because the interdict remained, and Part B also remained. And this was a very long and very difficult time of our lives. We were considered as the piranhas of this legal profession. People did not want to be associated with us. Clients did not want to be associated with us. And we felt that we needed to clear our names once and for all, so that we can start again and continue with whatever that was left with our lives. And that was what has happened. And I saw in the comments by the LSSA and the GCB, in my application, they alluded to the fact that I had not made it very clear what caused the interdict and the eventual upliftment of the interdict and the dismissal of the matter. That's what prompted me to then write a written submission that I would like to believe that all the commissioners here have had sight of. And I've just basically repeated what is in that document. Thank you, DCJ.
So the long and short of it is that the interdict no longer exists, it's since been uplifted.
The interdict no longer applies, and I believe that there are no issues with regard to my integrity.
Okay. You have acted as a judge in the Gauteng division of the High Court for a few times.
Yes, DCJ.
And you've written judgments, I hope, during those acting stints.
Yes, DCJ, I have.
How many?
According to my count, there is 47 judgments that I have written.
All right.
Some of them were written by seniors that I was sitting with in full bench and full court appeals.
No, I mean those that you yourself have penned.
The ones that I myself wrote are 40.
Okay.
Yes.
Any of them reported by any chance?
No, there hasn't been one that has been reported, although there is one that is in the pack that I had hoped that it would be reported, but it hasn't been reported. But I have been advised by some of the senior judges that they have seen my judges on Safely and on LexisNexis.
All right. Did you mark it reportable?
I did, DCJ.
Okay. All right. I'm going to stop now and hand you over to the Judge President of the division you want to join, JP Mlambo.
Thank you very much, DCJ. Good morning, Ms. Linyai.
Good morning, JP.
If I knew your clan name, I would address you that way. You've acted for a total of 30 weeks. That includes this latest stint this year. Am I correct?
JP, you are correct.
Thank you. And those 30 weeks, do you form the view that they've adequately prepared you to take on the load of a judge in the division permanently?
Yes, JP, I believe. I believe those 30 weeks have adequately prepared me.
Yeah. The reason I ask the question is, you've not been able, you have a very busy practice and responsibility to associations and organizations, but you've not been able to give me a full term to say I want to act for a full term. Have you?
No, JP, I have not been able to because of the other things that I'm busy with.
Yes.
Yes, like this year, you wanted to give me a full term, but I could only give you 6 weeks.
Yes.
Yes.
But am I correct that in those weeks that you've acted, you've heard the groans and screams and shouts of desperation of permanent judges who are carrying the full load?
Yes. Actually, let me just correct one thing, JP. In the first term of last year, I believe I did give you a full term.
You did a full term?
Yes, I did a full term, 10 weeks.
My mistake, 10 weeks, yes,
10
I see
weeks,
it now,
yes.
thank you.
And yes, all my senior judges, every time when they see us in the corridors at tea or when we visit each other in the offices, I have been asked, when are you applying?
Yes.
The workload is too much, and some of us, we want to retire, but we can't because there are no people coming in.
I think, in all fairness, I'll disclose this to you. Those comments also came to me, especially after that special motion that I gave you. You remember, you wanted to complain. Why am I giving it to you?
Yes, JP. I was under the impression that you didn't like me, but it was a very, very big judgment. It nearly broke my head. But the other reason why I wanted to complain, JP, was that I only became aware of that special motion 2 days before the matter was to be heard. However, the DJP came to my rescue. He advised me how best to prepare to make sure that I am able to get in court and listen to the parties. The matter was huge. It has constitutional aspect, administrative law, contractual law. It had everything in it. And me being a puny judge, as I've heard people referring to us as puny judge, I thought it was beyond me. But DJP advised me that that matter was given to me because the leaders of the court believe that I am capable of addressing that matter and make sure that I produce a good judgment. And I did my best.
Just to finish that part, after you heard the matter, you came to me and to thank me for giving you the matter. Am I correct?
Yes, that was so, JP.
And it's one of your, when you list the judgments you've written, it's one piece that you really treasure the most. Am I correct?
I do, JP, because that piece of work actually took me out of my comfort zone. I had to dig deep in me and also do a lot of research, and it really made me want to do more of such kinds of work.
Yeah.
Challenging as it was, I'm thankful.
Just before I go to the other comments, I just want to thank you for availing yourself whenever I was asking you to come, because it was a struggle for you to leave what you were doing and to come, but you did come now and then.
Yes, JP.
And I want to thank you for availing yourself, because it shows you feel you are ready. Now, the comments that I've seen, I've told you the positive comments from judges. The comments that I've seen from the law bodies in terms of your current application, they are actually commendable in terms of how you've performed. In fact, what the GCB says is that your appointment will send out a good message that the judiciary puts value in people who produce judgments, well-reasoned judgments, timeously. Did you see that comment?
I saw it, JP, and I was, I must say, humbled by it, because I am still learning. I'm still learning how to grapple with the legal issues and make sure that I deliver my judgments in a reasonable time. And to get those comments, especially from the law bodies like that, it was very humbling for me. Although I must say that there is still room for improvement. And if given an opportunity, I think I will do better than what I have been doing now. Because I will not be burdened with all these many things where I am in leadership, where I have to juggle my time before I can focus on my judgments. Because this, I consider being a judge as a service to the people of South Africa. There is nothing glamorous about this work. It's back-breaking, and you really have to be committed and show resilience and be willing to put in the hard work and be willing to learn and be advised by your seniors.
Yeah.
Thank you.
Well, you left one thing in describing the work. It's also an underpaying job. Thank you very much, DCJ.
MEC?
I think I'm covered, so let me spare you time. Thank you very much.
Thank you, MEC. Questions, commissioners? Yes, Prof?
Good morning.
Good morning, Prof.
Thank you very much. I just want to speak to you about a judgment that you wrote, which I really enjoyed reading. It is on page 86 of your bundle.
Page 26.
85 actually, 185 at the bottom. It was an eviction matter.
Yes.
Where you were dealing with an elderly person who was being evicted, and I think she also had children. And I mean, I fully endorse your approach and your reasoning. I think it's a very good judgment. I just want to ask you out of it, quite generally. the eviction laws in South Africa, when you look at them, on the one hand, you have the issue of arbitrary evictions. On the other hand, you have the issue of illegal occupation. And in most instances, you find that the people who are occupying the property, apart from indigency, they may be interfering with the right of the owner of the property. But our constitutional dispensation, we cannot just evict people while they are going to be rendered homelessness. I'm always curious as to when and how are we going to be able to balance the rights of the two people. When somebody who's quite wealthy comes and they have all the ownership entitlements over the property, but there is these poor people who are destitute and they have nowhere to go. And there is this issue of saying you need to provide alternative accommodation. And court after court has said this is not a duty that only resides on the municipality. And there must be a report. You deal quite well with that in the judgment. How do we balance these two issues?
Thank you, Commissioner, for that question. My personal view is that what I have observed from litigation and what is happening, the municipalities are not playing their part. There are no reports that are placed before courts to assist the courts to come to a conclusion that when you evict people, they will have somewhere to call home. The Constitutional Court calls it just and equitable. If the applicants, through their legal representatives, will ensure that the municipalities bring their reports, because the municipalities, if you do not push them, they will sit back. And you cannot come to court and ask a sitting judge, be it a full-time judge or an acting judge, to offend the presence of the Bill of Rights. That cannot be. However, me, in my personal capacity, when I have a client who has a bit of money and he is sitting with a situation where somebody is sitting in their property and refusing to move out, I do advise them that, take it as a sense of your social responsibility. Buy them an RDP house or something. Let them go stay there. Once you have bought them the RDP house, I think they can try and find ways to find out how they can pay for other services, or the municipality. There are programs there. It's called the Poorest of the Poor. They can go there and apply, and the municipality will offer them the necessary services. That is how I normally advise my rich clients. Thank you.
It is in line with the recent judgment from the CC, and I think it's the right approach. Thank you very much, DCG.
Thank you, Commissioner. Commissioner Shabangu Mdawe.
Thank you, DCJ. Good morning, Ms. Nyai. I almost said good morning, Ms. Mabayeng.
Thank you, Commissioner. I must disclose that she is my president in Saula.
I was also going there, DCJ, to disclose first, but thanks, Ms. Mabayeng. Ms. Mabayeng, I just want to commend you with whatever you've achieved thus far. It gives courage to young women who are coming after us and you. I want to find out from you, what is it exactly that we as leaders can do to have people that can, when JPs want acting judges, they can get good people who will produce quality work. In answering that, can you also indicate if training is enough without experience or without practical? And if really practical or training, experience is needed, what is it that we can do so that we can align the training together with the practical? Thank you.
Thank you, Commissioner, for that question. I will start with the first one of how can the JPs find candidates to come and act. What I believe should happen is that if you are fortunate enough to find yourself to be in a position of influence, you need to use that influence to bring others up. It is a slogan in Saula to say that as you rise, bring others up. And that is exactly what happened in Saula. There was a call from the JP to the Secretary General of Saula to produce a list of female candidates that JP can draw from to come and act. And the names were written there, and I remember I did not forward my name because I do not normally litigate in the normal way that people normally litigate. And I remember the Secretary General calling me at midnight, scolding me for not having presented my CV. And I did that, and I am thankful that JP, when he was selecting, he selected my name, despite the fact that I originally did not see myself in that space, because I believed that if you are not normally in the courts, you will not be competent enough to sit on that bench. And as I say, if people of influence do not use their influence to draw people out, like Saula did, like JP did, then those people will remain hidden. Us as the law bodies, what we used to do before the Legal Practice Council, the Legal Practice Act took over and the law societies, the provincial law societies were disbanded in 2018, the Law Society of the Northern Provinces, together with the LSSA, used to have what we call judicial skills training. In that judicial skills training, the law bodies were trying to upskill their own legal practitioners to make them ready for when JP calls them. I went there not because I thought I was to be called. I went there because after that hiatus of 8 years, I needed to build my own law firm, and I knew that I did not have somebody else who was going to lead the litigation department. So I went there to upskill myself. And in there, sitting judges were training the attorneys and some advocates who would avail themselves. That has unfortunately fallen off, and I put this clearly at the seat of my leaders in the judiciary, because the LSSA, we did try to continue with this in our quest for furthering and protecting the interests of our members. And the answer we got from the judiciary was that they are busy at Sajay. Now, the problem at Sajay is that if you are not a sitting acting judge, you will not be called to go to Sajay. But I have seen recently that some inroads have been made by the Office of the Chief Justice to transform that. But I think we need to also continue and go back to what we were doing up until 2018 to augment and add on what the Office of the Chief Justice is doing. In that way, we will have a large pool of attorneys and advocates that are ready and able to take on the job. Thank you.
Thank you, Ms. Linyai. Thank you.
Thank you, Commissioner. Commissioner Matolo-Tlepo.
Thank you, DCJ. Good morning, Ms. Linyai.
Good morning, Medlepu.
Yeah, my issue, DCJ, is to declare that I know Ms. Linyai very well, and we've been serving in structures of the BLA together, so I don't want her to be, so I know her very well. But what I wanted to clarify on the issue of your interdict, so that people don't go out thinking that there was something wrong. I was in the structures then, of the Law Society of Northern Provinces. You were only interdicted not to practice on your own account, but not as an attorney. You could
That
still-
is true, yes.
Okay, I just wanted you to clarify.
Thank you.
No more questions from the floor. Any questions from the virtual platform? Commissioner Singh, Bernard?
No, thank you, DCJ. Thank you. Very impressed. Thanks.
AP Betse, thank you.
Thank you, DCJ. Good day, Ms. Linyai.
Good day, Acting President.
I've got two simple questions for you. The first one, you are sitting as a member of an appellate court in an appeal against sentence by an accused person. And my question to you is, under what circumstances would interference with the sentence imposed by the trial court be warranted? Generally, without regard to the provisions of the minimum sentences legislation.
Thank you. Ordinarily, an appeal court does not easily interfere with the decision of the court of core, especially with regards to sentencing, unless if it finds that the sentence that has been given is so gross and disproportionate with the presence of the law.
Then thank you. My second question to you, you are presiding in a civil trial concerning a delictual claim, and the only element which is in issue is negligence. And for purposes of establishing liability, what test would you need to apply to determine whether negligence has been established?
Thank you for the question.
In essence, the court would ask itself three questions. Could you briefly?
The court would apply what I would call the reasonable man's test. You would look into the actions of the defendant to see if the manner in which the defendant conducted themselves was reasonable. A reasonable person in the position of the defendant would have acted in that manner. If the answer is that the defendant did not act in a reasonable manner, then I would find that the test for negligence has been passed.
Thank you. Thank you, DCJ.
Thank you, AP Betse. And we have no more questions for you, Ms. Lenyai. So this is the end of your
Sorry,
interview.
DCJ. Sorry, DCJ.
You're sitting right next to me. How did I miss you? Okay. From the virtual platform, and the definitive answer was no. But I'm not going to stop you, Commissioner Bernard. Go ahead. Then it's you, TM.
Thank you. I'm so sorry, DCJ. This time around, I was doing the load shedding switch. Our power just went off. It took a second to just do the switch. Ms. Lenyai, morning. First, I must declare, I think it's important that I serve with you on the Executive Committee of the Law Society. But my question is also mainly about the Law Society. So just quickly, last year you were the first president of the Law Society whose vice presidents were also all women. So it was a full, let's call it a full bench of women leaders. How did you experience that, and how was that and your term as president positively impacted on female legal practitioners?
Thank you, Deputy Minister. I must disclose that I am no longer the president of the Law Society of South Africa. My term ended at the end of March, and my constituency has asked me to stay on until they can find somebody to come and step in my shoes. I'm now currently the deputy president. I found my stint as as the president of the Law Society, I enjoyed myself. I was exposed to tables that I would not normally have been exposed to. I represented the LSSA and the country both regionally, continentally, and internationally. My peers accepted me and respected me and also mentored me. It was very interesting. You are a leader of people, but they are also mentoring you. Some of my mentors are sitting at this table. I will not mention them by name. And what it has made, it has given that young girl that I see in the malls. I get stopped these days by little girls. They want to have hair like mine. They want to become attorney like me. And some of them are already referring to me as judge, and I told them I am not yet a judge, I'm an aspirant judge. It has given young girls and young women the hope that they too, despite whatever adversaries they come through, they too can make it. It does not matter what circumstances you find yourselves in. If you think that you are not guilty of anything, your integrity is intact, it frees you up to do the work that enhances other people and lift them up. But there was also the added burden that as the first president of the Law Society, to fail was not an option. That is why I could not give my JP the many weeks that he wanted from me, because I had a responsibility to my sisters to succeed and make sure that I plant a seed in them, that it does not matter where you come from, what has been thrown your way, you just step up and do the work that needs to be done. I tell them that you need to see yourself as a brand. When you are a brand and you want people to follow and do what you do, you try to do what is best, set a good example, both in your personal life and in the spaces where you are working. You need to be exemplary in everything that you do. And I think I have managed that, because everywhere where we go, when we do outreach programs at the LSSA, BLA, and all the other structures that I serve in, people recognize that and they want to emulate that. And my co-presidents in the LSSA are also the same. And I think this is the only thing that we can do, because there is misconceptions out there about black legal practitioners that seems to suggest that we are less than. It is not that we are less than, it is only because we are not given opportunities. And I would also like to take this space, as I see the minister is there, that when it comes to briefing patterns, I must confess that I really don't think anything is being done. There's lack of political will. In my personal space, I have been put in so many panels, but I am yet to receive an instruction. People with less qualification than me get the work, and I'm here to tell you, Minister, that work lands on my desk because they can't do it. I do the work, give it to them, they bill you, and they pay me. And what I have realized is that professional black people, not only in the legal sphere, are not given the necessary space to grow. I will stop there.
Finished, Commissioner Bernard?
Thanks. Mine wasn't actually a question to, sorry, first of all, are we still mourning? No, we're not. But good afternoon.
and Ms. Lenyai. It wasn't actually a question to you, but I just thought I should still ask it while you were here. Now, sorry, I've lost things in the file. The GCB, in their submission, complain that they don't have the Annexure MMD, which is the court order that Ms. Lenyai refers to. This is now when the interdict is uplifted, but it is in the file. It's on pages 113 and 114.
Yes, it is.
Yeah,
They must have missed it.
It was more to the commission. Did everybody else not get a full copy of this bundle, and why did the GCB not get it? Okay, but I just thought I should publicly raise that question. Maybe the GCB can respond later. And then maybe just quickly while I'm on the floor, yes, it's your interview, not mine, but the Department of Justice does set targets for briefing of black practitioners and specifically women. I think there is concern about reducing possibly the targets of briefings for women because of the unavailability of counsel. But that's something we can more engage on outside. But there are attempts. I'm sure more can be done. Thanks.
I don't know if you want to respond to what the deputy minister has
No,
just
I
said.
think I will leave it there. It is a debate for another forum.
Oh, you had put a question to him. I see. All right. Well, no further questions, it seems. I already thanked you for making the time to avail yourself for this vacancy and subjecting yourself to this torture. But it was a good interview, I think.
Thank you very much, Commissioners, and have a good day going forward.
You too. Thanks. Commissioners, I've just... We go eat quickly and come back. How long do we want this lunch to take? 30 minutes and come back, directly back, please.
The next candidate who's supposed to come in, Mr. Patrick Malungana, approached me and sought my guidance, whether it was appropriate for him to withdraw at this stage. And he explained to me that he felt he probably thinks he needs more time to prepare. And I said, look, it's up to him. It's his decision. He's here. We're ready for him. And then he said, well, in that event, he would prefer that he withdraw, and he apologizes that he withdraws at this stage. He feels he wants to do more work, get more prepared to come and face this commission. So I advised the DCJ as chair of the session, and she's aware of this. Thank you, DCJ.
Thank you very much, JP. Well, it is the candidate's prerogative, not so. There's nothing we can do. Now, there's an issue with the next candidate. His papers are incomplete, and it's not his fault. It's our secretariat's fault. Our records are not complete, and they're still making copies, and apparently the photocopiers here are exceedingly slow. So they say it will take another 20 minutes or so to get copies for all of us. So I was proposing that we call the next candidate, Mr. Mota, so that we don't waste time. Is that fine? Okay. All right.
DCJ,
Yes,
there is a matter that I want to raise, and I want to raise it here. This thing of visual platform must be discussed properly so that we develop a way of handling it. In my own view, sometimes it wastes time, it disrupts us unnecessarily. We've got to wait if we get a load shedding so that we reconnect with those. And last time you were not here, we had to battle with the premier from the Northern Cape. And just today and yesterday, it created an impression that you don't want to allow other people who are on a virtual platform to speak because we have not noted them. My view is that it must be under strenuous, exceptional circumstances that we allow this, because it ought to be explained. I'm making an example. We all know sitting here that the next session is in October from the 3rd until the 6th of October. We all know that. And what would be the reason that a commissioner would say, no, I'm not available, I'm held up there, without clear-cut reasons that are coming forward? For me, I think this is inconveniencing, and we need to present here and talk about it a bit. Thank you.
TCJ,
Commissioner Malema?
I don't think this is the platform. I really don't think this is the platform.
That's what I was going to say too. Okay, we'll deal with it at an appropriate stage. But thanks for raising the issue, Commissioner. Okay.
I think Commissioner Todova must tell us which of the people on the virtual platform he wants to prohibit from speaking.
Good afternoon, Mr. Mota.
Good afternoon, DCJ.
How are you?
I'm in trepidation, but ready.
All right, well, that's good enough for us. Just speak a bit louder than you are at the moment. And
All right.
Yeah, that's much
Is that
better.
better?
You're a holder of a BA and BA Law and LLB degrees, which you obtained from VETS.
Precisely.
And you've had a checkered career. You started out as well. You did articles, but then did not join the sidebar. You decided to teach. Is that so?
No.
Well, that's the impression I get from your application form. It says you did articles between 93 to 95, and then in 95 you taught at Vista University.
Oh, yes. I had finished my articles at that stage. And then I got an opportunity to teach at Vista University. Then I took the opportunity.
I'm sorry, I didn't catch that.
I had finished my articles at that stage and got an opportunity to teach at Vista University, and I grabbed hold of the opportunity. Yes.
And you taught, where was this, at Vista University?
I've always been a Sowetan, so it was in Soweto. I'm a Sowetan at heart.
Yes.
Yes.
And you taught for how many years? 5 years?
It was quite some time. I can't remember very well, but it must have been 4 to 5 years until when my practice picked up. Then I saw that it was not possible to juggle both, then decided to focus on my practice.
Yeah. All right. So you taught part-time. You're also running your own practice while
Precisely.
teaching?
Yes.
Okay. Then in 2019, there's an indication here that you taught law at the Northwest University.
Yes, I got another opportunity to teach at Northwest University. And
What happened to your practice then? Did
by
you
then
continue?
my practice was pretty stable. I mean, as you can see, it was almost, 20 years later. So I had candidate attorneys, PAs, and it was pretty vibrant. So I could afford to go and teach and also take care of my practice. But I taught on part-time basis.
Okay, that's what you are doing to date.
Which is what?
That's what you are doing as we speak.
No.
Not any longer?
Yeah, as soon as I got the opportunity to act, I felt that I had too much on my plate and needed to narrow down my scope and focus. So I stopped lecturing and focused on practice and acting.
Okay. What kind of practice do you run, if I may ask? What kind of work do you do?
I run what I call black law. You see, I come from the old school. A number of judges, some in the SCA, some in the Concord, practice with me. We're all practitioners. And the only form of practice that was open to us during those dark days of apartheid was basically criminal work, MVA, divorce work, that type of work. And it didn't help that I was in Soweto. I didn't want to go out of Soweto because I wanted to serve my people. And that's where my heart is. I wish one day there could be a high court in Soweto and I would be the first one to stay to work there. But yeah, so it was black law, that type of work, not your complicated stuff like your, I see, can't tell me why Dovi looks the other way, Commissioner, your administrative law. It's only now that these fields are opening up to the young ones. Our kids have these opportunities, I must be honest, and the sky is not the limit. But for me, that was the type of law that I was exposed to.
Well, it's still the type of law that's available to most black practitioners, unfortunately.
Yeah, unfortunately, you're correct. But I mean, I blame to a large extent our government There's a lot that they can do. Just as a side issue, take the issue of Baja. I don't understand why Baja is not referred to as Batu Beli. Why is given a descriptive kind of language? We should use our own languages to try and put our people involved in law. You know, unfortunately, we lack creativity. And if you lack creativity, then black lawyers will suffer. Because if you look at Baja, which is of paramount importance, it's white, it's European. We've got our own concepts in the township, which are not being included in the whole legal system. For instance, we have something that is called umhobolo, ubalihobi. Every black person who comes from the township will tell you that some of the decisions of administrators are motivated by that. But you will not find it in Baja. Instead, you will have this concept of bias, capricious, irrationality. What about us? Include us, put us also there. I think we've done well in terms of changing faces in the judiciary, but we've not done well in terms of changing the concepts. Even in the Concord, I mean, you only see concepts such as Kumalo test. That's how far they go. You know, you don't get a concept that is black-based, that is based in our people and understands the concept of our people. And that is my, you know, the thing that is the bane of my existence, that we don't seem to appreciate that we have two parallel systems. We have the European system and we have our own system. I have an advantage because I've worked in Soweto all my life. I can tell you now, some of our people's lives are not taken care of. They do not interact with the law. Take, for instance, Ubusangoma. You know, people get injured there. People get serious incisions, but they can't sue the state. But if they go to the hospital where they interact with white law, they're able to sue the state. We must be creative. We must find ways and means of changing the law to apply to us as black people. And when I say, I hope one day there will be a high court in Soweto, I mean it. Soweto has more than 2 million people. That's bigger than Northern Cape. That's bigger than Swaziland. And it's mostly populated by previously disadvantaged people. You know, I mean, you have Indians there in Lenasia, you have Coloureds in El Dorado Park, in, what's the other township? There's other township. Then you have blacks, all blacks you can think about. I mean, from Zulu, Xhosa, Pedi, Shangaan, Venda. And you must understand, they all come from these provinces we're talking about. I'm sorry, I'm just being long-winded. I'm just venting. But it's what I always wanted to say. Let me say it, and people, let's hear it, because I feel that we are being neglected. We're not taken on board. The whole issue of language. I mean, I've been listening to these proceedings. It's a crying shame that in this day and age, black people, and you can see it's only black candidates who are questioned about the question of language. You know, those who are privileged, they're really laughing at us and saying, we're now beating them with failure to understand. It's our kids. I think I must take my child to the UK, and she will definitely fit nicely here. Because if my child comes from Zola and goes to the school that I went to, which is Pesesco, which is opposite Mandela's house, not far from Bishop Tutu's house, adjacent to Kizam Taung's house, during those days along Vilakazi Street, those people are not catered for. The advocates that I saw appearing in court as a judge, an acting judge, I can tell you now, some of the courts were white. Lily white. I mean, my first acting stint, I was blown out of my mind and said, what's happening here? Because remember, I'm from the RAF, you asked me what I do. I'm from doing RAF, Road Accident Fund Matters. And that's where you'd see a lot of change. You'll see black, white, colored, Indian attorneys. But since that stopped, then you have unopposed matters. You go to an opposed matter, as it happened in one case when I did my first acting stint. I was really wet behind the ears. So I relied on my registrar, and she said, Mr. Judge, we're going to call all the matters at once. And you can imagine I had 14 matters on that day. So you multiply that by 2, that's almost 28. My maths has not always been good, hence I'm a lawyer. So you have 28 litigants, because it's opposed motion. I can tell you, of the 28 litigants, very few were black. And I was taken aback. I was really, really shocked. And I was asking myself, where do they think these people will get all this experience if we don't have black practitioners here?
We hear you.
I'm sorry, I'm just venting, but I need to mention this so that
you are quite passionate about these issues.
Whether I get elected or not, but at least I would have told the truth, because one of the qualities of a judge is that you must tell the truth. So it's the truth that I'm telling, and that's what's happening on the ground if you're not aware.
Well, you've had occasion to act as a judge.
Precisely.
For how long?
It's 34 weeks now, because I was
34 weeks.
acting last week in the Zimbabwe exemption permit matter, ZEP.
And I noticed in your application form that you have been sitting as a small claims court commissioner for a
I love
decade.
that. I am even wearing the tie from the small claims court, because I feel that's where Section 34 comes alive. You see people being assisted, you see people, and the whole question of language just becomes so pronounced, because when people speak in their own languages, they're able to argue their issues. It's a joy to be in those courts. And I love that. I've done that for a long time. It was not for this purpose. In fact, I wouldn't be here had it not been for Judge Matopo. I must say, I didn't see myself as a judge. It's Judge Matopo who kept on persuading me, and finally, even now, I've been relying heavily on him. So yes, so I did that because I love it, because it's payback time, and I love my community. I really, really love my community. I wish we could all be like that.
No, that's not a bad thing at all. What I wanted to ask is whether you've had an opportunity during your acting stint as a judge to infuse this philosophy from the grassroots that you speak so passionately about.
To infuse where? Maybe I missed you.
In a matter you had and in a judgment you wrote.
No, I haven't
And
had...
went beyond the Kumalo test.
Remember,
you say
yes, no, I hear you. They say in Latin, festin lente. You must move very carefully when you start off. You can't just ruffle feathers from the word go. But the truth of the matter, I haven't had the occasion where I got a judgment where I could really talk about what's happening in the country, which is sad.
Maybe if you are permanently appointed, you will get that chance.
Well, we don't know.
Let's see what happens.
We don't know. I still wish that they could build a court in Soweto, because the court that we have there is horrible.
Well, the deputy minister is here and he hears you, so maybe.
I hope she's hearing me, because truth be told,
it's a he.
It's a he. I don't know.
That gentleman over there.
I apologize. Is that the sincere apologies? Sincere apologies. But these days people are binary, so you never know. But the point I'm making, Deputy Minister, is that if you go to Protea Court, which services a huge population of black people, it's a crying shame. The only proper structure, it's the one that was built during apartheid. That's when I was practicing. Now I don't want to practice there because our government has built zozos. They've built shacks. You find a magistrate sitting in a zozo. And not that funds are not there, just a stone throw away in Poisons. A state-of-the-art court was built. Why couldn't they build that court in Soweto to service our people? I really don't understand it. What's wrong with us?
Well, he's heard you. No, you may not, Minister. All right, but very briefly.
The problem with Soweto has been getting land to build a new court.
That can't be the problem, Minister. That's really passing the buck. There's so much piece of land. In fact, developers are developing
That's
Soweto.
exactly what I feared would
Yes,
happen, and I'll put a stop to it right
Let's
now.
not go into that, but we can have this discussion outside. But there is so much land. It's growing. It's going towards
DCJ, could I stop this?
Yes.
Because,
JP
some of us are very
I'm-
involved in that process that this candidate won't know.
Yes.
All right, well, JP
No.
Mlambo, I'm going to hand the candidate over to you now
Sorry,
to put your
JP.
questions.
Thank you very much, DCJ. Yes, I mean, we are aware of the situation in Soweto. The CJ is aware. We are very involved. Very involved. Yes, there's a lot of land. There's a lot of land.
Yes, it's not only that.
My first question.
All right,
my
sorry.
first question to
Okay,
you.
sorry about that, JP.
My first question to you is: you're very passionate about being in Soweto, hence your practice stayed there.
Precisely.
That's commendable. You've acted for the spreadsheet I circulated was 31 weeks, but you correct that has 3 more weeks that's been added because of the work you had to do this term.
It's a week. It's a week. Yes.
So is it 32 weeks? I heard you mention 34 weeks.
I was in court for 4 days, so you can add 4 days.
Okay, that's a week.
Yes.
Now, in your acting stints, the only area you've not touched is the area of special civil trials and criminal trials.
Yes.
Am I correct?
Precisely.
Right. How did you find that week when you did agent court?
Agent court was quite a revelation, and the problem with agent court is the failure. Sometimes it's not the failure, it's that candidates do not want to understand Rule 612B. Rule 612B just asks for 2 things. 1, you must show reasons why your matter is agent. Explicit circumstances must be stated why the matter is agent. The second one, it's lack of substantial redress at a hearing in due course. Now, if you fail to give reasons for lack of substantial redress or at a hearing in due course, how can you get an agent application approved? Because agency looks at the form and looks at the service. You have your Luna Mabel judgment, which gives you the gradation, basically, of what you should do, and you have your Publicae case, which talks about service. People do not do that.
You're giving ammunition to that full court there when you mention those.
Yeah, no, I know. Look, at the end of the day.
So, what I want to ask you is, in that week, how many matters did you have? There were 2 of you, is it?
Yes, there were 2
but
of us.
You individually, how many matters did you have?
We had 34 matters in that week.
Okay.
So we split them between us, and I had.
Was that a recess agent duty allocation or a normal term?
No,
allocation?
it was a normal term, JP.
It was a light week, I can tell you that.
Well,
the average number is 60.
Yes.
for
But-
2 judges.
Yeah, I might as well add that I harken back to the days when I used to do after-hours bail application during the agent matter, because I had one matter which was called in the evening.
Yeah. Now, you were allocated one special motion,
Yes,
but the one you're mentioning now, the ZEP matter, is the second one.
yes,
But that's a full court matter.
yes.
The one that's reflected here, you sat alone.
Yes.
Am I correct?
100%.
How long did it take you to produce that judgment?
It was less than 2 months.
Right. And did you find it challenging?
Law is not difficult, as long as you understand the rules.
Yeah.
I'm talking now as a lecturer. But once you understand the rules and you understand the facts, so I understood the facts. In fact, I tried to put the parties at ease by preparing a small spreadsheet and read out of it what the issues were all about. Because sometimes you have these counsels, senior counsels, let's not mention names, who think you know absolutely nothing. So yes, I found it quite a joy to deal with. Maybe it was because it was dealing with the Rule 12.
Yes. Okay. Now, I've been telling other candidates who are coming here that as JP, I want this commission to recommend candidates who will hit the ground running,
Yes,
who will not be a burden to other judges. That is, who will make me think twice before I allocate work to them. You understand what I'm trying to say? And I've articulated it as follows, loose language. Need hard workers, someone who's a proven hard worker, someone who is technically competent in terms of the work we have to do, and someone who's conceptually up to standard. You've been busy talking to us this afternoon about Soweto, the law, the Africanization
Yes.
of the law, but someone who's there, conceptual level should be at the right place. You can't be given a matter in one area of the law and you start applying wrong tests. If you understand what I mean.
I fully
So-
sorry about that.
So the GCB has made comments against you. You're aware of those comments.
I saw the comments.
And I just want you, and I don't want you to tell a story because I see
No, I won't.
you get carried away.
Yes,
Don't.
all right. No, I got carried away because of Soweto. I'm sorry about that.
Yeah, they say if we as a commission think it's not necessary to strive for the highest standards, that's the message we will be sending if we recommend you for appointment. You've seen that.
No, I saw that.
And they base their criticism on how you handled a number of cases. And one of them is where they say you applied an incorrect test in a leave to appeal application. You saw that.
Yes.
So it's a three-pronged question. Is there validity in this criticism? Looking at how you've performed as an acting judge and your practice of more than 20 years, lecturing as well, do you think you have what it takes to be permanent in the division? And do you think we should recommend you?
JP, let me start with the first criticism of applying the wrong test. Indeed, that's true. But it was, if you remember, I started acting before I even went for sergeant training, because it was during the days of COVID. In fact, I felt that we were guinea pigs because it was dangerous during those days. But then subsequent to that, I went for the sergeant training. And if you look at my leave to appeal now, I think I sent the latest one. It captures the law. Your section 17, 1A, Roman figure I, the appeal would instead of might. It captures that, and it talks about the cases which are around that, like your Tina Hussein case. So I have definitely improved.
Okay.
Hence I did not even include it in my pack. Because even the other
You
criticism.
did not include the case they're commenting on.
Yes, all the cases they're commenting on are not included in my pack. They're actually my very first case.
Okay.
All right.
What's your response to the other points I made in the same statement?
I am ready, JP. I am a hard worker, that you can see. I've not had a reserved judgment. If you look at all my judgments are delivered within less than 2 months at times. And I'm always working hard. So I don't know why I wouldn't feel that I'm ready for this job.
Yeah.
Yes.
You've handed down some, I think I've listed the number, 47 judgments in total. That's what the list tells me.
All right.
Now, it doesn't appear that in any of those matters you took an unduly long time to hand down those judgments. There may be one or two where you took more than 3 months.
No, there's none.
There's none.
There's none. I wouldn't do that because if there's one thing that lecturing teaches you is to discipline yourself.
Yes.
And work hard. That's one quality I have, JP, hard work.
So you admit the comment regarding that application for leave to appeal?
Precisely.
Wrong application of the test.
100%.
That one you admit, but
That
you
one
say
I admit.
That was early days.
100%. You can look at it. It was actually a leave to appeal the matter that they comment on. It was an application for liquidation. And the question there was the Baden Horse principle. I thought that the dispute was, the indebtedness was disputed on reasonable and on bona fide and reasonable grounds. That was the conclusion I came up with.
Yeah.
But obviously, the litigants thought otherwise. But I can say there was no prejudice to the litigants because I granted them leave to appeal.
Yeah.
And the matter was appealed successfully.
Okay. Thank you very much. And I must commend you for the work you've done in Soweto, the establishment of the Small Claims Court that's bringing access to justice to the people there, and your continued involvement with that project. And I mean, by keeping your practice in the township, it speaks volumes. We all want to gravitate to the urban areas.
No, I don't.
Yeah. But anyway, thank you, DCJ. I've got no further questions.
Thank you, JP. MEC, you covered.
Yeah, I'm okay, thanks.
Do you have questions, commissioners? Commissioner Malem?
Thank you very much, DCJ. I'm really covered, and I like the passion about the Africanization of the law, and that there should be the High Court in Soweto, and that the JP actually clarified that it is not correct that there is no land in Soweto for such a development. I just want to pick up your brain on customary law, especially that you speak very passionately, and I accept the responsibility as well. That we'll have a law passed by us now and not give it an African name, not even the law in content, just a name, a simple thing as a name. We had failed to do that from 1994 until now, to just name a law using an African language. So I'm happy that the speaker is here and can hear a speaker. Since 1994, a law, just to name it with the African name. Not content, just a name. We haven't done that. So I accept that, but your take on the customary law, what do you think of
it? Commissioner Malema, there's two things. Yes, customary law is important, but it's mostly located, you must distinguish between what I said and customary law. Mostly it's located in the rural areas, and we do practice customary law in the township. When we pay for malobola, when you stabisa mahadi, all those things. But here, I'm talking more substantive matters, more than customary law, because they like to relegate everything to customary law that is black. No, we are bigger than that. Like the example I'm talking to you about, Ehopi, it's not customary law. It's someone who has umhopolo, who wants everything to himself. Why can't you take that person on review on that basis? And a black person will be better positioned to argue that point. And you'll be able to employ a black counsel to argue that point better than a white counsel. Because now the system favors white people, we have to be honest. Now, if I'm going to argue bias, it's a difficult concept as a black person to appreciate. But if I'm going to argue Ihopi, umhopolo, it's closer to me. I know what umhopolo is all about. It includes bias, it includes jealousy, it includes a lot of concepts, but you find it in the township. And when I say in the township, especially, so it's representative of, it's a microcosm of South Africa, man.
No, thank you very much, DCJ. Even customary law is not given African name, yet it's for us black people.
Yeah, that was a nice parting shot, Commissioner Malem.
Follow up, DCJ.
Oh, sorry. Prof, is that you?
Yes, it's me. I just want to follow up on this point.
Ask your follow-up question.
No, thank you. Good afternoon, Advocate.
I'm an attorney, or
good
better, a
afternoon. How
legal
are you?
practitioner.
Oh, yeah. I just wanted to follow up on the issue that was raised by Commissioner Malema.
Yes.
No, not Commissioner. Your answer to the question that Commissioner Malema asked in relation to the race of the person who should do a particular matter. I just want to know if we achieve that and say perhaps maybe a black candidate or a black practitioner can be able to argue a customary law matter a little bit more efficiently. Will we not be creating a challenge where we will be met with resistance on other areas of law, where somebody can equally come and say, but we need to make sure that we employ white lawyers to actually argue issues such as tax and competition law, and then they will make reference to the fact that already black counsel are arguing customary law matters. Would we not be creating a bigger problem while we are trying to solve this important problem? Thank you very much.
Thanks for that question, Commissioner. It makes me laugh because the problem already exists. The white advocates are the ones who are arguing these matters. Black advocates are not arguing any matter. So what problem are you trying to solve? I mean, I can tell you now, from what I've seen, most of the junior counsel that are briefed are our kids who've gone to white schools. Advocates who are coming from the township will never get briefs or be juniors to big matters. So I don't think you'll be solving a problem if you don't acknowledge that there's a problem. Firstly, you must acknowledge that, you see, I'm not much of a horticulturalist, but if you have a flower planted in a garden and it doesn't grow, you don't blame the flower. You blame the soil, the garden. That's where the problem is. Our garden is not proper. So it's a combination of things. It's not just customary law being argued by specific people, but also location. If you're going to locate a court in Soweto, for instance, you're going to have a Soweto GCB. That GCB will immediately be populated by our people. We'll also empower, with knowledge now, proper knowledge, our people. So I don't understand the question, and I don't think it comes from the correct premises. I'm not saying white people don't have a role to play. Please don't misunderstand me. But I'm saying we are left far behind as black people. We are forced to live to a standard that's not ours. That's not right. We must meet each other halfway.
The candidate has finished answering your question. Do you have another one?
No,
It
no,
was a follow-up.
I'm-
No, it was a follow-up.
It was a follow-up, yes.
Yeah.
Thank you, DCJ.
Okay. Any, oh, it was your turn, Commissioner Nyambi.
Thank you, TCJ. Afternoon, Mr. Mota.
Afternoon, Commissioner Nyambe.
No, let me join also and commend you for having your practice in a township. That's where the historically disadvantaged people are staying in a meaningful percentage, as you have outlined it. JP has asked you about the GCP comment. I'll ask you only one question. Is the one of Nadel in response to the JSC questionnaire?
Yes.
Where you said a sweet victory won on technicality, where 2 accused were caught and handed with 1 million and worth of counterfeit money.
Yes.
They are saying the response creates the impression that the candidate views the law as something that can and should be manipulated, not as a means of justice. So your comment on that?
I just want to juxtapose both the GCB's comment and LSSA's comment. GCB says, I write badly. LSSA says, my judgments are, what's the language? Erudite. Meaning, I was shocked. I never thought my judgments were erudite. But yes, that's not number one. Now, with as far as the sweet victory, I think it's a complete misunderstanding. And it must be understood in this context. As I've already explained, I grew up in the township, my practice is in the township. The 2 accused I was representing were people I grew up with. In fact, accused number 2 stayed 3 houses from my house. His father was a pastor, a prophet known in the area. Their case was the talk of the town, talk of the street. I was 1 year in practice when this happened. The court of public opinion had already ruled us out. We were as good as dead. And during those days, unfortunately, I will have to take you back. During those days, it was just at the end of apartheid. So you know the rural areas were mostly populated by what we used to call volgramte magistrates. And this was in Port Gietersrus. It was guaranteed we're not coming back. And the weight on my shoulders was not light. And they said because of money, I think there's that comment that because of money I would sell my soul or something like that. But there was no money there. The reason why they picked on me is because they didn't have money. So I was not making money. So when we won that case, in fact, let me just add this. On our first appearance, the magistrate in court called me and said, "Is Jia Procuria, proof that you are a lawyer." And we had 2 lawyers. The other one was not asked. I was asked because I was from Soweto and obviously because also I was young. Now that you are asked in front of the accused, what confidence would they have? In fact, up to this very day, we talk about that case. So when we won the case, I still believe we won it on prayers. When we won the case, it was celebration. That case built me. That's why I think about it. That case brought a lot of cases to my office because the people in the township started saying, yeah, no, this guy, he can handle criminal cases. No, we don't have to go and brief so and so. No, we can try him out. So that's why that case was important to me and I mentioned it. Not because I was taking first one on the law, or I was trying to be smart. No, I know too well about that.
No, thanks for clarifying it, and context is everything. I hope Nadel is listening and it's more than clarified. Thank you. Thank you, DCJ.
Thank you, Commissioner Nyambi. Any more questions?
Yes, I
colleagues?
do want to
Commissioner
ask,
Nyambi?
I think Commissioner Pillay was probably ahead of me. All right, thank
Okay.
you. Yes. Good afternoon, Judge, actually. I appeared before you 2 weeks ago. So I called you Judge then. I think I should continue calling you Judge.
I had hoped we wouldn't talk today.
No, what I'm worried about is to make sure that you don't say one thing and do the other.
Yes.
You don't come here and say to us, I'm all for black people, but your judgments reflect something else. So I want to take you to 2 of those judgments.
Yes.
So let's start with the judgment of Stotch.
Oh, Stotch, yes.
Yeah, which is an August 2022 judgment. And at paragraph 35 of that judgment, this is a statement that got me worried.
On what page?
At page 73 or page 70. 73 at the bottom, 70 at the top.
70 at the
Yeah, and it's
bottom.
paragraph 35 of the judgment.
Yes.
Yes, and these 2 lines towards the bottom of that paragraph where you say, if pi does not apply to an eviction from a cottage used for holiday purposes, it certainly cannot apply to an eviction from a holiday home's garage. Now, I don't understand the statement, what it means, because if a person is in a garage that is located in a holiday home, and ordinarily those would be black people, but you would then deny them the protections of pi. Can you explain yourself?
Context is everything again. This was not that kind of a case. We're dealing with multi-billionaires. In fact, if you read the judgment. So the garage was not about occupying it. It was parking cars.
Yes. No, I'm talking about the general statement.
Well, generally, yes, I agree with you. I will agree with, but this was area-specific, context-driven.
Yes, no, that's the point I'm making, is that when you make a statement like this in a judgment, which says, if pi does not apply to an eviction from a cottage used for holiday purposes, it certainly cannot apply to an eviction from a holiday home's garage. So you're saying that the statement should not be read generally, it should be read narrowly.
It says, yes, I agree with that.
Yes.
But it's also, there's a qualification there that says holiday home garage.
Yes, no, I understand that.
Yes.
But my problem with it is that the statement is phrased in a very generic way that impacts on black people who can use a garage, whether on a temporary basis or on a semi-temporary basis. But that's really the concern, is whether or not the phrase could have been formulated narrowly.
I take the criticism.
Now, let's go to another judgment that also worries me about your statements that you are for black people, but when you look at your judgments, I get worried. It's the Motibe and Seleka judgment.
Yes.
Now, this is where
That's on page?
The page is 90 at the top, 93 at the bottom. Now, this is where you declared a black person a delinquent director.
Yes.
And the basis for that declaration is set out at paragraph 42, where you say, you first set out the test in Giwala.
Yes.
And then when you apply it, you say in paragraph 42, in Kasu, the first respondent failed to utilize his position as a director for the benefit of the company. He did not have regard to his fiduciary duties by offering a salary of 66,000 rands to the 5th respondent without any resolution and agreement between the members of the board. Now, my own sense was that it's a pretty radical order to declare a person. And here you don't apply any compassion, any Ubuntu, nothing. In fact, you just apply the statute And then the way you apply it seems to be pretty radical for a declaration of delinquency. And the reasoning that you give seems to be very, very thin. So I've got two concerns with this judgment. One is your professed protection of black people under the law is not reflected in your judgments. In fact, your judgments show a level of conservatism. And secondly, it's quite drastic what you did here. So I want to put those to you and then get your comment.
I think, Commissioner, you're completely wrong.
Yes.
If you read the entire judgment, it's
Yes.
a black woman who is
Yes.
being disadvantaged by a black male in this case.
Yes.
In fact, the application was brought by a black woman.
Yes.
If you read what he had done,
Yes.
I'll just mention the facts.
Yes.
This was an
Well,
opportunity
there is-
given. This was an opportunity given to black people to run a multi-millionaire business, and what he did, he shouldered the black woman because it was given understand that both of them should run the business.
Yes.
He shouldered the black woman and employed another man
Yes.
without consulting, without any form of board meeting, and offered that person 66,000, and they started to be in cahoot,
Yes.
fighting to make sure that they kicked out this lady. So if you read the judgment, that's not just I think if you take that one out of context, it will give a wrong impression.
Yes. All right. So
But
again,
if you read all of it, you'll realize there's a lot. I can read from the judgment some of the things that he did, which will also worry you.
Yes. No, I think the only principal point I'm making to you is this. The professed statements that every time you approach a case, you do it from the perspective of protecting black people. I just don't see it in any of the judgments you've written.
I never said that.
Oh, I see.
I never said that.
No, then it was
No, no,
entirely
no.
my error.
I never said that. It's not my modus operandi to protect black people. And you must understand, Commissioner Ngwaitu, I'm not putting a show. That's who I am. I love my people.
Yes.
I live with my people.
Yes.
I have two houses in Soweto. So it's not a show.
Yes, no,
That's
then I
who I am.
misunderstood your statement because I just wanted to go
No,
through
you misunderstood me.
Yes, I wanted to go through the judgments to see where exactly in practice have you protected these black people. And it seems that actually what you've done, you've just applied the law like any ordinary judge would do in any circumstances. And that's
Yes.
not a criticism.
Thank
That's
you.
just to, yeah. Then the other thing I wanted to ask you, and it's a point you didn't debate fully with Commissioner Malema, and because you said you are not talking about customary law, but I want to talk about customary law.
Okay.
Yes. To understand your grasp of customary law. Yes. Now, I've made an example to several candidates that have come before us, which is where there is a contested rule of custom, how does a judge resolve the contested rule of custom?
Yeah, where the-
Under Alexco and Maelane.
Yeah, I think there's another case, Mamitwa, which looks at the contested rule of custom. If you can look at that case, it captures nicely that you look at the development also of custom, and it must always comply with the Constitution. Your development of custom must always, thanks.
We were actually warned that this would happen. It's going to take about 5 minutes to resolve. So let's wait a little bit. Hold your thought, Mr. Moja. colleagues, the power situation has been resolved. Let's continue. We were waiting for you. All right. Do you want the question to be repeated, or you remember what you are about to say?
I remember
Yes,
the
you,
question. I was,
I mean, I do want to, because it's going to be long the way you started. Let's forget about the Constitution. The Constitution is not implicated.
yes.
I'm
yes.
just debating how you resolve a contested rule of custom.
I mentioned the matter of Mamitwa.
Yes.
Where you had a chief being put forward who happened to be female. But I can't remember it properly now. I
No,
had,
that's fine. Let's forget about the cases then. That was my mistake. Just give me the steps you would follow as a judge to resolve a contested rule of custom.
I've drawn a blank and I have it in my book.
No problem.
Yes.
Thank you, Decision.
Anyone else, colleagues? Or Commissioner Pillay and
Thank you, DCJ. Good afternoon.
Afternoon.
May I ask you to look at page 132? 132 of the bundle. I just want to ask you one question around your Unitrans judgment.
Yes. 132.
Yeah, the bottom 132, Mr. Motta.
Yes, I'm there.
If I can then, in this judgment, what you did is you had to consider whether or not to grant a final interdict. Do you recall that?
Yes.
And if you look at page 147, which is where you then start dealing with whether or not you should grant the final interdict.
Yes.
At paragraph 47, Mr. Motta, you say, it is tried that a final interdict may be granted on application if no bona fide dispute of fact exists.
Yes.
Is that a correct statement of the law?
The
And
point,
you reference Plascon Evans for that?
I was referencing to Plascon Evans for that.
Yes.
To say you can only grant a final interdict where there is no dispute of fact. I should have said, yes, there's no bona fide dispute of fact. And now,
And is that your understanding of the Plascon Evans principle?
my understanding of Plascon Evans principle is this. A final order, not an interim order, a final order may be granted, or final interdict may be granted where there is a dispute of fact. That is where there is a dispute of fact in motion proceedings. If the facts as stated by the respondent, together with the admitted facts contained in the applicant's affidavit, justify that order. Put differently, facts averred by the applicant with admitted facts by the respondent, together with facts of the respondent, should justify that order. Sometimes facts are not admitted but cannot be denied. So they would be taken as admitted if they're not. I'm not sure if you're with me.
I'm struggling to follow your formulation of Plascon Evans. Let me just ask you this, and we'll get back to Plascon
Okay.
Evans. At 47, you're referencing Plascon Evans to lay down your approach to the
Yes.
question of disputes of fact.
Yes.
I'm asking whether it's reflected correctly in your judgment. And I must just say you've kind of mangled the Plascon Evans test in how you've
Can I
recited
give
it
it
now.
a go again, the Plascon Evans test? Because
Perhaps start with your judgment. Let's start there.
okay, let's start with the judgment.
Yes.
It is tried that final interdict may be granted on application if there are no dispute of facts.
Yes.
That's what I understand the law to be.
So in other words, what you're saying is that Plascon Evans doesn't apply to final interdicts?
No, it applies. Remember, if there are dispute of facts, the instrument that you use to decide on the dispute of facts, it's the Plascon Evans, all right? Because you make your judgment on common cause facts. So how do you arrive at common cause fact? By looking at Plascon Evans. You look at the statement of the applicant, as stated by the applicant, together with the admitted facts by the respondent, okay? And if they justify that particular ruling, then you make that ruling. And you have your Whittigan case, Whiteman case, which says sometimes a dispute is not bona fide. It must be, sometimes the dispute is not bona fide, it's just manufactured. And that's why you must sometimes use what they call a robust approach. That is your Sofiantini judgment. So that's my understanding of Plascon Evans.
Thank you. Thank you, DCJ.
Thanks. Good afternoon, Mr. Mota.
Afternoon.
Well, we spoke earlier, so I have greeted you really. We can speak outside because I don't think the DCJ will allow me to go further on the issue, but we can speak outside about the problems that the Department of Justice has in acquiring land in Soweto to build a court. But I just wanted to make the comment, that to thank you for your contribution and your role in the small claims court, particularly the one in Soweto. To say, you don't have to answer this, that I hope that if you are successful and get appointed as a judge, that you will continue as a small claims court commissioner. You will not be the first judge who does that, and it's good that your JP, if you are appointed, seems to be supporting you continuing with that work. So I just wanted to put that, to make that comment. Thank you.
Thank you.
Any questions from the virtual platform? No.
Seems now. And DCJ?
None.
None, TCJ. Are we still here, Commissioner Dodovo?
I'm happy about that.
Two last questions from AP Betsy.
Good afternoon, Mr. Mota.
Afternoon, Commissioner.
You are seized with an appeal against sentence by an accused person. Under what circumstances would intervention by the appellate court in the sentence imposed by the trial court be warranted?
Yes. Every time when you sit as an appellate judge, you need to understand what form of discretion you are dealing with. Is it a narrow form of discretion or a loose form of discretion? This you'd find in Trenco judgment. I think it's Kampempe. Now, when you're dealing with the sentence, you're dealing with a true sense of discretion, because the trier of facts had the advantage of choosing from equally competent judgments or sentences and chose one. You have no business in interfering with that decision unless you can prove that there was misdirection which vitiates the sentence, or it's so gross that no reasonable court would have arrived at that decision.
Thank you. The second question, which takes you out of the realm of customary law, has to do with common law. We are conducting a civil trial concerning a delictual claim. and the only element which is put in issue is negligence. And for purposes of liability, what test would you then apply in order to
That's
determine?
your Kruger versus Gutier 1966 judgment of Holmes. You look at the, I'm sure you'd say these people have been watching, but as a lecturer, I should know this because my students are watching. So it's the diligence pater familia test, the father of the family. He puts himself in a position of a defendant and say, would have foreseen his conduct causing harm to a person or his property, which resulted in patrimonial loss, and would have guard or taken steps to guard against that harm. And in this case, the defendant failed. So that's the test that you use.
Thank you, Mr. Mota. Your students would be impressed.
I hope so.
I take it that there are no further questions, colleagues. There are not. Well, this is the end of your interview, Mr. Mota. Thank you so much for your
Much
time.
appreciated. Thank you.
All the best. You're excused.
Thanks.
Give me just one moment, Mr. Manyati.
Thank you.
Good afternoon.
Afternoon.
Are you well?
Yes, I'm well.
Good, good. I'm fine too, even if you did not ask.
Thank you, DCJ.
You went to Forte and Wits.
Yes.
Which degrees did you obtain from these fine institutions?
Forte, B Juris and LLB. Then at WITS, higher diploma in company law. Although I didn't include it in my CV, I also done the LAM in labor law with UJ, but I finished the coursework. I passed the coursework. I was busy with the dissertation of sexual harassment at employment, but due to family problems, I couldn't finalize my dissertation.
Well done. I always admire people who study while working. I don't know where you find the time, but, well, my hat's off to you.
Yeah.
You stayed on at Forte as a lecturer for 3 years.
Yes, DCJ.
Which subjects did you teach?
Private law and interpretations of statutes. Private law one, at the time, they had a branch in Bishop for adult after hours. So I also done teaching private law 2 and commercial law in that particular place.
All right. But then you left teaching. You left the noble cause. Why did you leave?
At the time, I was still young. I felt that was boring for me. And I wanted just to be an advocate. That's what I wanted to do.
All right. And you became a prosecutor?
Yes, I started at some stage as an interpreter, district court prosecutor, then original.
You started out as an interpreter, then you became a prosecutor, then you rose to the ranks of the magistracy.
Yes, yes, this is it.
Well, that's the route I followed as well. All right, so you remained a prosecutor for 3 years and then became a magistrate, a district magistrate.
Yes, this is it.
But soon became a regional magistrate, which you still are.
Yes,
And have been for 22 years now?
Yes, for 22 years as a regional magistrate, altogether 26 years as a magistrate.
All right. You have acted as a judge?
Yes.
Where, how long?
In Gauteng, since 2016 up to now.
And since 2016, you say?
Yes, since 2016.
What has taken you so long to apply for permanent appointment?
I thought that I needed to be more equipped and to learn more instead of rushing, so that I can be able to understand everything. And when I'm ready, then it's now that I feel that I'm ready to apply, because at the time I felt that I'm not yet ready to do that.
Well, that's a good enough answer for me. All right. I'm going to hand you over to JP Mlambo.
Thank you.
To quiz you. JP Mlambo.
Good afternoon, Mr. Minyati.
Good afternoon, JP.
And I also want to thank you for availing yourself for this interview and for being available to act in the division.
Thank you.
When I was looking for people. Now according to the allocations, you've acted for a total of 63 weeks in Gauteng.
Yes.
And 49 of those have been in the criminal trial courts, am I correct?
That's correct, JP.
Yeah. That's, in a sense, reflective of where you've spent most of your professional life as a judicial officer in the criminal trial courts, am I correct?
Yes, although at some stage I was doing the civil in regional.
Yes.
Yeah. Especially because I'm stationed in Captain Park.
Yeah, try and speak closer to the mic.
I'm stationed in Captain Park, and at the time we had only one a regional magistrate that was dealing with civil. Now she was doing Captain Park. She does also Springs, I think Springs and Brakpan together, and Heidelberg.
Yes.
So most of the time she's not at the office. So on the days that she's not there, I will actually do any civil matters that appears. I will also help her with issues of divorces divorce role when she's not there.
Yeah. You may not want to answer this, but you know, in the high courts, we sit with the problem that the civil work that must be done in the regional courts comes to the high court. We've done all we can, I know, in Gauteng, to dissuade lawyers not to bring that work to us. And they complain that they don't get justice in the regional courts when they take their civil work there. You've acted in the high court, you've done some civil work in the high court, and you are aware that most of that civil work belongs in the regional court. Am I wrong?
You're right, JP.
What should we do? Because to me, it tells me that the conscious decision made to make sure that instead of going for costly litigation in the high court, it should be done in the regional court, but it's not happening.
I think there's something more that must be done, JP, in order to do that, because we actually in Captain Park we are getting a lot of civil matters, as I've said, and I don't know other clusters, but we try by all means. As I've said, we've got only one. That's why I must sometimes help, but I cannot be able to say at this particular stage what might be the reasons why they feel like that particular way.
I'm not blaming you. I hope you're not understanding it as I'm blaming you. We need help to see what we can do to make sure things run properly. That's why I'm raising it with you, because you are involved in that court level. You know?
Yeah, I think, as I've said, JP, I think more must be done in order to be able to help, especially people who are appearing there. Most of them are people from the locations, Tembisa and all those particular people. And at least if that can be, something must be done to encourage them so that their cases can be finalized as quickly as possible.
Yeah.
And actually to help those people that does not have money to come to the high court where the costs are involved at an end. But I think they're not as, if we can actually develop that particular area, I think that will actually help a very good way.
Now, you've done some civil work in the High Court. I see you've also done a week in the Agent Court.
Yes.
Was this during recess?
No.
It was during, who was your partner in crime when you did the Agent Court?
That was Judge Malindi.
Judge Malindi, oh, okay. So that was during term. And you've not done special motions, even though you've done, I think, it shows me that you've done 2 weeks of opposed motions.
Yes, I've done 2 weeks, one in Pretoria, one in Johannesburg.
Yeah. How long did it take you to finalize the reserve judgments that you accumulated in the opposed motion courts?
I've actually done most of them in 3 months, before the end of the 3 months.
Yeah.
There was, I think, 1 or 2 that there was a cycle. I finished them within time, but they were delivered late because the secretary that was helping me in Pretoria, especially in Pretoria, I don't know what is the problem. Apparently he resigned or his contract ended, and without actually handing those particular judgments to, but they were written in time.
Yes.
And I finalized them within 3 months' time.
Yeah. Now, as is clear from the spreadsheet, you haven't done work in the full court appeal area. You've done work in the full bench area, am I correct? Where it's a magistrate's judgment, that's on appeal.
In criminal?
Yeah.
No,
in civil. In criminal, yes, you would have said in a full court, am I correct?
I've said both in civil, full court in civil as well as criminal.
Yeah.
And I've penned those 2 judgments.
Right. What was your bench in the civil one?
That was Judge Sadwala and Judge Davis.
Davis, the Pretoria judges?
The Pretoria judges.
Okay. And then in the criminal one?
That was Judge Spilch, as well as acting Judge Ngube.
I see. But you penned those two judgments?
Yes, I penned those
Okay.
two judgments.
That's good.
I
And
think
then-
the one of, I think the appeal one, the criminal one, I had to read about 12,000 pages of that particular judgment.
Yeah. Now, what I've said to the other candidates, you would have seen it if you guys are watching in the holding room, that I would like to see this commission recommend candidates who will not be a burden, even though they are there, but won't be a burden to other judges. That is, if I say I want to give you a special motion, I don't have to think twice. I don't say, I can't give it to him because no judgment will come out, or judgment will take 2 years. You understand? Because I do have instances where the parties will look at the duty roster and see who's there, and they'll write to me and say, look, we provide this evidence why we don't want this judge to hear this matter, because judgments never come out. That's what causes me to say the pool that I must use of people who must do the heavy work has continued to shrink, and I want people who will help me in that regard. You understand that part?
Yes, I do understand.
Yeah. Now, I'm saying this to you to say, I would like the commission to make sure that the technical competence of recommended candidates is at the correct level to do the work in the division. Obviously, these must be people who are hardworking. You've been in the division, you know the volumes we deal with. You've just mentioned 12,000 pages,
Yes.
which is one appeal. And your conceptual grasp of the issues you're dealing with needs to be at the right level. You understand that?
Yes, I do understand, Jacob.
Right. Now, what is your comment to what the bar is saying about your candidature for permanent appointment, the GCB? Have you seen it?
Which one is it?
I think they are saying effectively that your strength seems to be more in the criminal law arena, and that you may need more time in the civil law arena.
I don't blame them, JP, because I think they had only the application without the spreadsheet of the cases that I've done.
Yes.
And if you notice, some of the appeals, I've written them, some of the judgments in civil, I started somewhere in 2017.
Yeah.
What used to happen is that in a term, I will finalize my criminal appeals before the term ends, and I will have about 6-7 days that I don't have any work after I've done a look to other criminal judges in respect to help them with the petitions. I will go for a roll call, where they will give me a 2-day or 3-day, especially unlawful arrest, as well as ref matters.
Yeah.
So I will do those particular things until I've been doing that since 2016, because if you can check, I've been finishing my role before the end of term. Then I will go for civil court roll call in order to get some work, civil work to do. Although, as I've said, on a little bit scale of 2 days trials for unlawful arrest. From that time up to now, I think I've done almost 10 or 12 of those particular judgments.
No, in fact, I want to confirm to the commission that you are one of those acting judges that when your criminal trials collapse, you go to the DJP to say, I'm available, I need work. Because you know he's always looking for people to help.
Thank you.
You always do that, I know that.
I always
Right.
do that.
If you look at paragraph 6.1.1 of the GCB comments, the bar criticizes you as to how you resolved or approached the issue of locus standi.
Yes.
Do you have it there? Have you read it?
Which case? The case of?
It's the case of tenants of Waterford Court and two
Okay.
others. Yeah, you saw that.
I've saw that.
You are aware of what they're saying.
I'm aware of what they're saying.
What's your response to that criticism? Is it well-founded, or is it unfair, or you don't agree with it?
I don't agree with it. It's unfair. In that particular matter, as I've said, I've found that the matter was not urgent.
Yes.
Based on the fact, firstly, that they received the notice of the termination in February.
Yeah.
And the application was done, all the other things were done, but the application was actually done somewhere in October. Secondly, I found that on the basis of lack of local standing,
Yeah.
because the applicants were not actually the owners of that particular building, neither were anything that shows that they were related to anything to that particular. To me, it appears like as if people would just group and enter the building, and they were owing the municipality plus minus 2.5 million on services.
Yeah.
So,
So you don't agree
again,
with
I
the
don't
criticism?
agree with them. That matter, at some stage when I checked, the same attorneys, they brought it back to one of the senior judges, and on the same facts, the senior judge again gave the same judgment that I gave, the same. So that's why I say I don't even agree with what
I
they
see.
said.
Okay. So you regard yourself as eminently ready to be recommended for permanent appointment?
Yes, JP, I think as I've said, as the Deputy Judge, Chief Justice said, I've waited a long time, and I've done because I wanted to equip myself with almost all the areas that are available.
Yes.
I'm accustomed to what is happening in the division. It's very busy. I've become accustomed to the fact that as a judge, you don't go to bed at 9 o'clock. You don't have weekends. You don't have public holidays.
Yes.
So your book becomes a library because you have any time that you have to read. So I know how the division is so busy.
Thank you. Thank you, DCJ.
Thank you, JP. MEC, do you have any questions for this candidate?
Thank you very much, and good afternoon to you.
Afternoon.
My questions would have really been around the criticism that the JP has spoken to, but I think you have dealt with that quite adequately. Although I would have just wished one comment on, what will you consider to be your contribution broadly to the body of knowledge in the legal profession, based on this, observation or criticism that you're more in the criminal law space, but broadly, while I take the points you've made, but what you do say you have contributed to particularly research, contributing new things to the development of the law and all that.
Thank you very much, Commissioner. As I've said, that I believe that as a judge, you must be able to know all the law, parts of the law, civil and criminal. And it is also a fact that none of the judges that knows 100% civil and 100% criminal. Each judge has got their own strength. I'm of the view that although I actually have more strengths on criminal, I've done a lot of also civil matters. As you see, I think one of the bundle, the senior judges, they trusted me with an appeal, and I penned that particular judgment, which they were very much happy. They sent comment that they were satisfied with the job. So I feel that I actually do the research. I read my spare time about things that I needed to do and to read in respect of other fields that I haven't done because I've not received any case that relates to those particular issues.
I can leave it here, thanks.
Yes, dear.
Thanks. Good afternoon, Mr. Manyati.
Good afternoon, Commissioner.
I'm going to be asking you, look, I'm only allowed to really ask you one question, so I'll try and put it all in. But it's about the State versus Christo Smith judgment.
Yes.
Where you overturned a sentence, the Accused raped. The accused was the boyfriend of a young girl who was 13 years old. The accused was 39.
Yes.
And he raped her. The rape was upheld, and the issue is the sentence. And as you know, the legislature has set a minimum sentence for child rape.
Yes.
That is the intention of Parliament. These cases are serious, and therefore the minimum sentence for rape of a child is life sentence. You, however, say, no, I'm of the view that life sentences should be used sparingly and for very serious rapes.
Yes.
You do say things which are in the judgment about, you're meant to find, and I'm going to be asking you, what are the substantial and compelling circumstances? What I can find from your judgment is that the rape happened at the spur of the moment. The victim did not sustain any injuries. She's responded well to trauma counseling. You also then say, no, because the complainant and the appellant stayed under the same roof for a period of 8 months when the incident took place, because the accused was the boyfriend of the victim's mother. You say, therefore one will approach this matter as rape by a family member. I note in your judgment, you did quote a number of cases. You did not quote State versus Machichi, which is a 2011 case, which is a more recent judgment than any of the judgments you quote, where it says Parliament had ordained minimum sentences for certain specified offences, and these were to be imposed unless were truly convincing reasons for departing from them. Courts were not free to subvert the will of the legislature by resorting to vague, ill-defined concepts such as relative youthfulness or other equally vague and ill-founded hypotheses that appear to fit the particular sentencing officer's notions of fairness. Predictable outcomes, not outcomes based on individual whim, were foundational to the rule of law. So look, I just want to give you a chance to respond. I find your judgment induces a sense of shock for me. This is the rape of a child. Parliament has said substantial and compelling circumstances not to impose a life sentence. Please tell us what those are. And tell us if you regard the rape of a child by a 13-year-old girl, by a 39-year-old man. Is that not a slightly very serious offence?
Thank you, Commissioner.
You gave 12 years.
Yes. At the start, I want just to express that a rape is a very serious offence. No one can argue in the contrary that rape is not a serious offence. I think the legislature, the manifest purpose of the legislature is to make sure that a serious sentences are being passed for such particular issues. But on the same time, when you look at the Minimum Sentence Act, it also gives a discretion to the judicial officer in terms of Section 51, subsection 3, as to state what are the substantial and compelling factors to deviate from the prescribed minimum sentence. You read the cases of Mahamudzi, 2012, where the retired judge, I think, I'll remember just now. But when you look at those particular cases, State versus Mahamudzi, State versus Vilagazi, State versus Abrahams, and all those particular things. But as early as 2002, the judges started to understand and try to give a guidance as to what is meant by substantial and compelling factors for the court, especially in respect of the minimum sentence. Judge Cameron and the others, when you look at those particular cases, it states that the courts are not supposed to slavishly adhere to the minimum sentence. The manner in which the offense is committed, the factors, how is it committed, those particular issues must be taken into account. As I've said, that the fact, it might give the impression as to the quote that you give that I'm saying, because it's a family member, then it's different. When you go deep, a little bit down in that particular thing, I said it makes no difference whether it's a family member or not. Rape is rape. Mahmoud says that other rapes are more serious than other, are totally different. Now, I think the legislature, because our duty is to make sure that we interpret laws, we don't make laws. Now, clearly, when you look at the fact, the manner in which the rape took place, to me, it also formed one of the substantial and compelling factors. Now, in this particular matter, it was not a planned one, and secondly, there was no violence that was used. And when you look at the minimum sentence, the issue here is that the problem that we're having is that he was actually charged with the extended definition of rape. That was not the traditional rape that we know. The issue there, the facts, is that a tongue was used. I'm not saying that it's not rape. Don't anybody take me as if it's not a rape. Rape is rape. What I'm saying is, it depends on the manner in which rape has been committed. That will determine as to whether the life sentence must be imposed or not imposed. So, as I'm saying, when you look at those particular factors, the response, the report that I got into this particular child, she was traumatized, I understand that. I will not sit as a judge and a presiding officer and pretend to know how does a woman feels when after being raped. The fact is that rape is rape, and a certain minimum sentence is actually prescribed, but we cannot slavishly adhere to that. There are certain factors that the court has to look in order to. I felt that the life sentence was too much it was disproportionate to the facts of the matter. Hence, I arrive at the issue of 12 years imprisonment.
Thanks. Well, so you're saying the substantial and compelling reasons were that the rape wasn't planned. You're saying the substantial and compelling reasons were that there was no violence, which probably is a bit difficult for a 13-year-old girl against a 39-year-old man who she knows who's her mother's boyfriend. I mean, with respect, Mr. Manyati, and then also, as I said, why didn't you look at Machichi, which is a SCA case more recent, 2011, than the ones you were quoting in your judgment?
As I've said,
so basically, I have to say I'm quite horrified by your judgment and your approach to the issue of rape.
Commissioner, sorry, just to add to that, when you look at the recent case of State De Beer versus the state, in that particular matter, it's a Supreme Court of Appeal decision. In that particular matter, the stepfather actually abused the 8-year child for a period of almost 8 months. And the High Court, after the magistrate court gave her 15 years, of which 5 years is total suspended. The High Court increased it to life sentence. The SCA was of the view that that was too harsh, and they actually dismissed or set aside the life sentence. So what I'm trying to say is that I actually read the latest that I have, especially De Beer's case. It's, I think 2014, if my memory serves me well, it's a 2014.
Okay, but you don't quote De Beer, so we'll have to look it up. But it's interesting that you're referring to De Beer now, but it's not in your judgment. Just a note on that.
Just a follow-up, CJ.
Follow-up.
No, it's just a quick one. I'm just following up to the minister. Deputy, I'm not too sure whether you get the Deputy Minister, and I don't believe you understand the Deputy Minister, the Commission. It seems as if your approach is that irrespective of the fact that there is a minimum sentence, this is a legislation, your point is that you must lavishly apply the minimum sentence. I think that you are wrong. Because the starting point is to accept that a legislation has been ordained which prescribe that life sentence or whatever minimum sentence has been prescribed. And then once you do that, the next approach is to then look onto the facts of the particular case so as to determine that these circumstances justifying a deviation do exist. But yours is the other way around. And hence, you, in your response to the minister, you cite all the cases which are totally relevant to what he is asking you. Because here, what were these factors? Is that there's no violence? Is that is a family friend? I mean, what is that?
That's what I'm saying, sorry, Commissioner. That's what I'm saying. I'm not saying that it's not a serious offense. What I'm saying, because that has to do with the Minimum Sentence Act, the prescribed minimum sentence, as to how should one approach that. So I'm of the view that the circumstances, the manner in which an offense that carries a minimum sentence on its own, one has to look at those particular issues and form whether is it a substantial factors, because one cannot be able, the Act doesn't say what amounts to a substantial and compelling factors. It depends on the merits and the facts that are placed before me as to what is the situation. So, as I've said, that it was a first offender. As I've said, that the issue, there was also no violence, and there was no violence, and it was not, that's what I'm trying to say, that those are the factors that I took into account at that particular stage.
Thank you, TCJ, but I'm not satisfied. In fact, you still don't understand how
He's
do you
given
move
his
about.
answer, Commissioner. Do what you will with it.
I also want to just do a short follow-up, like a shorter than Mr. Nojesi.
There are two follow-ups before you, Commissioner. Commissioner Pillay?
Thank you, DCJ. This is just a quick follow-up. Good afternoon, Mr. Maniati.
Good afternoon.
Can I follow up on what Commissioner Nojesi has put to you? And it really is, and this is where you two seem to be speaking past each other. It's the approach that you used is an incorrect approach. If you look at paragraph 15 of your judgment, you say, in the evaluation of the facts before me, I'm of the view that the learned magistrate put much consideration to the seriousness of the offense and the interests of the society above the personal circumstances of the accused. Lastly, that the degree of severity in this matter is not that serious. You were applying the Zinn test, which is a completely different approach to sentencing. You disregarded the minimum sentencing dispensation, and that's the problem. You acted as if you've got a discretion which you exercised from scratch, and you took into account the Zinn factors. You didn't depart from the perspective that the minimum sentencing legislation is in place. That's what the legislature ordained, and your only job was to check as to whether or not there are substantial and compelling reasons to depart. That's the distinction.
As I've said, Commissioner, my approach was automatically the first thing that one has to do is to check whether there are substantial and compelling factors to deviate from the prescribed minimum sentence. What I did was to look at the factors, the facts of that particular matter, whether the sentence that has been imposed, is it disproportionate to the offense that has been committed. Now, at the same time, when I look at the fact that he was a first offender, looking to the fact that there was no violence that was used, and I've not actually planned, it was just a spur of a moment, but still the fact is that he committed this particular offense. I felt that the issue of life sentence was disproportionate to the facts at that particular time. But as I've said, if the Commission feels that that was a wrong approach, at the time, I bona fide believe that that was the approach that I wanted to do, that I was supposed to do at the time.
Thank you, DCJ.
There was a follow-up question from the virtual platform. Who was it? Have they given up? Okay.
Not Dodova was right after all. It's just.
No, no, you was not
No,
right.
Let's,
it
I
was
don't.
me, DCJ.
Yes. Who was it?
Yes, it's Clement.
Go ahead.
Good afternoon, Magistrate.
Good afternoon, Prof.
Yes.
I can't see
I'm
you.
also concerned with this case, in a sense that you are using the word violence. And I just want to understand in what way you are using the word violence. I cannot think of any way of thinking of violence than somebody actually violating you by putting any part of their body into your own private part. I think that is violence enough. But over and above that, I just want to understand from you, when one deals with the question of rape, are there degrees of seriousness? And what determines whether an act of rape is more serious than the other in such a way as to deviate from the minimum prescribed sentence? Thank you.
Thank you, Commissioner. As I've said, when I'm talking
DCJ,
about...
So sorry, it's the same question. I just want to add something on the same question that Prof has asked. If you allow me, can I just do it so that he package it, if it is possible? Okay. My simple question is, what is not violence in rape, especially a statutory rape? What will constitute non-violence?
Commissioner,
Or put differently, DCJ. Or put differently, what is your definition of violence?
no, in this particular matter, Commissioners, I was talking about physical in the sense of assaulting or stabbing. As I've said, the fact that we take it very seriously, that any rape is serious. That's why the extended definition that if you use any part of your body is rape. The rape is rape. But as I'm saying, you look at the facts. How is the matter being committed? How is this rape is committed? That's why I'm talking about the degrees of commission, the action itself, not the rape itself, but the manner in which the rape has been done. That's why I'm talking about that particular issue.
But DCJ,
Rapes are all of them are serious.
DCJ. But we agree that rape is violence. Should we agree on that one? That rape on its own is violence?
Yes, Commissioner Malema, I do understand your side of the thing. That is a violation.
Side of the thing.
That is a violation of a human. And rape, as I've said, is serious. But when you look at the cases, as I've said, when I'm talking about, when I referred to the issue of violence, I was actually meaning, maybe it might have come out in totally wrong, but there was an issue where somebody has stabbed somebody or assaulted this particular woman. That's what, when I'm talking about violence in that particular sense. But I do agree that rape on its own is rape in a technical sense, is violence.
Yes, I mean, DCJ, I wonder if maybe I can help the candidate. I think the problem that you don't have to answer this because I think you've attempted to do so in response to Commissioner Pillay. I think the problem that you are being pressed on, certainly from this side of the table, is that you've distorted the test. You know, if you look at paragraph 14, in cases of this, of your judgment at page 30,
Okay, you can post it.
Do you have it?
I'll check. I'm trying to check.
no, let's just go through it together. Maybe you can concede and then we move on.
Yeah.
It's page 30, paragraph 14. It looks like you're looking at the wrong bundle.
Sorry about that.
No, I know the feeling.
Sorry about that.
Yeah, so I think the point that is being put by Commissioner Pillay is that you've distorted the law. Because the way you express the law is that in cases of this nature decided by the Supreme Court of Appeal, the message is that it's clear that life sentence is the most severe which a court can impose and must be regarded as a last option. Now that's where the distortion is. The law is that it's the first option, unless substantial and compelling reasons exist. So that's where you are misunderstanding the law. That's what is being put to you. The second thing around this misunderstanding, it looks like you are not the only one, because when you turn to page 32, the judgment is concurred in by a senior judge.
Okay. I think I've got it.
Yes, but you don't have to answer because I think you've already taken enough.
Just one quick other follow-up. Mr. Manyati, you speak about the extended definition of rape. I'm not sure what you're talking about. There was a common law definition of rape, which was more narrow, which was repealed by the Sexual Offences Act in 2007. And then there's one definition of rape, which is person A who unlawfully and intentionally commits an act of sexual penetration and with a complainant B without the consent of B is guilty of the offence of rape. Full stop. That's a definition of rape. So what's the extended definition? There's compelled rape, which is not one of the factors here. That's the third person. So, I mean, even with respect, I suspect you are looking at the old common law definition of rape, which was repealed as being the correct version, and the statutory definition of rape as being the extended version. And let me assure you, it's not an extended version, it is the current definition of rape.
Yes, Commissioner, I do understand. As I've said, I think what I'm trying to say, as I've said, Commissioner, is the fact that when those issues that were indecent assault and other issues, they are now actually rape. That's what I'm talking about, because initially there's certain part of the body that was used before it can be regarded as a rape. But now the Act talks about any part of your body and any other objects. That's what I'm talking about when I'm talking about the extended definition of rape. But as I've said, if that was the wrong approach, I think it came in a wrong way, the way I put it, but that was not what I meant, and I accept what the Commission says.
Commissioner Lucas?
Thank you very much, DCJ. Good afternoon to Mr. Manyati. Is it Manyati? I was listening to the candidate, and I think I want to ask him to forget about the technical approach that he's actually bringing to this panel, and tell me whether, in the light of the high prevalence of gender-based violence in this country, someone just Monday responded to say that they realize that South Africa in some aspects can be seen as a lawless country, particularly if you look at the high prevalence of gender-based violence. Now, while you are sitting on the bench, whatever kind of judgment you give become kind of precedents. Have you taken into account how many children is being endangered by taking a decision technically that you have got, what do you call it, that you can decide discretion, that you have discretion whether you want to impose a minimum or a maximum or a minimum sentence? Have you taken into account how many of us, or do you expect us as women here to to agree with you and say that you are fit and proper for us to recommend that you should be appointed. Because we are very disappointed, and I don't become a board anymore. What is happening is that it is very, very painful to hear someone speak and making something that is so painful a technical issue. DCJ, if you allow me, I want to tell you, I was in the United States of America earlier in last month. And you know, because of the time difference, we are reading South African news all the time. For the 5 days that I was in America, every day, 2 women at least was killed and raped. And that is why we don't know how someone can be technical about the issue of rape.
Thank you, Commissioner.
Thank you.
As I've said, Commissioners, I take rape very seriously. Maybe the manner in which I've put it is the weights in that particular judgment sends maybe a wrong message. In my instinct, as a judge in this province, I've actually done more than, I think, 5 cases that has to do with rape, where the accused has been sentenced to life imprisonment. Last month, I think in January this year, in Captain Park, I sentenced the accused who was sleeping with his own daughters, that are 3 of them, that were underage. I gave him 3 life sentences plus 30 years on top of that. What I'm trying to say is, I'm very much sensitive to the gender-based violence. I think some of the cases that I've gave to you, that shows that I'm very much sensitive to those particular issues where gender-based violence are involved. You can see also in one of the cases that I've quoted, the one of Palisa Modiba, a UJ student. I'm very much serious about those particular issues. But as I'm saying, that I might have used a language that is actually not correct in this particular matter, but that on its own, as I've said, I think I will have to look at that at the next time as to how do I put that in a proper perspective. But I take gender violence very, very much seriously.
I think the difficulty, Mr. Manyati, is that you strenuously defended this obviously flawed judgment of yours. And it's not just the reasoning. Well, you are backtracking on your reasoning now. But the sentence you imposed there shows exactly what, how you understand the notion of rape. You imposed a mere 12-year sentence, which backs your flawed reasoning. How do you account for that? And then you come here today and you continue to defend this judgment when so many people are trying to show you where you went wrong. I've not heard you concede to this point that you were wrong in that judgment.
Thank you, Commissioner. As I've said, that I thought that the way I put it and the manner in which I've done, I was of the view that I'm in the right track. But as the commissions are pointing out, I cannot dispute what their views is. But at that particular stage, that means that next time I have to be very much careful about that particular issue. I do agree and accept what are they saying.
Thank you, DCJ. Good afternoon, Mr. Manyati.
Good afternoon.
DCJ, my question in fact becomes a follow-up on what you're saying. Mr. Manyati, the courts speak to the public and to the parties that appear before them through their judgments. And it is therefore important that the orders that you get to are reasoned. When you read the body of the judgment, as a party that before you, when you read the judgment, you want to see an explanation of why an order was given. You reduce the sentence to 12 years. There's no reasoning why 12 years. Why not 5 years? Why not 20 years, right? So this child of 13 who has been subjected to violence, because it is violence, has been subjected to violence, has no idea why you have sentenced you have reduced the sentence to 12, why in fact it is 12 years. And all you tell us is you've taken into account the personal circumstances. And the only personal circumstances in this judgment is the accused is 39, he's got a son of 17, he's an IT specialist who earns so much. Those are the only personal circumstances that are in here. And we have to have, you want the public to have faith in the decisions of the courts and how they come to the decisions of the court. But it will not happen if we don't explain ourselves. And I make the point because whether you get appointed or you continue to act, you are going to continue writing judgments, even if you're acting. You have to understand and appreciate that you owe it to the public to explain your orders. You have failed dismally to do this. In fact, as a result, the impression is, well, you take rape lightly, this kind of rape lightly, hence the 12 years.
Thank you, Commissioner.
Thank you, DCJ.
As I've said, I do accept, as the Commission is of the view that that is the issue, I do accept that maybe I've made a mistake. I do understand in respect of the approach. But at the same time, as I've said, I promise that I also take that serious, any rape matters, as well as any gender-based violence offenses, I take them into seriously. But I do understand what the Commission's concern is. But as I've said, I will try to next time to sort out the way that I've done it, the approach that I have.
Mr. Manyati, you've come 7 years after you've done this judgment. You've heard all of us say you can't justify your sentence and your reasoning. And yet you continue to say, I hear what you say, which means your view hasn't changed and we haven't helped. So what do we do? Which appears that you've written the judgment today, the way you're defending this. You come here for an interview. We're telling you about the difficulties. We're telling you that there was maybe an error at best for you, and you don't admit that. You justify the unjustifiable, and you continue to do so today. And I have great difficulty with that. That causes me serious concern.
Yes.
Because I see this judgment as if it's written today. And by the way, it's not a 12-year judgment, it's a 10-year judgment, because you antedated this judgment.
Yes, Commissioner, I do understand. Maybe I don't put it, I do accept that the Commissioner's view, I do accept that there was, maybe the approach was wrong. I do that I was wrong, and I've said it's one of those regrettable errors, and next time I'll try to be able to do that. I do agree and accept the Commissioner's view in this particular matter.
Yes, Commissioner Maleng.
No, just a very brief follow-up. Apart from the law that the other side has shown and everybody else has spoken, in particular Commissioner Lucas, and how this has become a huge problem. Now a cardinal mistake has been pointed out to you that child will never recover from. That the admission you are making here now confirms that she has never received justice, she will never receive justice. In the spirit of Ubuntu and Africanism, having accepted all of this wisdom that was shared with you, Judge, collectively, don't you see that you should take this opportunity to really, sincerely apologize? Because it will go a long way to heal some of the wounded women of our country who have fallen victim of this. And there is a general acceptance that they are not. Is there a problem, Commissioner Nonjes? No, but I see you two citing the DCJ with a hand sign. You want to stop me?
Commissioner Malem, time is against us.
So I thought the acceptance will not just be an acceptance, will be accompanied by something beyond that, because we're now going beyond the law and all of that. Seated here, we can't correct that. ourselves. We don't have that power. But seated here, we can reach out in the spirit of Ubuntu and say, this wisdom has opened my eyes. I'm really sorry. And in future, I'll correct it. A lot of people will find a lot of sympathy out of that. Not that we're trying to find any legal correctness or anything of that sort. It has been pointed out. The victims are watching. Commissioner Lucas made a very clear plea of what our women have been subjected to. And when they rush to justice, they don't get justice in the manner it has been presented to now. Will it cause any harm to just say, I accept I was wrong and I sincerely apologize?
Thank you, Commissioner Maleme. I think I was trying to say that my approach at the time, I thought it bona fide, believed that it was the right approach. I realized, as the Commission is saying, that it was not the right approach, and I apologize for that, as I've said. Going to make sure that this particular mistake does not happen again, and I assured you that even if after this, there are my cases that has to do with this type of crime, the appropriate sentence was imposed. So I'm sorry about the approach that I've used, and I'm wrong.
On that note, we have reached the end of your interview, Mr. Manyati.
Thank you. Thank you very much, Commissioner.
You're excused.
Thanks.
Good afternoon, Mr. Noko.
Good afternoon to you.
How are you?
I'm fine, thanks, and how are you?
I'm fine, thank you. I see that you're a dad of 3 young ones.
Yes,
Yeah.
I was delayed a bit.
Are you raising them on your own?
No,
Oh, all right. I was a bit worried. I saw that you're a widower, and I wondered how you juggle all that comes with that. Okay. Just tell us a little bit about yourself. What academic qualifications do you hold?
I hold B.Juris degree from Northwest University, previously called UNIBO, and LLB. I also hold LLM from the University of Pretoria. I hold a postgraduate diploma certificate from the University of Johannesburg. I also did a diploma certificate, if I could call it, from the University of Pretoria on insolvency practice.
Right.
Yes.
You're an attorney
Yes, I'm an attorney,
and a conveyancer in Notary Public.
conveyancer and notary public. Yes, indeed.
I see that you've worked in a few firms of attorneys before, or including the well-known Seriti Mafundla firm before you started practicing on your own account.
Yes, I served articles at a firm in Rustenburg, ceded the articles to another firm in Pretoria, and after my admission, I then joined Seriti Mavundla and Partners for a short stint.
When did you start acting in the High Court?
I started acting in the High Court in 2019.
2019. And how long, how many stints have you had? How long a period have you acted there?
I will say, including the recent stint that was not indicated at the time of the application, that I'm approximately on 34 weeks.
I see that your practice fields a wide range of legal aspects. It's a general practice. Is it not so?
Yes, I would say it's a general practice.
And what is the majority of the work you do? In which area of the law is that?
I will say we have got mainly conveyancing in the form of transfers, bond cancellation and registration, and property litigation in general. And what would ordinarily be the general civil practice, your divorces, your Rodex and fund. We are also into labor, we also do land claims, related litigation matters.
Have you written any judgments as an acting judge?
I did.
How many?
I will say 26, if I'm not mistaken.
The legal professions comment very favorably about you. And what rings is that you write well. You agree that you write well. You think well.
I wouldn't say that I ran 100% well. Obviously, they've made comments that there were typos here and there that I did not do a proper edit, amongst others. So I wouldn't say that I'm 100% well as maybe they've conveyed to the commission.
But you try your best.
I try my best, certainly.
Okay. Do you have any reserved judgments?
At the time when I applied, there was one, but for sentencing only, and it was argued only on the 29th of March. So with regard to, as I said, at the time of the application, I would say that I still have got one reserved judgment for sentencing. I don't, however, include the judgments in respect of my recent stint when I was acting from the middle of January until...
I should have been clearer. I'm asking about judgments that are older than 3 months.
No, except, no, I don't have.
All right. All right. Okay. I'm going to ask JP Mlambo to continue with you.
Thank you very much, DCJ. Good afternoon, Mr. Nuku.
Good afternoon, JP.
How are you? Is it Nuku or Noko?
Neither, it's Nuku.
Nuku.
Yeah, it's not Nuku or Noko, it's
Oh, okay.
no, in the middle.
Sorry if I'm murdering your surname.
No stress.
You were discovered as a gem years ago by Justice Matopo, Ledwaba, and myself in a judicial training session. How many years ago? It happened outside Joburg.
Yes, it was in Rustenburg. I think it was 2016 or 17. 2016, I think, yes.
And you've acted, I think my spreadsheet says 40 weeks, give or take. You've acted again this past term.
Yes.
But I think we've added those weeks, haven't we?
I'm sorry?
We've added those weeks in this spreadsheet.
Yes, I think there was some mistakes on the spreadsheet, including the fact that I also did an extra 1 week agent, so it was not included.
Yeah, so you've done 2 weeks in the agent court. Is it?
Yes.
Yeah. I remember the first time you did the agent court week, you were sitting with Judge Collis.
Yes. Oh, the 1 week that I'm speaking about is the one when I was with Judge Collis.
Yeah.
But previously I did it last year, not with her. She was not the one who was with me.
How many matters, just for interest sake, did you have in the agent court yourself that week, the last week?
It was not more than 10, because she took a load of them.
She took all of them?
Yeah, I'm saying a load.
Oh, okay.
Yeah, I think she did 11, and if I remember well, I was doing 10.
Oh, sir.
Yes.
And the first week?
The first week, that was last year, it could have been, I think, around 10. There were not that many either.
And you were able to get through them?
I was able to get through them. Obviously, some of them will then be withdrawn and not proceed. So it was not too extremely harsh for one to go through all of them.
Yeah. How long did it take you to write the judgments you accumulated in the opposed motion? In any of the weeks? You've done 4 weeks in that court.
Previously?
Yeah.
Yes. I would say by average, it would be around 3 months plus a few weeks, I should say.
And how are you able to do that? I mean, in fact, we'll come to those judgments. I think there are comments here that there are, I think in 2 instances, there's a judgment that took you 8 months. Am I correct?
The comment from the GCB, maybe
Yeah.
I could speak to them now.
Yeah, please.
Yes, the first one, it was Lumka, is the one where I took, I think, approximately 4 months. I left, obviously, my acting stint towards October, December, to back to my practice, so it was a big hectic at the office to cover up, and it slipped through. That's why it delayed. The second complaint related to it, I think they made a mistake on the second one. It was handled by my colleague Nzelele, if I'm not mistaken. It was a full bench.
Who?
Is it Nzelele?
Oh, Munjelele.
Munjelele, I'm so sorry.
She's a permanent
yes.
judge.
Yes, so they made a mistake. They said I'm the one who was ascribed there. The third one, it was written by me, but what transpired, I was in Johannesburg with a senior judge. The 3 matters, one of the matters was full for the full bench. So the senior judge took 1 matter, I took the 2. Unfortunately, he got sick for some time, but I realized only later. As I said, I was done with my stint, and I offered to write the judgment. That's the one that took long. I spoke to her, I spoke to him, and he confirmed that it was his matter, and he also penned down an explanation that I should have forwarded to the JSC before. So in principle, I would say that I'm responsible for one of those delayed matters amongst the 3 as identified by the JCB.
Yeah, okay. Thanks for that explanation. I think you spoke, either you or the judge spoke to me whether he can send the letter to the JSC to confirm that it was his fault, not your fault.
Yes,
I can't remember who of you.
I also did mention it.
Yeah. Are you firmly of the view that you now want to come permanently to the division?
Yes, I believe that I'm ready.
Yes.
And, yeah.
That's why you're sitting here. And
That's why
talking
I'm
to-
sitting here.
Yeah. And you've encountered no challenges in your acting stints. If you have, please tell the commission, you know.
No, I didn't have what I'll call maybe serious challenges. I had senior judges who were easily accessible, who would guide you here and there where there's a need. To a great extent, I enjoyed both acting in Johannesburg and also in Pretoria.
Yeah. The professional bodies are very sparing in heaping praise on candidates. You are one of those where they say, I mean, the comment about your appointment is that it would send a positive message, right?
Yes, I'm humbled by their comments.
You saw that?
Yes, I did.
Yeah. And they've reviewed some of your judgments.
Yes, certainly.
I see. And thank you very much, DCJ. I've got nothing else to ask this candidate.
Thank you, JP Mlambo. Oh, MEC?
Thank you very much. Good afternoon to you. One simple question from me is just, if you can just very briefly share, your experience in constitutional law, what exposure do you have there, and what's your knowledge of that?
Well, I've been reading cases that are from Constitutional Court, the ones that are normally published. I'll have to indicate, I also mentioned in my application that there's a pending matter that is in the Constitutional Court where we are acting for one of the respondents. We had a matter from my office also that was between a municipal manager and a mayor, and the dispute relates to what the mayor, it was a defamation case, where the mayor made some utterances in council meeting, and unfortunately at the municipal level, there's no protection as it happens in parliament. That in parliament you can make utterances but will not necessarily be sued therefore. So in our case, we were trying to argue before, it started in Pretoria until the Constitutional Court, we were trying to argue that mayors in council must be afforded a similar exemption as it applies to members of parliament. So those are the two matters that I'll say that I was involved in. I may briefly also indicate that I had a matter acting for a traditional leader who was being charged for contempt of court in instances where he says I was not involved, but only the community members. And we wanted to reason it out as it happened in one of the Machabi matter, which was in the Constitutional Court, to say that if the municipal manager cannot be charged for contempt in respect of the official in the municipality, that should also be extended to cover traditional leaders in respect of conduct of what, for lack of a good word, I'll call their subjects. So it went there, but unfortunately the court indicated that the prospects are not very good when we were trying to challenge it. And the second leg that we tried to raise in the very same matter was to indicate that ordinarily in contempt of court proceedings, ultimately you will then, for example, fine who I will call the respondent. But in imposing a fine, you must also at the same time assess whether it's affordable or not. So our client was not afforded the opportunity to address the court as to what would be a reasonable and fair amount. And the reason why I wanted to raise it, we are saying that when you sentence or when you impose a fine that will be paid, not a fine ultimately that it will be impossible for lack of a good word, the accused to pay. Otherwise, it defeats the purpose. And I'm saying that the only way in which you can assure yourself that this fine that I'm imposing will be paid is having to listen to the person who's supposed to pay. And in this instance, the respondent was not given an opportunity to address the court on what he can afford. But as I said, both the SC, unfortunately, and the Constitutional Court were not with us.
All right. Commissioner Nyambi?
Thank you, DCJ. Afternoon, Advocate Noku.
Good afternoon, Commissioner.
Indeed, it's very rare for us as Commission to get almost all the law bodies commending a candidate. So it means we have done exceptionally well. So it's one question from my side. If you can share with us the attributes, 3 attributes of a good judge, probably that might be the secret behind these positive comments. Mainly focus on those that you think you possess.
Yes, I'll talk to independence, objectivity, and impartial. Those are the 3 attributes that I think I possess, and do believe that to a greater extent can also be read from the judgments that I've delivered.
Thanks, Advocate. Thank you, DCJ.
Thank you, Commissioner. Commissioner Moimang.
Thank you, TCJ. Good afternoon, Mr. Noku.
Good afternoon, Commissioner.
Just one question from my side. As a follow-up from what the response that you gave. Particularly the independence as one of the attributes that you raised. Is the independence of the judiciary meant to protect the rule of law and the public interest, or is meant to protect the individual judges? That's my question. Thank you.
I would say it's more to protect the judiciary. But as judges, being members of the judiciary, it also extends to us. Because as a judge, as I said, I'm employed within the judiciary. So I'm supposed to be independent. And ultimately, it's only then that it wins confidence from the general public, that when their disputes are referred to the judiciary, they will be independent and not be influenced or induced to give a certain judgment in favor of one of the parties for unfair reasons.
So you'll agree that with the independence of the judiciary, all of us are winners?
I guess so.
Thank you. Thank you, DCJ.
Thank you, Commissioner Moimang. Commissioner Singh.
Thank you very much, and thank you, DCJ. Good afternoon to you, Mr. Noku. I'm on the virtual platform.
Good afternoon.
It's very commendable that, in your limited acting space, you even had a reported judgment, because we come across others who don't have reported judgments with double the number of cases that they address. So I think it's very, very commendable. I just want to follow up on the Premier, and I'm glad that you've been reading the comments by the law bodies, because you referred to the typographical errors that the GCB referred to. So you knew about it even before you were asked. But in one of the paragraphs, they talk about your limited exposure to administrative law. Would you want to speak about that? The Premier asked you about constitutional law, but your limited exposure to administrative law. It's also commendable to see that you've enrolled to do a tax diploma, which you'll probably complete at the end of this year or next year.
Yes. I'm not sure whether it came clearer on my CV or on my application. We are also on the panel of the city of Tshwane, and in greater details we were dealing with procurement law, where obviously they will issue out tenders and there will be issues that parties will fight over. So in as far as that is concerned, I will say that to the extent that we handled matters over a period of, I think, 3 to 5 years, even though mainly we are doing labor, we did get a bit of exposure in administrative law. And at the same time, we also look out for workshops that speaks to that, and I believe that it will enhance one's knowledge in that sphere.
Thank you. Your forte seems to be labor, though.
Yes, I would say labor and property, but admin law is also getting exciting in the process. You would have noted from my application, I also referred to a matter that we are handling on behalf of a mining house, speaking to a review in terms of the admin law.
Thank you very much, DCJ. Thank you, Mr. Noko.
Thank you.
Could I follow up this point about administrative law? Thank you, DCJ. Mr. Noku? Okay. Look, I've read the 3 judgments you've given. They are strong, they are fluent, they are logical. It's, I don't want to say unusual, but thank you for paying attention to what you're doing.
Thank you.
I've also seen that but your response to administrative law is that you are already doing procurement law, which is administrative law writ large, or maybe writ small.
In between.
Yes, but I mean, it's administrative law.
Yes.
What you are doing is administrative law.
Yes.
You can term it procurement law, but it's administrative law.
Yes.
Yes. Now, I want to ask you something else now. Thank you, that's also excellent. I want to ask you something else. I see that you are also doing land, which, you know, always people come here, they talk about land, but I'm glad to see someone who's actually doing the work. Because it says here you've done Esther and restitution cases.
Yes.
Yes, no, that's excellent. So would you also want to be, if you get in, to be seconded to the Land Claims Court to assist there? There's a real problem of capacity.
I gather if assistance is required, I'll make myself.
I see the JP is not impressed with my question.
And so the answer will not impress him either.
No, I mean, I think there's something about, you know, we need people as articulate like you in the space of land to do real work and to stop the populism. So are you going to be willing and available if a request is made?
Yes, when I've done my time at the High Court, I'll consider that.
All right. Actually, I don't have any substantive questions. Thank you.
You actually never had any questions for this candidate, Mr. Gauteng. Anyone else? Oh, sorry, Commissioner Maturu-Lebu.
Thank you, Deputy Chief Justice. Good afternoon, Mr. Noko.
Good afternoon.
I have to declare that I know you from the Black Conveyancers Association. What I just wanted to find out that you are very active in fighting for the plight of black conveyancers, especially against the banks. So are you telling me that you are abandoning ship now? So we are left with no one? Thanks.
I think I've groomed a few who will take over where I'm living.
I hope you give us some time before you get off and go to the bench.
I'll consult with the JP on that.
Any further questions, colleagues? No.
DCJ?
Yes. Is that Mr. Bernard? Oh, Prof.
It's clear. Yes, thank you very much. Good afternoon, Mr. Nuku.
Good afternoon. Can't see you though.
Yes, I'm on the visual platform.
We can't hear you, Professor. Your line is horrible.
Look, I must say some of your but in particular, the judge that issued a dissenting judgment of versus Bruno, John Bruni. I'm not sure you remember it. It's on page. I think your dissenting judgment is on page 70. Page 76 of your pack.
Yes, I know about the judgment.
And you remember that judgment where you dissented. The majority judgment was written by 2 senior judges, and you dissented from there.
Yes, I did.
You remember that? Yes. I just want to look. I thought it was a well written dissent and a valuable one in that. I just want to understand your approach when you dissented from that in relation to summary judgments. By first outlining what is the approach that one should take when adjudicating cases that deal with summary judgment. And perhaps maybe just to give us an indication as to, on this particular case, what was your approach of saying, but in these particular facts, you would not necessarily agree with the majority?
Yes, I may have to mention that at the initial stage, I was going to write the majority judgment, but ultimately I failed to persuade my two seniors. My approach was to say that the plaintiff need to satisfy me that all the requirements for a specific course of action have been met, even before I look at what the respondent is saying. So in this case, there were three elements which were very clear, which were supposed to be met. The course of action was about contiguo indebiti, where the plaintiff claimed that he was impoverished at to the benefit of the defendant, but he failed to bring evidence before court to indicate that I was impoverished, and here's the proof. The response that I got from the applicant was that the proof is at the office, and I couldn't bring it to court. Secondly, if you are saying that you get impoverished at the instance of the defendant, and instead of attaching records confirming that the defendant received payment, you attached documents which suggest that somebody else was the defendant. In actual fact, to be specific about it, they were suing P2LTD, but in support of them proving that the defendant is the one who was enriched, they then confirmed that the account numbers belong to an LTD, and I'm saying those are two different entities altogether. So I was not satisfied that the applicant satisfied the requirements of the contiguo indebiti for which they wanted a redress. I would say that the majority judgment focused more on what the respondent has said. And I'm saying from where I am, there was no need for me to cross over to the respondent if I was not happy with the applicant's case.
Thank you very much, Mr. Nuko, and I personally think that your approach is correct. Thank you very much, DCJ.
Thank you.
All right. Any further questions from the virtual platform? No.
Okay. Thank you so much.
End of your interview. Thank you for coming. Thank you, and all the best. You're excused.
Thank you.
Good afternoon, Ms. Retief.
A very good afternoon to you, Deputy Chief Justice.
Are you ready?
I am. I trust your will.
I will.
Good.
I see that you're a mom of one, a daughter of 22 years of age.
I am indeed. Does that make us kindred spirits?
Sorry?
Does that make us kindred spirits?
Indeed it does, although mine are many more than yours.
I understand.
You hold a BLC and LLB and an LLB degree.
That's correct.
Obtained from UP.
The University of Pretoria. That's right.
In 1989 and 1991.
Correct.
Okay.
From 87 to 91, to be exact,
Uh-huh.
Deputy Chief Justice.
All right. You started your foray into the workspace in the Ministry of Justice as a judge's registrar.
I did.
How old were you then?
I must have been about all of 20.
Yeah.
It was a very small stint. I actually just helped out a young lady who was going on a studying sabbatical, and it was for a 3-month stint at the Palace of Justice in Pretoria.
How did you find that experience?
Well, it was rather exhilarating, but it's when you're a law student, you don't really understand the intricacies of it all.
Yeah.
So one makes a number of faux pas, but my judge was awfully gracious and awfully kind, and it was a wonderful experience. But I think if I know what I know now, I may have very well got a great deal more out of it than I did at the time when I was that young.
Yeah, that's usually the case. A lot of things are wasted on the youth.
Absolutely.
Yeah. You did your articles in 1992 to 1993, and then started as a professional assistant in 1994.
Yes.
And then you left that firm. You were with Routledge Modise, then you went to Newton's.
Yes. Deputy Justice, what happened there was Rutledge's had a Pretoria office, and I went to the Pretoria office. That Pretoria office then pulled away and became Newton. So it was really, in effect, one and the same firm. It just changed its name.
I see.
Yes, that's really what happened.
All right. Then you decided to strike it off on your own.
Yes, I did.
And you did that for 10 years.
I did.
Then you decided to join the bar.
Yes.
In 2007.
Correct.
To date.
Correct.
Have you regretted that choice at any stage, that decision?
Not at all, Deputy Chief Justice. It's as if at that particular time in my life, in late 30s, a number of my colleagues asked me why, and we teased and said perhaps a midlife crisis. But in truth, it was such a form of growth, and it was the right space at the right time.
Yeah. You do a lot of interesting things. One of your passions is child welfare, I see. And you've worked with organizations such as, is it Door of Hope? Door for Hope?
Correct.
And Baby Save.
Yes.
What's that one? Baby Savers SA. What do you do with those organizations?
Yes. Deputy Chief Justice, my practice as an advocate concentrated not primarily, but mostly on medicine. And a great deal of that became fertility law.
Yeah.
And in fertility law, obviously what flows from that is children's and children's rights. And at a stage, I started doing a number of work for KELS. And it just so happened that the difficulty that we have with abandoned children became a topic of discussion. And I then formed a think tank, so to speak, with KELS to try and see whether or not, if we look at our existing legislation, whether or not we have what we call safe haven laws with regards to abandoned children, but more specifically centering on what about these young ladies? Are they the criminalization thereof? Is it abandonment per se? And then on equality in terms of male-female equality, it became the test on if a woman gives up her baby and is found criminally charged for abandonment in terms of the Children's Act, what happens then to the young man who basically just then walks away? So it became quite an interesting think tank, and we've got quite a lovely group. And the Door of Hope is actually one of these homes that takes care of abandoned children. But the pertinent interest here is that they have what they call a baby saver, which appears to be a controversial issue. And a baby saver, I always say, it's just a little bit like a Moses basket, really. It's a conduit where a lady who wants to be anonymous places her little one in a particular container at the doors of the Door of Hope. So it's a drive for the recognition of a body called Baby Savers South Africa, in a nutshell.
Very commendable. You're an expert in the law of fertility.
Yes.
That's a very niche area of the law.
It is indeed, but it's an exciting part of the law.
Yes.
It's as if the law is trying very desperately to catch up with medicine, which is fantastic to be part of, because you learn a great deal. One's mind turns all the time.
Yeah. You haven't had an opportunity to write a judgment in the area of the law, though?
Not yet. I'm
Not
hoping
many
to do so.
cases.
That would be quite a privilege.
Yeah, yeah. You mentioned a brief you received from CALS to consider advising on aspects involving a class action in which the concept of obstructive violence, and I've never heard of this concept, obstructive violence as an infringement of a constitutional right is to be claimed. Can you tell us a bit more about that? That got my interest all piqued.
Yes, it got my interest too, but the pity is that although I was approached to be part of that think tank, and it's because I do a great deal of medical negligence work too, and gynecological, unfortunately, when I was asked to look at the papers once and settle the papers once the class action had been finalized, I wasn't given the papers. So I was also waiting with the bit between my teeth, but was never released on it.
Oh well. Okay, I'm going to leave any questions on your acting stints in Gauteng and judgments you may have written to the Judge President of the Division, to whom I'll hand over now. JP Mlambo.
Thank you, Deputy Chief
Thank you very much, Deputy Chief Justice. Good afternoon, Advocate Retief.
Good afternoon, JP.
You've acted for 26 weeks in total in Gauteng.
That's quite correct.
Right. And I see in those acting weeks, you've had 4 weeks in the opposed motion. That's where you would have accumulated reserve judgments.
Yes.
But I note that it doesn't appear like you've reserved for longer than a month or 2 months at most in all your judgments.
Yes, JP. It was a wonderful exercise to do that flow chart, because I never really thought about it.
Yes.
But when I looked at it critically, I saw that most of the opposed matters were extempore. Those that were written, obviously, I think 2 months is a fairly good, fair reflection.
Yeah. You haven't done work in the agent court,
I haven't. I did
but
notice.
you may have got 1 or 2 pass-ons. You didn't have that.
I didn't have pass-overs, but if it gives you any comfort, JP, in the 15 years that I've been an advocate, I have practiced in the urgent court.
Yes.
I'm quite au fait with what I have to argue as counsel as substantial redress, and I think I'd be quite comfortable with deciding whether or not that aspect has been proven and dealt with. The other thing is that in the opposed motion court in 2019, when I had the taste of my first stint, it was quite a triggering moment for me, in the sense that I realized that the 29 years of experience that I had and life experience almost came from my big toe and out of my mouth, meaning that if one looks at the 2019, I was able to get to the nub of the matters rather quickly, which I think is quite important in urgent matters.
Yeah. Thanks for that response. I think perhaps this is accounted by the number of weeks you've acted, which is more than the divisional threshold anyway, even though it may be viewed as illegal.
I see.
But we do have a threshold.
I see.
you've not been allocated special motions
I have not.
as well as special civil trials.
No.
Right. In your stints in the appeal courts,
Yes.
did you have any criminal appeals that you dealt with?
Yes, there are a number of criminal appeals, and I think I did note them down.
Yes.
Yes.
Okay.
And there's one in the, I think I
Yeah.
placed one in the bundle, JP.
You are actually in the list that's gone to the president for the conferment of silk. Am I correct?
Yes.
Yeah. You have not heard yet. I think there's a wait now this year, no, last year and the previous year.
Correct.
We've not heard anything from the
We
presidency.
wait eagerly,
Yeah.
JP.
Now, your appearances, you're an advocate. You appear in the High Court, that's a given. Have you had appearances in the SCA and the Constitutional Court?
Only in the SCA,
Yes.
JP, but not in the Constitutional Court.
Okay. Now, I know that the bar has found nothing to criticize you on. They're actually writing good reports about you and the reports they get from people who've appeared before you when you were sitting. I, as JP, want this commission to recommend candidates who will hit the ground running. The leadership sitting in that table there has been complicit in denuding the Gauteng division of its capable judges. So I need to build that capacity again, because when,
Understood.
you know, Gauteng attracts all this big work.
It's a very busy, busy division, JP.
Yeah. So I'm saying this to you to say, you've acted, you've been in practice, you're a specialist in fertility law, you've been around. You consider yourself to be more than ready to become permanent.
When I reflected to apply, that was a test that I had to consider. And it's a resounding yes, JP. If I look at being an attorney, if I look at being a counsel, if I look at being a lecturer, if I look at being an examiner and a mediator, the answer is yes. Over 30 years, I think I have a great deal to give the judiciary. I'm 54 years old, which means I've got a good term left in me.
Yeah.
I've good health, and I'm energetic. I think I am certainly ready.
Yeah. You were nominated, but you didn't want to accept the nomination until you consulted widely. And one of those people who consulted was myself, remember?
Yeah, correct.
I was out of the country. You had to wait for just over a week before we spoke. And you wanted to know whether, as JP, having seen you work, I feel you should accept the nomination. And the rest is history. You're sitting here.
Indeed.
Yeah. Thank you,
Thank you for
DCJ. No further questions.
Thank you, JP. MEC? All right. Any questions, colleagues? Commissioner Dube.
Thank you very much, DCJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
Yes, I read your profile here and what is on the table. For me, it's quite clear that you embrace transformation, because herein you train admitted attorneys, you train people around issues of BEE on how to file claims. And this is very, very good according to me. But my question is, in the three arms of government, which one is the least transformed in your view? And in that sense, what is it that can be done to fast track transformation so that all of them must be equal? Before you even respond to that, let me tell you why I'm asking this.
Yes, because it gives me time to reflect,
And
Commissioner.
yes, let me tell you why I'm asking this. Just looking at what we're talking about all the time here, I get a sense that we're using old laws in the current dispensation. For example, the Criminal Procedures Act, it is of 1977. When the president sets up a commission of inquiry, whether it's Zondo or what, he uses an act of 1947. When you institute a claim in terms of the state liability, you use an act of 1969. I can go on and on and on and tell you that. And in my respective view, I think that the least transformed arm of government, it is the judiciary. What is your take on that?
Well, if I reflect on it, and if I accept your answer, because I haven't had time to really give it some thought, but let's run with your answer. Perhaps I would agree with it. Sorry, perhaps, thank you, JP. Perhaps I would agree with it only insofar as it appears that those that apply those laws perhaps have not understood the value of the Constitution and the Bill of Rights and what's incumbent upon them to do. So in other words, it's not necessarily a case of transforming the bench as it is, but it's the transforming of application and mind. So in other words, it means that everything is here. Our entire toolbox, the Constitution, here to my left, is here. But it's encouraging, demonstrating how this tool gets used not only for constitutional issues, common law, and customary issues. So, yes, I hope that does answer.
No, it's okay. I just wanted to test you
I see.
on that particular aspect. Just on a lighter note, DCJ, last year I gave my daughter 2 books, law books. The one I think is written by Lawrence Baxter, and the other one by Marinus Weigers, and said, this you must go and read. Now, the other time she comes to me, she says, you know what, Rex has got a lot of money. Either he takes people to prison, or Rex is having a lot, he's suing people. I said, no, Rex means the state, in that sense. You must understand it. Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner. Any questions for this candidate from the virtual platform?
Yes,
Yes.
DCJ.
Okay.
Go ahead, Commissioner Singh.
No, thank you very much, DCJ. Good afternoon to you, Advocate Retief.
Good afternoon,
I'm
Commissioner.
on the virtual platform, as you can see. I was very interested to read in when you presented yourself that during your practice, which traversed general litigation, medical malpractice litigation featured prominently.
Yes.
Now, you have been involved in medical malpractice legislation and litigation. And I want to ask you this question to get your wisdom. Now, of late, we know from my experience in Parliament, I think one of the biggest contingent liabilities the government has on its financial, is land claims liability and medical claims. And there have been a number of interesting cases regarding claim for medical negligence. With recently a landmark judgment in the Eastern Cape, where the court ordered that they should not pay money to the victim, but rather, provide care for a young patient. So that's something landmark. But in other instances, we found even government commenting, and they've got the SIU to investigate what they call fake medical negligence claims. And to that end, they want to introduce a bill to limit the amount of claims to about R1 million, and then also have more settlement rather than taking 16 to 24 months to deal with these claims, which it does. And, just to quote from one of the articles, the Eastern Cape Health Department says the ruling of the Eastern Cape will help shield the public from, quote unquote, unscrupulous lawyers who, quote unquote, cheat litigants. How can you help South Africa in this matter if you are appointed as a judge? Thank you.
It is an interesting question, but at the same time, it is a little bit vexing. And I say that it's vexing because I can understand that principle applying and that thought process applying when one refers to claims of medical injury relating to road accident fund claims. But when one is dealing with situations where people have been hurt factually, in other words, the inquiry here is actually somebody that's really been personal injury to body that has traumatized them and whatever the case may be, we won't go into that. That is a factual consequence, so it cannot be fabricated. But the important part here, I think, on the fabrication, even sitting as a judge, is actually the computation of the quantum. So if we keep liability aside and we accept that there is liability, we are finding more often that the realm of experts giving lip service and providing reports that actually don't speak to the heart of the actual future medical treatment is on, let's say, the rise. What that does require, if matters do go to trial, is very proficient advocates who can cross-examine these experts who are supposedly at the top of their field. But more importantly, the balance simply is for the judiciary to understand, or not understand, they understand it, but to apply the principle that, yes, one is entitled as an exception here to accept expert evidence, but actually, if it's not reasonable to reject expert evidence, and that doesn't happen, and it could happen because of volumes, it could happen because there's been consensus with regards to amounts of claims that are made. I'm not entirely sure, Commissioner, whether the bill, and I haven't seen it, so I can't comment, but I'm assuming it's much like the Workers' Compensation Commissioner bill. In other words, I don't know if it's a no-fault liability. I'm not entirely sure whether that common law principle is going to be not adhered to. But I'm assuming you're talking to capping of claims. Is that right? All right. So once you're capping a claim, yes, once you're capping a claim, the other thing that you're also doing is you're taking away the redress of somebody, and in certain circumstances, children who are, and adults who are mentally impaired, who can't care for themselves and can't work for a dime. So the moment that you cap that, depending on whether the common law claim still stands, that's a different issue. But if the common law claim falls away, you are really taking away the only chance that a person has at negative inter esse, placing them in the position they would have been had that very incident, or we call it insult, happened. So it is an important investigation, but one must consider each side exceptionally careful. And I suppose the best way to do it is to put yourself in that position at the end of a knife and realizing that you can't do what you do anymore and your claim is capped. It's a mouthful, but...
No, thank you. I think the Deputy Minister is taking careful note of what you are saying, because I know there's a separation between the judiciary and Parliament and executive. But I just hope that your wisdom can prevail and you can somehow make comments to that bill, even if you are appointed, or recommended for appointment as a judge, because this is certainly a matter that vexes, I think, not only politicians, but the country as a whole.
Yes.
Because even one court even went out to suggest that it's the departments that are at fault, and then the kind of a very poor care that they are offering our people in these hospitals. That's largely the cause. So I think one has to balance this very, very carefully.
Yes.
Thank you. I don't know if you have any comment to that.
I think that you've hit the nub. In essence, the practitioners are the voice of a patient, in as much as legal practitioners are the voice for the client. And sometimes that falls foul and people get really injured. Yes, and the only way that they can go back to where they thought they could be, which cannot be if you're injured personally, is by looking to the law. But thank you for your question, Commissioner.
Thank you very much. Thank you, Deputy Chief Justice.
Thank you.
Thank you, DCJ.
Thank you, DCJ. Good afternoon.
Good afternoon, Commissioner.
May I just ask, the DCJ asked you about the portion of your application where you reflect that you were briefed to give an opinion on novel issues. I think that's how you put it?
Yes.
And what was referred to was obstetric violence.
Yes.
Did you provide the opinion to CALS?
No.
All right, and what happened to the matter?
I'm actually not sure. The Think team actually never came back to me. So what it was is I was briefed in another matter dealing with sexual discrimination in the workplace. And through that, they found out my expertise in medical negligence. And so we then started having our initial, shall we say, preliminary chat. I then received a brief to say that documents will be coming to you to settle the class action. I must just wait. It's coming. And then a follow-up, it is coming. But it didn't in the end.
So apart from these preliminary chats, absolutely nothing, you did absolutely nothing on the matter?
Nothing concrete to add any particular value which I would have liked to.
Because I'm just trying to understand, Mr. Tief, why that would find its way into your CV if actually you literally did nothing on the matter.
Well, I think the important part or the thrust of it is, Commissioner, is that it basically states that my expertise in a particular field, working for KELS, they considered that actually giving me the brief would add some value in that area. And I found that I thought that was wonderful. In other words, it gave me credence in a particular area.
Are you aware that there are a number of juniors working on that matter?
I am.
And did you consult with those juniors?
No, we consulted on another matter on the safe haven, and that's how I know that they're on that particular matter as well.
All right, then just the last thing that I need to touch on is, you deal with transformation under a number of headings. I don't have time to deal with each one of them, even though I would have loved to go quite carefully through it. But let's deal with transformation through the upliftment of women.
Yes.
Now, you say that the transformation happens at two levels. When you were at the sidebar, you employed candidate attorneys who are women. Am I correct?
Correct.
So when you come to the bar, that I have a question, because what you reflect here is that you set up what you call an informal women warrior group.
Yes.
Before I put my question to you, I just want to lay the basis. You've gone to great pains in your application and in your CV to portray yourself as a specialist, both in relation to medical negligence, but specifically also in relation to fertility litigation. Am I correct?
Yes.
And so you see yourself as having specialist skills in both areas.
Well, I think it goes further than that, Commissioner. It's not only that I see myself, it's that when I applied for silk, and as you're well traversed with the application of silk, my body accepted and I carved a particular niche in that particular area of law, and I was recommended on that basis. So it goes further than just my own sort of, shall we say, subjective approach.
That leads me to my question.
Yes.
How many black women have you worked with as juniors in your matters?
Yes. So the way that, let me go back. I can amplify how I deal with my practice and with the ladies within my group. Presently, I'm in a group called Group 33, and the reason for the move, amongst other things, was simply that the idea behind Group 33 is that it utilizes a third. In other words, it's a third race, a third gender, and a third seniority. The beauty about the chamber is that it is rather small.
Mr. Tief, I'm sorry, I don't want to interrupt you. We've got limited time.
All right. Well,
So
let's get to the thrust of it. Let's get to the thrust of it.
So, how many black women have you
Yes.
used as juniors in your matters? That's the question.
4.
Four.
Yes, 4.
Is that 4 fully on brief with you?
Yes.
And that's throughout your career?
Yes.
Right. And the 4 have been involved in medical negligence matters?
Medical negligence and fertility and donation, yes.
In all of the 3 areas?
Yes. And in terms of where I couldn't, in terms of cash or whatever the case may be, the attorney couldn't carry a junior, I create spaces. And that's why the preamble of the Group 33 was so important when I answered the question. Because the spaces are that where I can't give them the work, I then hand work over, particularly to tax, to other colleagues. I pull in on commercial matters where I have the ladies that work within my group. We have a very close-knit senior-junior conduent practice together. And the Woman Warrior was actually to pull that all together to try and expand where they wanted to be, because most of them don't necessarily want to be with medical negligence. In fact, most of them don't.
And just last question, apart from the 4 black juniors, how many other juniors have you worked with?
2.
So 6 juniors in total?
Yes, so two other juniors, one being a black male and one a white female.
Thank you. Thank you, Chief Justice.
Commissioner Baloyi?
Thank you, Chief Justice. Good afternoon, Ms. Retief.
Good afternoon, Commissioner.
Ms. Retief, it's really a follow-up. It's become a follow-up on a discussion with Commissioner Pillay.
Yes.
You say in your application that, maybe let me ask the question first.
Yes.
Are you appointed to CALS?
Yes.
Appointed, what does it mean? You're employed at CALS?
Yes, and what they did was they appointed me as an advocate for a period of time, and I think my duration was 2 years. So from time to time, they would appoint me as a preferred advocate on a particular matter, and I have a letter of appointment for 2 years.
Okay.
Yes.
So you're appointed to be briefed on matters. You're effectively on their panel for 2 years.
Correct.
That's effectively what it means.
Correct.
Okay. So what does it mean where you say, at page 44 of your application, you say, I think the heading you have there is transformation through upliftment, transformation through civil society organization, and you speak about CALS, and yet in your explanation, all it is that your involvement with CALS, all it is that you're on the panel to be briefed. What does one make of that? And maybe let me level up with you that I'm uncomfortable because on the face of it, it seems like you represent something that is not in that paragraph. And that takes me back to the obstetrics violence issue as well. That was my concern there, that if you answered that you were waiting for the matter to come to you, you don't know what it is, then why is it there? And it's not telling us anything other than to create an impression that is not.
Yeah. Commissioner, the reverse is actually true. So with regards to the appointment of CALS, it started with a labour matter. And actually before that, it started with me being introduced to CALS giving a pro bono mediation course. I then received a brief to do a labour matter relating to sexual harassment. Seeing what CALS does and seeing what they do, I realized that on a number of my matters, and particularly the safe haven, which in fact is not originally a CALS matter, it's a matter which I took to CALS. In other words, I said, look, do you have the appetite to deal with this particular matter? And together with another large firm in Johannesburg, we've created this think team to forge ahead to do what we think is right together with Dr. Rosenberg on this matter. So that's it in a nutshell. There's no misrepresentations at all.
All right. Thank you, Ms. Retief. Thank you, DCJ.
Thank you, Commissioner Baloyi. Any further questions for this candidate, colleagues?
Yes,
Yes,
DCJ.
Prof, go ahead, please.
No, thank you very much. Good afternoon, Advocate.
Good afternoon, Commissioner.
Thank you very much. A point has been made that the division to which you are going to be appointed receives all these big matters. And in most instances, some of them are review matters, be it against the state generally or some other institutions. Yes. I'm not really sure the extent to which you have had exposure to admin law, but I just want to ask you a general question.
Yes.
In relation to admin law generally.
Yes. Thank you for... Yes.
Sorry, one of the most crucial decisions that a legal practitioner will have to make when instituting a judicial review will be to decide whether to rely on PAJA directly, yes, or to bring an application in terms of the constitutional principle of legality. I just want to get your understanding as to the circumstances under which one can bring an application under PAJA, and if PAJA is not applicable, then under the principle of legality.
Yes. Commissioner, it was a lengthy question, but I just want to understand. The first part of the question, as I understand it, is, if I'm correct, is if I've had experience with reviews. Was that the first one?
Yes, basically, yes.
Yes, basically. And the second one then was amplified to ask whether or not one understands the difference between a review in terms of PAJA or a review in terms of legality, where,
yes,
for example, the state reviewing its own decision. With regards to the first one, in my practice as an advocate, I also did petroleum work, meaning that I dealt with a number of matters on the either site or retail license, the acceptance or rejection thereof, that went through a process, an appeal process. Once that internal process was exhausted, the only remedy there was review. So on that basis, in the law of petroleum, I dabbled in reviews. As far as being a acting judge, if one has a look at my stats, there's a number of matters which are PAJA reviews, and one in particular, a legality review relating to the public protector. That particular judgment I have placed in the portion of my judgments. Coming back to the last question, the PAJA review, I suppose it's easier for me to state that if there's an administrative action by an organ of state or a natural person or a juristic person that is acting as a public body and has a public interest, and there's a decision that affects somebody's rights, then one is entitled to go in terms of PAJA. In fact, the entitlement is actually you must. It's prerequisite. But in a set of facts where one finds that the very decision is a body who is the state, then one sits with a situation where the review must be brought in terms of the law of legality. So in other words, if the door is closed in terms of the statute being PAJA, then one then looks to a legality review, if that answers your question.
No, that is your answer, and I will live with. Thank you very much, DCG.
No further questions then, colleagues? All right. I guess you'll be relieved to hear that the interview has come to an end, Ms. Retief.
Thank you.
Unless you still want to have a go at it.
If this is the end of the road today, then I'm grateful, and I'm very, very thankful.
Thanks to you for
time.
making yourself available.
Thank you very much.
You're excused.
Thank you. Thank you, Commissioners. Thank you.
Good afternoon, Advocate Wandeles.
Good afternoon, DCJ.
How are you?
I'm very well, thank you, and yourself?
I'm fine, thank you.
Good afternoon, Commissioners.
I'm not going to keep you. I can't speak for my colleagues, though. You have appeared before this commission how many times now?
DCJ, it's in fact my fourth occasion, if one counts the October, sorry, I beg your pardon, the April 2021 interview. But hopefully this will be the third occasion that hopefully my name goes forward for consideration.
It is exactly for that reason that I'm saying I won't keep you. We know exactly who you are.
Yes.
We know that you started acting in, as far back as 2012, for example. So you're an old hand at this. And
yes,
I just want to raise one thing with you, though. In your
Yes.
application form, you list, you list a long, well, you make a long list of, you present a long list of, it's late afternoon, you present a long list of reserve judgments dating back 6 months from the time you were preparing the document.
Yes.
Can you just explain to us how you came to, accumulate so many reserve judgments and if they have been delivered?
Yes, thank you, DCJ. I trust that my correspondence was received.
Yeah, it was.
By all, yes. So that is, I understand it's a fairly voluminous and hopefully a thorough explanation. But if I can just summarize that.
Yes.
Yes, DCJ, unfortunately, and if I may be so bold, perhaps the questionnaire I'm advised is possibly one of the things that will be looked at when the JSC looks at its criteria. But that particular subparagraph, I think it's subparagraph 9.5, which asks, do you have any reserve judgments at the time, causes difficulties because, as I've set out in the letter, when one fills it in, if it's really a matter of timing. If you've come off 2 weeks of opposed motions and special motions and family court, and as I've set out, then obviously you're going to have a lot of reserve judgments. So in a nutshell, I've set out all the other reasons as to why. But to cut a long story short, and I know you've been at this today, DCJ, for a long time. But out of all of those judgments, which were set out at pages 8 and 9 of my letter, they have all been delivered, and the only one that has not been delivered is number 8. That's a matter of Centpred Properties, and the guideline, therefore, is in fact only the 21st of May, 2023, because I had to chase applicants' counsel to eventually give me the authorities he wanted to give me when the matter was argued. So they're all up to date. Everything is
all but one.
No. Yes. Sorry. Well, yes, all but one. But as I say, that yes, there's, and that'll be delivered shortly.
All right.
Yes. So
thank you.
Thank you.
Okay, JP Mlambo.
Thank you very much, DCJ. Good afternoon. Advocate Wandeles.
Yes, JP. Good afternoon.
You've acted for a total of 149 weeks.
Yes, JP.
In the division. That's because you started a long time ago, and in 2015.
Yes.
And whenever we need help, we always call on you. You've helped in a number of recesses, because with the absence of judges in the division who go to other courts, even the complement that must do recess duty is not there. So that's why you've availed yourself throughout.
Yes, JP.
And just looking at this, I see you've done 25 weeks in the opposed motion court. That's seriously sizable.
Yes, JP.
Yeah. And I think you've done what?
If I may, JP, on previous interviews, that the 25 weeks of opposed motions, yes, JP.
Yes.
Sorry.
So you've been around the Gauteng division, basically. you know what the workload is like. You know what the nature of the work that comes, and you've done it.
I do.
In terms of judgments, what is your average turnaround time in terms of handing down judgments?
I think, JP, the average turnaround time until usually was always under 3 months.
Yes.
There was never it was always that. It was only, I regret, just recently when, as I set out in the letter, that I was faced with an extraordinary, judges in Gauteng have an onerous workload. I think I was faced with an extra onerous workload in one, and I'm not complaining, because it's given me an opportunity to perhaps even write better judgments on more complicated matters.
Yeah.
And more portable. But that's the average. The longest judgment is the one that is.
How long will that be?
That was 5.5 months.
Okay. So nothing over 6 months?
Never, Jim.
I see. I'm sure you've had occasion to watch some of the interviews for the week. The bar that this commission has been consistent with this week has been to ensure that whoever it recommends for appointment is someone who's technically competent, someone who's a hard worker, and someone who's conceptually up to standard. You've seen, and you may have heard that some candidates have been criticized for having a weak understanding of the law, misapplying tests. You've heard and seen all that.
Yes, Jim.
Yeah. What's the bar's comment against you?
JP, there are no adverse comments at all, as far as I can see. And in addition to that, perhaps I could just amplify it. I've certainly never had any adverse comments from colleagues when working, for example, in appeals. And I've done a lot of judgments in full court appeals where the senior judges. The
So you
judges
feel, I mean, you are a silk, you had a practice. And by the way, would you like to remind the commission how is it that you left KZN and came to Gauteng?
Yes, JP. It was probably an event which has potentially changed my life. I attended, in 2015, there was a conference held by the Transformation Committee of the Johannesburg Bar at Lily Leaf's Farm for acting judges. And having acted in KZN before, I elected to attend the conference, and at that conference, you, JP, were a guest speaker. And again, you made a call for the fact that, or were bemoaning the fact that the silks in Johannesburg were possibly giving you a week here and a week there, but you weren't getting much time. So, to cut a long story short, I tendered my services. Obviously, the agreement being that I would pay my own accommodation costs and my own travelling costs, which I have done in all of the weeks that in all the time that I've spent acting in Gauteng, and I've acted in Pretoria and Johannesburg, and that's how the relationship began. And again, I must say I was welcomed with open arms. It has, if I can just finish this question just briefly, JB, I was reading the transcripts of my previous interviews, and it seems to be of some concern to some commissioners that the reason why I'm applying for a position in this, well, I'm not applying, I've been nominated for a position in this division and not KZN, but the fact is obviously that I've done 99% of
Well, the
my
fact
experiences
is,
here.
after that conference,
Yes.
you had a call to me to say you would want to come and help.
Yeah.
And I didn't guarantee you that I'll appoint you all the time.
No.
Said whenever I've got available vacancies, I will.
Yeah.
And I think as your appointments will indicate, it wasn't a continuous appointment.
No.
Yeah.
No. And as I've been, I've been welcomed with open arms, and I've really enjoyed my time here with colleagues. And I think it's been a good thing I think historically, to have a cross-pollination at times with judges from different divisions being possibly appointed in other divisions, I think it's a healthy thing. I think that one can bring different things from different, with ways of practice and possibly different patterns.
Now, the Gauteng division attracts, it's always in the press, in the news, with the cases it has. I mean, even this week it was in the news, last week it was in the news. Sometimes, almost daily, there's mention of a case that's being heard or a judgment handed down in Gauteng. And these are matters that are in the public domain, mostly administrative law cases. Have you had a fair share of handling these cases?
Yes, Chabi, I think over the time, I can't think of anything in particular.
Yes.
But there certainly have been matters which have attracted attention.
Yes.
And yes, and I've never shied away from that. You know, it's obviously very important to be independent and to be independent thinking, and to make decisions when one needs to.
And you regard yourself as eminently eminently appointable. Let me use that word. And
yes, Chabi, I think
that's why you're sitting here talking to us today.
Yes, Chabi, that's why I've accepted the nomination. It's
Yes.
not a personal thing. I don't have any illusions of grandeur to want to be a judge. It's a sacrifice I'm prepared to make because people want me to be, and I've been nominated, and I've accepted that nomination, and I've made certain sacrifices, which I'm quite happy to make, and to continue to do so. And I believe with my experience at the bar, which has now been 32 years, 20 years as a junior and 12 years as a silk, and that experience together with the almost 2.5 years of acting experience which I've accumulated in all these different courts, as you've said, I believe I would be, hopefully I could add some real value to your division if I was appointed to serve. JP, if I could just, before we move on, just back to the work allocation very quickly, is that you will also see that I've done, and this hasn't been raised in previous interviews, that's why I just wanted to just touch on very briefly the fact that I've also done 24 weeks in the unopposed motions. And this relates to a comment which has continuously been made in the reports by the Johannesburg Society of Advocates, and which has been confirmed by the GCB, was that my ability, and it's been commented by members of the bar, my ability to handle an unopposed motion role, lengthy unopposed motion roles, because we know how lengthy those roles can be and how difficult it is to prepare them. There can be 60, 70 matters. You've got to read all those matters, and then you've got to get through the role. And on top of that, in the words of our erstwhile DJP, what an important court it is, because, and it's a difficult court to run because it encompasses so much knowledge of so much of the rules and of various sectors of law. And it really is an important court, and I think that taking all those factors into account, and the fact that I did have, for many years as a junior counsel, have a very busy motion court practice in Durban, that I really could make a valuable contribution towards that court. And I know that, JP, you have various committees, and should I be appointed, I would certainly hold up my hand if needed for that.
My last question is, you come from a province that hasn't caught the bug fully in terms of digitization or electronic filing, and you've acted in Gauteng for this long. Are you one of those judges who are doing the physical stuff who think, I don't know? Or have you fully brought up to doing work electronically?
JP, I think, I wouldn't say fully, but I think I've made great strides in that regard. And I'm certainly enjoying the case lines and court online as well.
Thank you. Thank you very much, DCJ. No further questions.
Thank you very much,
Thank you,
JP. MEC?
Thank you very much, DCJ. Good afternoon. Can I just refer you to, I see your colleagues in the GCP have made a comment about your knowledge and your capacity to do this work. And in this particular case, they say that, and that is on page 6.5 on, I think you'll find that on, well, there's no page here, unless I'm mistaken. But you can look at the comments of the GCP about what they say. The one I'd like to quote is paragraph 6.5, which they say, whilst in practice, the candidate did not practice in the field of constitutional law, close quote. Now, for me, constitutional law permeates and is the most important pillar of the South African legal system. As you know, the Constitution is very much important to all laws, and anything inconsistent with it, it's definitely a problem. Now, can you just give me why would they say that about you? Because if that is correct, then that worries me quite seriously. That at the position you have applied for, the work that you'll be doing requires a very good knowledge and appreciation of constitutional law.
Yes. Thank you.
If you can just clarify me on that. But first, is it a fair comment? If so, just clarify me on that.
Yes, thank you, MEC. First of all, once again, it's noted that on the questionnaire there was no particular place. Well, there was when one mentions one practice, I suppose. But having said that, there was, yes, other than one matter in terms of where I was a junior counsel and I was briefed in one specific matter. There wasn't during practice. I wasn't briefed I haven't been briefed in constitutional law per se. But I think I've answered this question before in another interview. But the fact is, so I took the fact is that during my time as an acting judge, I've then had the opportunity to, and that's been 2.5 years, to in many judgments apply various constitutional principles. So I've made up through constitutional transformation, because it's obviously very important, and as you say, it underpins everything. It is the most important thing of all. So whatever I may not have had, and it's not that I didn't have any experience at all. I mean, when one argues a matter, one always refers to the Constitution, etc., etc. But I've been able to expand on that. And in one of the documents, a summary of judgments, because I've answered this question before in a previous interview, and I've said, well, that's the case, but I hadn't had an opportunity to go through. There's so many judgments I've handed down. I haven't had an opportunity to go through each one and mark where I've mentioned constitutional principles. But what I did on this occasion, when I compiled that summary of judgments, I did mark some that then correspond with the spreadsheet. So I've done that. Also in my pack, the very first judgment that I put up is a reported judgment where I've dealt with the constitutional principles in respect of unlawful arrest and detention. So I've dealt with many in many judgments with constitutional. So I think I'm, if I may use the colloquial expression, up to speed with the Constitution, and I'm a great believer in constitutional transformation, and I don't think I can answer the question any further than that.
Any questions, colleagues?
Yes, may I please ask Deputy Chief Justice. Good afternoon, Mr. Wanlands.
Good afternoon, Commissioner.
Could I ask, apropos the points that are being raised by the MEC about your grasp of the Constitution, to just test in relation to the common law of contract, and specifically to ask whether, in terms of our law as it stands, it is permissible for a court to refuse to enforce a contractual term on the grounds that, from a constitutional perspective, the enforcement would be unfair, would be unreasonable, or would be unjust. Yes. And what are the leading cases, even if it's one or two?
Commissioner, I'm going to be able to answer the matter in principle, on principles, but my memory fails me when it comes to the name of the matter. But that would be
no problem.
That would be the debate between, essentially put another way, between Pacta Servanda Sunt and the principle of Ubuntu. Is another way that it has been put by certain writers. Would that?
No, I'm not talking about Ubuntu. I'm talking about three specific terms.
Three specific terms.
Good faith,
yeah.
unfairness, and reasonableness.
Well, putting that aside, the way I understand the law at present is that because of the principle of legality and certainty that, and the constitutional right to freedom of contract, that our courts have not gone that far at this stage to entrench those principles in any decisions that I'm aware of.
Yes, and the judgment of Botha versus Botha of the Constitutional Court, didn't the court invalidate a contract there on that basis?
Well, I'm not. You may well be right, Commissioner. Regrettably, obviously, we can't know everything, and we learn as we go along, and that's the exciting thing about the law. And it hasn't crossed my desk at the moment, but hopefully it will. And if it does, then I'll certainly remember the matter.
Well, the judgment was subsequently distinguished by the Constitutional Court, which came back to the principle that pacta servanda sunt, or pacta sunt servanda, remains applicable.
Yes, yes. So we still. So was I right then, Commissioner?
So in your original answer, which you should have stuck to it.
Yes, yes. I was just being honest, Commissioner, to say I hadn't read Botha versus Botha. So.
Any?
Good afternoon, Mr. Wanless.
Yes.
Just two questions. You've acted then, I mean, you're residing in Durban.
Yes.
That's is what you've put down as your address.
Yes.
But you only acted in KwaZulu-Natal for under a month.
Correct.
In 2012, and then you never acted there again. Do you want to just comment on that? It's a bit odd that you don't want to try and get broader experience and take an acting position from where you're actually living.
That seems to be, Commissioner, that also seems to be a question that is, for some reason or not, perturbed the Commission in my previous interviews. I can't explain it. I can explain it in this way, is that, and I think I have in previous interviews, the fact is that first of all, to get an acting appointment, to render your services and serve one, to assist in the administration of justice in KZN is far more difficult than it is in Gauteng because of the size of the court. They just don't employ or ask for the assistance of that many acting judges. So that was the first point. The second point being that when one, having now built up the relationship that I have with Gauteng, I was now obviously out of mind, out of sight, or out of sight, out of mind. So once everybody knew I was spending this time in Gauteng where I was being asked to act. So it became really sort of immaterial. And again, because of the relationship and because of the way I was welcomed here in this division, and should this commission decide that I am suitable for appointment, then my wife and I have obviously discussed the situation, and then there'll be a permanent move to Gauteng.
Okay, thanks. Sorry, I wasn't present when you were interviewed before.
No, I understand.
My second question is, you would have been conscripted for 2 years. Is that a yes? Sorry, I can't see.
Yes, sorry, yes,
okay.
sorry, yes.
Why don't you put that on your CV? It was employment. It was conscription. It's just that we had a earlier candidate today who did put it on their CV. Wasn't an issue, nobody raised it. But I just was surprised, the question on the JSC questionnaire is please furnish chronological particulars of employment since leaving school or university.
Yes.
And it's 2 years. Why didn't you disclose it?
Commissioner, it wasn't a deliberate thing by any means, and thank you for raising it. It hasn't been raised before in any previous. I think certainly it's not employment. You know, so it didn't, that's really the only reason I can think why I didn't put it down. Yeah. It,
Are
certainly
you saying it
wasn't-
wasn't employment?
No, no.
You were remunerated.
Well,
Probably wasn't much, but it.
No, no, it certainly wasn't much. No.
But you were remunerated, so that's employment.
Well, I won't split hairs, Commissioner, but, well, possibly it was just something I didn't, I just omitted it. There was, as I say, there wasn't any intentional reason for that.
Okay, thank you.
I think you've declared it before, though.
Have I?
I seem
must-
to remember that, yeah.
Yes, thank you.
Any more questions for the candidates? Commissioner Malema?
Just a brief understanding of customary law.
Yes. A brief understanding, Commissioner. Yes, Commissioner, obviously it plays an important part of the development of our law, and in terms of section, I think it's subsection 211, subsection 3 of the Constitution, it must be applied. Customary law must be applied unless there's other legislation that conflicts with it, or it's in conflict with the Constitution. I've heard lots of. I know the other commissioner has asked various other candidates questions on that. I think that the test. I don't know whether I want to answer the other commissioner's question, but
Carry on, tell us the test.
the test, yes. The test is, and I never heard any of the other candidates answer it, but in terms of the matters that you mentioned, Commissioner, I think the way I understand the test is that the court must obviously look to evidence of ordinary people. That would be the first thing, or evidence of traditional leaders, and evidence of experts, but certainly to be wary of old authorities, because that obviously takes one back, and clearly customary law in itself is something that is always developing on its own, but needs to be encouraged in terms of decisions wherever possible. So wherever the court can apply customary law, that should be done.
55%.
Just. Thank you, Commissioner.
Commissioner Nyambi?
Thanks, DCJ. Afternoon, Advocate Wenles.
Good afternoon, Commissioner.
In your view, what do you think would be the role of traditional courts in the administration of justice in South Africa?
I must confess to answer that question, Commissioner. First of all, I don't have an in-depth knowledge or understanding of the structures necessarily of those courts, but certainly if the traditional courts are obviously passing down orders or judgments in terms of customary law, then I think that's very important, and I think that is law that should be taken into account by the High Court, by the SCA, and by the Constitutional Court.
Thanks. Thank you, DCJ.
Any questions from the virtual platform? Prof? Commissioner Singh?
None from me, DCJ.
Commissioner Bernard?
None from me, DCJ.
All right. Well, we have reached the end of the road this time, Advocate Wenles.
Thank you.
Thank you for making yourself available once more. I hope things will go well for you this time around.
Thank you, DCJ. May I know it's been a long day, but may I simply make a very brief closing statement?
Yes.
Thank you. I know that, and I would just like to first of all acknowledge what a privilege it's been to once again to appear before this commission and to be shortlisted along with other candidates. But I think I touched on this earlier, but I just wanted to, for the sake of the commission and also for members of the public who may be watching this, that I know that I think sometimes there's an impression that candidates or some candidates may be doing this, maybe applying for some personal interests. And I just simply wish to say that that's certainly not in my case. That's when I mentioned earlier, I don't have any illusions of grandeur in seeking the position. I'm 60 years of age. I can offer the Gauteng division another 15 years of service. I think I've proven that service. I think I'd be a valuable member of the judiciary. And simply to act, just really the reason that I'm here is because I've been nominated for the position and asked to put myself forward. And I've accepted those nominations because I believe I am suitably qualified. And I believe my commitment and the sacrifice that I have made by the traveling expenses, the accommodation expenses, et cetera, speak for that. Again, there's been the experience, I've already touched on that. So I just wanted to say thank you. I'm ready to swap my Zulu shirt for I don't know if it's a Kaiser Chief or Orlando Pirates, I'm not sure, anytime if needed to be. And certainly my Sharks jersey will get tossed out of and I'll have to buy a Lions one, or maybe a Blue Bulls, I'm not sure. But thank you very much for your time, and I'd like to just simply lastly commend the commissioners and this commission for your invaluable role that you play. I mean, growing our democracy and most importantly, MEC, our constitution. So thank you very much. Yebo. So, Yebonga Gakulu Salagashli.
DCJ, DCJ.